Dr. Eisenberg is sick.
Eisenberg is in rehab.
That's 9.
And Cherie's here, so 1, 2, 3, 4, 5. We have 4.
Okay, I think we'll start with the first item, is review and adoption of the minutes from the Bite-Mark panel meeting and the DNA number of meetings. Everyone has a chance to have read this in great detail, I'm sure. So will somebody make a motion?
Move to approve.
Second? Okay. Aye?
Aye.
Nay? Unanimous. Now, before we go on to the next item, I should say that Dr. Norma Jean Farley is over here. There she is, standing there, trying to hide. She was one of the commissioners before my time, though. And so I think we should say hello, Dr. Farley.
Welcome.
Welcome.
Thanks for being here.
Okay. The next is the WIN, it's the Office Administrative Update.
Sure. So we just wanted to give you an update on the budget status, and it's in the same format that Dr. Pirwani had requested a number of meetings ago, that allows for the description of the item, year-to-date projected expenditures, the current remaining, and percentage of the total budget that the item constitutes, the percent projected to be used, and then what's remaining. And as you can see, so this budget includes all of the expenditures through this meeting. So we accounted for projected travel. This is going to be a very interesting meeting for our budget, because we'll see how the cost of both the Licensing Advisory Committee and the commission travel works out. And then we can make sort of better projections going forward about how much these meetings are going to cost, because this is the first time that we had 18 people potentially traveling on the commission's budget for a quarterly meeting. So we are approximately, if you turn to the second page, you'll see that we're all told 51.64% expended, and our fiscal year runs through August 31, so it's just a little bit over half, which is on track, I think, for our fiscal year. The other thing that this budget incorporates is the position reclassification for Lee and for Nick. So getting them on the payroll full time, and the university worked very well with us to enable us to do that. They're not traditional positions for Sam Houston, so it took us a little while to work through it, but because they don't hire a lot of lawyers. They hire faculty, they hire staff, they don't hire a lot of lawyers. So both of their job descriptions are in your materials too. And it just shows you what their responsibilities are. But the truth is, we're all responsible for everything at the commission, because there are 4 of us. So we do whatever we need to make things easier, hopefully, for you guys. So that's the budget. I think we should probably, does anybody have questions about the budget, about any of the categories? We do have good news in the form of our construction project. It's almost done. They have like just 2 panels to finish off and put some plate covers on, and we have offices for everybody. So yeah, it took them a long time to build that second office. It was quite a project, because they'll come in. We weren't a huge priority. They come in teams, so the electricians don't know what the drywall people are doing, don't know what the painters are doing, so they come in and out, and eventually you have an office with a door.
Eventually.
So we do, and it's nice. I think it's good space for us. So I think it would be good to get a motion to approve the budget, since it reflects.
I'll move that we approve the budget.
Aye?
Aye.
Nay?
Okay. Also, Also in your administrative materials are some AG opinion letters that we got between the last meeting and now. One of them was a request that we put in related to section 39.14H of the Code of Criminal Procedure, which is also known as the Michael Morton Act. And that section puts some disclosure obligations on the state in terms of impeachment evidence, exculpatory evidence, and so forth. And the question that we had posed to the Attorney General was, is the commission considered the state for the purposes of that provision? Or is the commission, or is it just the prosecutors who are responsible for their cases? And basically what the AG came back and said was that the commission, neither the commission nor the prosecutor sitting on the commission has any special notification requirement under the Michael Morton Act. If the commission wants to notify people of exculpatory information or impeachment information that it receives, that's fine, but there's no independent duty. And I think the concern was because the statutory language was ambiguous, we didn't know if we were covered by that, and I think Richard in particular, it's fair to say, wanted to understand clearly their interpretation of his obligations, because in his role as a commissioner, he sometimes sees potentially exculpatory information just by the nature of what we do, but it wouldn't be his case because he's just viewing it from the lens that everybody else is viewing. So the AG came back and said, you know, we likely have no notification duties. Hopefully a court would agree. And that the prosecutor member of this commission has a duty to comply with the law in his or her individual capacity on the cases that person's involved in. Does not preclude, again, the commission from doing any notifications, just doesn't wrap us into the Michael Morton Act by virtue of the fact that we're a state agency. Is that clear?
It's clear to me.
And then the other request we had was in response to a PIA request. And whenever we get a PIA request and withhold information, we have to ask the AG to make sure that the withholding is appropriate. And in this case, it was information we received, information filed as part of an allegation of professional negligence or misconduct is not subject to release under the Act. And so there were there was information we received from outside parties that the AG said we shouldn't release until the investigation's over. They agreed with our interpretation, and that's all this AG. So every time we get that type of request, we have to ask. So that's why I included it in your materials. In addition, like I said, we have the position descriptions. They're called assistant director and associate director because they don't have assistant general counsel or associate general counsel type positions or staff attorney positions or anything like that at Sam Houston. So they did the best they could with the classifications. And I think is that all we have for admin lead, or is there anything else?
I think that's it.
So that's what we have so far. We are struggling a little bit with our website. I think the commission is going to need to discuss during the next fiscal year switching to a more sophisticated platform. Just by way of example, you know, we published the list of accredited crime labs inside and out of Texas. And we have a very nice PDF that was created by our database person for that, but we also paid them to do a searchable function where you could enter, say, Abilene, and then get all the labs in Abilene, and it doesn't work. And so Lee is in a constant battle with the website people, and it just takes them a long time to update things. And so I think we are probably going to need to talk about some procurement around the website of the commission when the next fiscal year comes around.
We take some bids.
Yeah, we
Some
might even
estimates.
start trying to see what other agencies with high level of website use, who they use.
Do you need our permission to do that, or can you
To
just go
start
ahead and
looking
do
into,
that?
we'll start looking into it, we'll report back.
Okay.
So do we have that information in a database?
Which is,
The information on the accredited crime lab?
yeah, we've got it all in a very good database, but
Is
they're.
it capable to just export it to Excel, say, and then, because you could search in Excel very, very simply?
Yeah, I mean, when we post the list, those are searchable and easy to navigate, but our goal was to have not just the list, but, you know, if you just want to say, what are all the blood alcohol
I see, so
labs,
you've
or
got
what
to
are all
you've got to
the-
subcategorize
Yeah,
each
like
laboratory.
what are all
Okay.
the labs that do drug chemistry in Houston?
Okay.
Or, you know, and they've had a really hard time communicating that information from the database to the website.
Okay.
And that, you know, is frustrating for us because that's part of what we pay for. So.
Right.
Right, and if they can't get the answer on their own, then they'd be calling you, and that's going to take up your time answering the phone to answer questions that could have been answered on the server who was working the way we wanted it to.
In fact, Lee spends quite a bit of time
Yeah.
answering those types of questions. And people
Okay.
love the PDF list. It's not that they don't. It's just that it's worse to have a search function that doesn't work because then the lawyer goes on, tries to search for blood alcohol, can't make the thing work, calls Lee up, says your website doesn't work.
I mean, defense attorneys are relying on this information. They're going on there to see if the lab was accredited or is accredited, and then it doesn't show up. I mean, that's pretty important.
I agree.
It's got to be accurate.
So we've sent them
It's
a-
got to be real time, too.
We sent them a notice saying that we want our money back. And so far, that was not well received. They said they were going to fix it. But we're still in back and forth with them. But we don't think we should have to pay for a search engine that has not worked from basically its inception. So we will update you on that.
The unfortunate thing is that happens all the time.
Yeah.
They promise you and they don't deliver.
That's it for number 2, I think.
Yes.
It's Bernard. Dr. Bernard.
Really?
Go for it.
We have 19 complaints to go through. To start out with, a motion was made because we have a lot of cases which, or several cases which deal with potential mixtures, and a motion was made that these cases be referred by staff to the DNA mixture triage team headed by Mr. Wyckoff, who I talked to earlier and was very enthusiastic about that opportunity.
So I want to make one slight revision to that. So for the general state review, it goes to Bob. For Harris County, it goes to Bob, but for Tarrant County, it goes to Dawn or some combination of Dawn and a defense wheel. And then in Travis County, it goes to the capital area defenders. Is that right? And so we just want to be clear that when we say it goes to the team, depending on the county, most of them will go to Bob, but there are some situations where they will go elsewhere.
That would be funneled by the staff, though?
Yes, we'll
Okay.
distinguish those.
So the motion was made that in those cases in which there was a mixture question or potential mixture question, that in general it would go to the DNA mixture triage team, but in certain circumstances, particularly involving Tarrant County and Travis County, it would go to separate individuals representing their county. Is that fair? Is there a second to that?
Second.
All in favor? I don't know whether you're going to do that or whether I'll
can
do it.
do
Yeah. All in favor?
Aye.
All opposed? It's unanimous. The first case is one with the Austin Police Department. It was a self-disclosure discussed last time, which in September of 2015, the Austin Police Department manager, Bill Gibbons, reported a non-conformance by a crime scene technician for not issuing reports that were consistent with a number of field calls. The supervisor, after evaluation, discovered 11 field calls where there was a particular technician at a scene, but he failed to issue a report. Notes were found for 9 of the 11 crime scenes. 2, however, there were no notes found. In these cases, no evidence had been recovered. In going back and reviewing all of his cases, or all of this individual's cases, since May of 2007, it was determined that there were 121 field calls with missing reports, all of which determined that no evidence was recovered. The technician was placed was removed from casework on August 3rd, 2015, and resigned on August 28, 2015. Part of the investigation, the laboratory conducted an audit on all the remaining crime scene staff to determine whether this was an isolated event. One employee was found to have 2 reports that were not generated. Notes were found and reports were generated for both cases. A corrective action plan and root cause analysis were performed, which indicated the analyst failed to follow procedures, that there was no process in place for supervisors to check that all calls dispatched were documented in LIMS with a report. They developed an audit process that would allow supervisors to ensure that this doesn't occur with any other employees. They self-reported the issue to Travis County DA's office, and they attempted to contact and interview all the victims affected by those particular events. They entered an administrative report into LIMS in all the cases for which the initial crime scene report was not generated, and then they took preventive steps to ensure that the new audit process was implemented and that they would follow back up with an audit in 1 year. The recommendation by the subcommittee was that there was no further action needed following these actions. So the motion was made to not require any further action. Is there a
You
second?
need to talk about it. You need to talk about it. You can't just
Okay.
accept the
All-
recommendation
Oops.
without discussion.
Is there any discussion?
Well, it seems the lab's done a pretty thorough job of following up and making sure that the root cause analysis, or at least some of the root cause, has been identified, and their corrective actions seem justified.
Mr. Gibbons is here. Would you like to say anything in addition to what you submitted?
We did take this serious. We found a hole in our process. We use 2 different, we use a dispatching method through the dispatchers, and then we use LIMS to do our reporting. We found a hole between those 2 systems. So we have closed that hole. We have audit procedures in place now to make sure that that doesn't occur again.
Can I ask one question? Did you notice any discrepancies between, like, the victim's perspective of whether evidence was collected and what the technician thought in terms of whether evidence was collected, or did you find that they were all cases where no evidence was?
There were some victims that thought that evidence might have been collected. The issue is that most of the evidence by this is a property crime technician, so these are all property crime cases. The issue is some of the people thought that he might have collected latent prints, but they have some discretion as to they can collect cards and then come back and evaluate them and make sure if they're of value or not. So it was real hard to determine if there was actually evidence in those cases. We did send this through our Internal Affairs Division, and we did send this through our Special Investigative Unit to see if there was any criminal activity that we thought that occurred. They posted that to the DA's office, and they opted not to pursue anything at that point.
Move to accept the committee's recommendation.
Second? Is there a second?
Oh, I thought you were seconding.
Yeah,
Well-
they're done.
Aye.
Aye.
Nay.
All right, the next case is, the second case is a latent prints. The next 2 are latent prints related cases. This is related to DPS in Weslaco. September 29th, 2015, The laboratory director notified the commission of an incident in which the latent print section of the laboratory in which an analyst misidentified a latent print, which occurred in June 2015. Root cause analysis was performed that same month, and a quality action plan was documented. Root cause analysis revealed that the latent print analyst failed to take into account the appearance of the skin pores as a deciding factor with regard to image inversion. The analysis and quality action plan also exposed pitfalls in the latent print section standard operating procedures as they pertain to image processing and verification of excluded results. So in response to the incident, the lab completed a supplemental review of cases from 2013 to present, in which the following conclusions were reported: excluded, inconclusive due to latent print, or not suitable. The analyst was removed from casework. They implemented a local policy effective in August 2015 requiring verification and review of excluded, inconclusive due to latent print, and not suitable for conclusions. They updated the lab's latent print standard operating procedure addressing verification of analyses. And the summary of the results of their review was that the latent print analyst completed 109 cases from 2013 to 2015. 11 of those cases met supplemental case review criteria. As a result of the case review, a previously excluded suspect was subsequently identified as the source of the suitable latent print, palm print. Quality action plan was completed in identifying the root causes and corrective actions to be taken. A amended report was sent to both the investigating and prosecuting agencies involved. In August 2015, as a result of the supplemental case review, a latent print previously reported to be not suitable was determined to be suitable for comparison and subsequently identified the suspect. Quality action plan was completed identifying root causes and corrective actions to be taken. Following notification of the parties, prosecutor informed the lab that the amended results did not affect the criminal case outcome. Because of the discrepant results, management determined further case evaluation was warranted and is being completed. And the staff and the recommendation at a subcommittee was to table the self-disclosure pending final results of the evaluation by the laboratory.
Brady?
Yeah, it was determined that when we had a very robust review process for positive associations with latent prints, we didn't do a thorough 100% review of reg detail that wasn't associated with an individual. And with this particular examiner, as we review additional cases, we're finding that at times there were negative results that other examiners have determined were able to be used or were actually positive results. The context of the cases are cases where he's made one a positive association. There's other multiple rich details within that case that he's not looking at thoroughly. So we've chosen, like was mentioned, to do a 100% review of this individual's work. We've notified the affected DAs of the counties that are served by the Wessica Lab for latent print processing. The employee is no longer with the department as kind of a result of this process. And the biggest thing that we've done is we've changed our review process for all cases in all 4 of our latent print laboratories to include looking at the negative results, looking at results that are positively associated to a particular individual. But our review is ongoing. We've completed all of the review of all the cases that we have. There are DPS cases where we have the evidence retained. To date, there are 4 outliers that we are working through. We're working with the DA's offices in those affected counties to bring in other cases for review to complete the review, which will be completed by the time the next commission meeting, the next court will be able to provide the results to you.
Can I ask a question? So this was all identified because of a proficiency test, right? That was the
Yeah,
original.
it was a peer review of a case. I don't know if it was a proficiency test, but I believe it was a
That's
proficiency case.
next
That's the
one.
next one.
The next
Sorry.
one is the proficiency.
The next one is the proficiency on latency. But this, so it was a tech reviewer essentially who figured out that there was an issue.
It would appear, yeah, that's correct.
A peer review.
It was during a tech review. It was
Yeah.
a peer review individual that was looking at the totality of the work in the case and had determined that there was rich detail that could be used. used.
Okay.
Could be, yeah, inclusive.
I have a question. A peer review is a blind peer review, or do they know the previous?
They do have
conclusion?
access to the case record, so it's not a blind review.
And still correct.
Just a table.
So
Okay.
yeah, I was going to say, the recommendation was that we table the self-disclosure for further discussion pending the workup, the final evaluation.
Also move.
Second?
Second.
Aye.
Aye.
Nay?
The third case is another latent prints case from Corpus Christi Police Department. In December of 2015, the Corpus Christi Police Department lab director notified the commission of an issue in the laboratory's latent prints section where an examiner misidentified a left finger as a right finger on a proficiency test. Once the error was identified, the management initiated an investigation root cause analysis, and because the work related to latent print identification, when they're positives, it's verified by an additional qualified examiner, and management had no reason to believe that any actual casework had been compromised, as this was a proficiency test. As a follow-up, the analyst was removed from casework. Part of the investigation, a root cause analysis was conducted in conjunction with interviews of all the examiners and the laboratory's quality assurance manager. The analysis revealed examiner neglect, either haste or carelessness, as the root cause for the examiner confusion. It was felt that the analyst identified the correct finger in her exam, but wrote her notes in a careless manner and made the transfer of these notes to the data sheet reflecting the incorrect finger. They didn't believe that it was a result of technical issues from the lack of technical ability. Corrective plan was developed, which yielded that there be a review of all casework completed by the analyst since her last proficiency test in April 2014. The analyst would attend an ASCLD assessor training course for its testing laboratories in March of 2016. The lab's policy on proficiency testing was rewritten to provide specificity in examination protocol and consistency in reporting format, and the laboratory scheduled closeout for completion of the corrective action plan was May of 2016. An update will be sent to the commission and ASCLD. So the laboratory's recommendation the recommendation from subcommittee was that no actual casework had been done, but it did bring up the issue about proficiency testing and whether if someone fails a proficiency test, whether that is something to be reported to the affected prosecuting agency. Also, based on this, it was felt that quite a bit had been done and no further action was needed, especially in light of the fact it's a proficiency test.
So I think the question is more of a legal question and a recommendation in terms of the obligations of a prosecutor to disclose information under the Code of Criminal Procedure, which we have here. But the key issue is that that is a judgment call for the prosecutor to make, and it's not just about exculpatory information that needs to be disclosed, it's about potential impeachment information as well. And so I think most prosecutors would like the ability to make that determination. That the determination about whether it constitutes impeachment evidence rests with the legal system, not with the laboratory. And so that, I think, is the root of why it's suggested that even though this was a proficiency test and not live casework, that information should be disclosed to the local DA so they can decide whether it meets this definition. Is that?
And that's my position. From a prosecutor's standpoint, I think that we need to know about this. Again, I mean, ultimately, whether if it was something that was pursued in court, it would show that it was caught, it didn't affect the case, and the system's stronger because of the examination. But it's assumed that we know about this stuff. That I think that it's just a dangerous situation. The alternative would be for that question to be asked of an analyst in a case if they've ever had trouble with their proficiency testing, and then we find out for the first time that they give an answer, and we don't know the full story. And so that's why I think the safer attitude is to make the prosecutor's office aware of it.
What about those cases where there's a proficiency test and the problem was due to the actual sample that was sent out? Because that does occasionally happen.
Well, that wouldn't be an error on the part of the analyst, so I think that's a different category. This is not to overstate, it's not a huge problem. This was a mistake. This was something that was not done correctly, and it was caught. So I think that puts it in a different category. This witness, we need to know about that. I mean, if we, again, even the ability to keep it from coming into court, we have no ability to get a ruling from the judge and argue it's not relevant and shouldn't come in if we don't know about it. And so that's the other downside of us not doing it, just playing well, maybe it won't come out. Again, the potential for it having a big impact in a way it shouldn't is greater if we don't know about
And
it.
there's no question it meets this definition.
No.
But my question, as part of the, just clear it up for the crime lab people, is, okay, this proficiency happened, for example, this is not even technical deficiency, in the proficiencies, administrative, was it? Happened 2 years ago. How long do you want to know that? Like, how long they need to send them to the prosecutor? Until that person is working? Or until they do another proficiency? Or when is like, how you
What I would say is that
define it?
once we're aware this mistake is there, it becomes our obligation as that person is a witness in future cases to make that information available. That's for us to determine. That's the individual prosecutor's office's determination about releasing it. And I think in this instance, per the statute, when that person testifies, that information will be released. We already do that in certain instances. I think that's just our obligation. I'm not saying that I like it and understand the concerns from a laboratory standpoint, but I don't think the statute's ambiguous. That's our obligation.
So you're requesting the laboratory, as long as that person is working, to just, every time he or she wants to testify, to
No,
present
I
it?
think they give it to us once. Once they give it to the DA's office, it's in, and we have that information.
That's it?
That's it. It's our obligation to forward it. No, we don't need it. We're not asking the lab, we're not asking to put an asterisk by this person's name every time they come to court. Give us the information, and we're responsible for disclosing it.
Who is, okay, they just send them, so it doesn't have to go to the prosecutor of the case.
Send it to
Has
the
be
elected district
elected-
attorney and let the
Yes,
elected district
elected, yes,
attorney.
that's it.
Yes.
All right.
And
I just
also,
wanted to-
No, it's okay.
if they fail another one, that one needs to go too.
Yes.
I don't think it's ambiguous. I really, really don't think it's ambiguous at all.
And in this situation, it's easily explainable as human
Exactly.
error, isn't that? I
Exactly.
mean, she identified a left finger on a right palm print.
Right. She had a transcription error.
Yeah.
Well, you have here at least 1, 2, 3, 4 crime lab directors. Maybe you want to ask them how they want to implement it, or just do it? Or?
So in response to Michael Morton, the DPS came up with a policy to convey this information to prosecuting attorneys. And so the lab came up with a policy where we, in not giving it to the DA's office once, we're giving it to the prosecutor who's trying the case. And we're giving information that is our kind of our CD, so it has our history. We also supplement that with a disciplinary history form. We identified that it goes back to impeaching a witness. So if there's active investigations, founded investigations, we provide that information to the prosecutor during that venue. But we struggled with the PT issue, where the proficiency test gets put on that form and lives forever. So we, at this point, do not disclose that on that form, but having this discussion in front of the commission, we'll go back and kind of refocus that effort. And then I also liked hearing that maybe our distribution is wrong by giving it to each prosecuting attorney. Maybe we need to come up with a distribution scheme to be like the DA.
Well, I think the trouble is that DA's offices are not immune to turnover as well, and I think it'd be nice to assume that a case starts with a prosecutor and stays with them, but there's also the issue of who the case is assigned to depends on, is it an intake, is it a grand jury, is it the trial attorney, has the case been disposed of, is it now the appellate attorney? So I think from your standpoint, you're putting an extra burden on yourself to find the individual when something that goes to the elected has the identifying information that they give to a staff person to make sure they go to the right person.
Very good. Yeah, that's good.
So we have prosecutors from three additional counties here, Harris, Travis, and Galveston. So I imagine you all have thoughts on this subject of failed proficiency tests. I imagine if somebody fails a proficiency test, you want to know about it.
Yes, that's your position, right?
Yes.
I agree.
Okay.
Well, my position is I don't think the commission should take a position on it because anytime that we report to our district attorney's offices, and I know this is going, I understand I don't disagree with the legal requirement that it's exculpatory. When we provide information to our DA's office that they have not asked for, they typically do not know how to process it. It either goes to someone, as you say, who does not put that within the system, or it gets stuck in a file and it doesn't get acted on. I think the appropriate legal process is through a discovery motion with the DA's office requests all the information. I just finished providing a training file for one of my individuals, a former employee, to a public defender's office that includes all the proficiency information, all of their evaluations, et cetera, et cetera, et cetera. There is a process in line by doing another process where we push information out to our DA's office. They're terrible at maintaining that information and putting it in the system. They deal with things on a case-by-case basis, and they process the information on a case-by-case basis. You give them overarching information that doesn't have to deal with one particular case, then they get confused and they want to make it relevant to everything when it's only relevant to specific things. So my recommendation is let the individual district attorney's offices deal with it, because our office hasn't quite decided how they're going to deal with Michael Morton and all the information that is supposed to come in from law enforcement agencies. In fact, when I brought the issue of some granular information that we thought might be exculpatory, I was told by a representative, yeah, we have so much other information we're trying to process with regard to Michael Morton, that's the least of our trouble. So throwing more information at them, what they haven't asked for, but is available through the normal subpoena or discovery process, I think is not appropriate. Let each office deal with it how they want to.
So going back to the case context, the laboratory said in the disclosure to us that they did not disclose this information. And so I think the commission, in the context of this case, certainly should weigh in on that if they think that's not the best call for the criminal justice system.
Again, I mean, all I can do is speak as a prosecutor, and I hear the concern. And I understand there's lots of offices, including mine, that are struggling with how to handle this information and how to put it out there. But I think I just don't agree that it's a good idea that the answer is to rely on the discovery process. The biggest problem with that is we don't file discovery motions asking the agencies we work with to disclose stuff to it. That's not how that works. That's a defense-motivated thing. What I'm saying is that from my standpoint, if I know about the information up front, that is the way I prefer to do it. If it's information that is not relevant and I know about it, then I can legally try to deal with it. The alternative is to find out in the middle of trial, and And it's very difficult, and I've been in those trials before where things have sprung up I wasn't aware of because a lab had not shared something with me, or I didn't know about that background information the defense had. And I can tell you, it causes a lot more harm when it happens at that point than earlier. I think over time, officers will figure out a way to, what to do with this information. So all I'm saying is that in this particular case for the commission, I think the prosecutor should be notified about it. Obviously, the commission doesn't have the power to compel DA's offices to do anything.
Yeah.
But I think, again, this is just an example of some of the struggle of science and law coming together and different obligations. And it's not a perfect fit, but as it relates to our obligation, our ability to continue to practice law can be influenced. And I think I'm most concerned with the reputations of my fellow prosecutors and the ability for them to know the information. And then what they do with it is on them.
Travis, do you got anything?
Our office contains, we have a database for any time we get a report for any officer or crime technician, and we just maintain that database. We just add any proficiency test that has failed or complaint to that file, and the defense bar knows, and we put that out in every case as part of discovery. This witness is in our Brady library. Go see that file, you can see everything that's in there, so we do have a system to process those. And as a prosecutor, my personal experience, I would much rather have that information there than just to worry about it might get somewhere and hope that the defense attorney in the discovery process might come across it.
Do you have a process that you can let the lab know that you received it? So that's been finished one time, they send it to you, and that's done?
I think that's something that can be worked out with the individual laboratories. As I think, again, that we deal with multiple laboratories. I think there's a way. Again, we likewise have folders and files that we keep that type of information in, and I think it'd be it's easy to keep track of that stuff.
Because the concern was that the prosecutor office lose it.
Right, but
And
again,
it happens quite often.
a lot.
Working in the lab, I mean, they just send them and they don't have it for the next
That's
try.
their problem.
Yes,
Seems
no.
to
So
me.
that's it.
No.
So that's all right. That's
That's just
as
it.
long as we just have it and then the lab
their
people
problem.
receive, then that
If they're
is that
disorganized.
way.
And as they get, and then again, the more, it's like anything else, they'll learn to fix that issue. I mean, my feeling is that we all struggle and make mistakes, but a mistake is not a reason to stop trying. So
Okay.
I think they'll work that out. They're gonna have to come up with a system, and I think the system that most are gonna default to is we need to start keeping this information in a discoverable way in a folder and put it in there. I mean, again, it just doesn't, what's best for the laboratory. It's best for that individual to have it out there than to have it sprung on them in court, because there's nothing I can do to try to rehabilitate that issue, because I don't know what just happened.
I also would say, to Brady's point about if the error is in the context of an individual case, I do think you should alert that prosecutor who's working the case. Not the elected. But when we're talking about, okay, so this is an issue, a potential impeachment issue because it's proficiency testing, it's not an actual case, I think that's what Richard's suggestion was about, send it to the elected. But when you have a real live lawyer working the case, I think you guys are doing the right thing there.
But it just depends on how the office sets up the information. I mean, again, 160 attorney office is going to handle this different than a 10 to 15 attorney office. And even in those situations, I still think, even at the very least, a CC to the DA, because the prosecutor gets that information. If they don't save it appropriately, or if they don't share that, which in our office would be what they'd be telling them to do, is make sure you share it. If they fail to do that, then we're back to square one. It was given to someone, that person didn't pass it on, and now another prosecutor in that office. I still think it's better to share it with the DAs and let the DA's office be responsible for disseminating it as they see best.
What's the purpose of a proficiency test?
It's a test.
Proficiency.
Yeah, I was going to say that.
Is it a teaching thing, or is it a gotcha to be.
But it doesn't.
It doesn't
It
matter.
doesn't matter.
This
is in the statute.
It's-
Right.
It
But
doesn't.
what I'm saying is, anybody with any intelligence then will know they should do the best they can not to take a proficiency test. And, but let me explain something. What you are doing by this law and concept is you're encouraging people to do everything they can to not take a proficiency test. And that is the most sensible thing it is. I mean, if I had a choice, Norma Jean, would you take a proficiency test?
I was just thinking I wouldn't, actually.
But that's
it's
not.
required.
we
No.
can't-
That's a different
that can't
animal.
be the answer. It just
But the
can't be
answer
the
is, what I'm going is more than this. What I'm saying is, I know what you're saying, and you're saying it's the law, or something like that. But.
That's something like
That's something like that.
It is the law.
Or, you know, come on.
But if there's a problem, if there's an issue here, and it's going to work to the detriment of science and labs, then the place to address that is before the legislature and asking them to qualify that statute.
Okay, you're missing my point. I'm not saying that we shouldn't do this.
Okay.
But I'm bringing up an argument that your concept is of a proficiency test is a gotcha test. And that is educationally terrible.
But if a prosecutor explains the context of the situation and the fact that it's,
Yeah, no.
that's on them to be able to communicate that this is not, if it's not a big deal, they need to be able to explain that. That's on the lawyers.
As long as they understand that the individual prosecutor understands that it's just a proficiency test. Most of the time when doctors take proficiency tests, it's not if you miss one. There's a whole list of questions that we take in that one section. And if we miss one, that's fine, you still pass the test. You see what I'm saying? And so we do take proficiency tests, and you might miss one and disagree with them and then argue that you don't agree with that answer, and then it comes back and 80% of the pathologists disagree.
Actually, a good proficiency test, there should be mistakes on it.
Right, because you're supposed to learn from it.
But again, that's a good prosecutor would have that conversation with you and let you explain what it is, so we're better able to minimize and even potentially keep it from being addressed in the courtroom with appropriate legal motions. But again, that's another reason for making sure that we're aware of it, because we can't ask you. We're not going to say blindly, let's talk about proficiency when we have no idea what your answers are.
Right, I'm just afraid that instead of that person taking the proficiency test, someone will be overlooking the people taking the proficiency test before they turn them in to see that the answers are correct. Being a previous lab director, that's what I would be, and not a crime lab, hospital lab. I'd be afraid that other people are going to be looking over to make sure that they get them all right before they turn in.
Or I would.
the training to punish them, basically.
No, but I think it's a quality assurance issue. I mean, they have to do.
I don't know. The point is so they learn from that test and not that.
Right, but
Isn't the proficiency test also a means to determine the reliability
Yes.
of the
Yes.
forensic result?
Yes.
Right.
Yeah, it's
Right.
a quality assurance issue to ensure that the examiners are actually knowing and doing things correctly.
And again, the fact that it worked and caught something shows that it should be in place. It served its function before again, that discussion. has
Serve
happened.
its function as a teaching thing. Again, you're into gotcha versus teaching something.
in this particular situation, the analyst mislabeled the finger left for right or right for left, and the lab tells us it's because of her negligence, that she was moving too fast and she was rushing.
Yeah.
Now, is it administrative? You could say it's no big deal, it wasn't about her ability to do the analysis, but she has to explain that. I mean, that's reasonable. It is
It's still an error.
reasonable to say, this is what happened, I was moving too fast, I learned from it, and this is how,
But they need to probably send the positive, the good ones to the prosecutor too. So it should be really send all the proficiency to the health. I am saying a DPS lab director says yes.
No.
Yeah, you have to have your own information.
I'm sorry. If there is a problem with proficiency test, there's always going to be a corrective action process. process around that.
Yes.
And that's where I was kind of shaking my head. Is that if we've got a failure, and it could be, you know, a grievous error where we missed the result, or it could be a transcriptional error like we talked about in the case before the commission a second ago, we'll do a corrective action process. We'll remove the individual from casework, do any type of retraining that needs to be done, or whatever type of corrective action process we need to do to rehabilitate that employee, and then we'll have another proficiency test, which at that point is a competency test, to be able to turn them back on casework. And so that's where we're disclosing a problem with the proficiency test. There's actually a positive outcome when we put the person back on the casework.
Absolutely.
And
And the
something
fact that
great.
they're taking off casework is something that has to be told to us as well, because that's, I mean, there's just no way around it. I
That
mean, it's-
usually happens right away in the lab, that's standard.
Yeah, and it sort of
Okay.
follows, Brady, I had a quick question for what you said earlier as well, relating to that, is where you'd say, obviously this would be on their employment, in their training history internally, but you don't report that in the paperwork when they, for the DA or whatever on that
That's
case,
correct.
right?
We were not reporting the proficiency test portion on
So,
that.
I don't know, to me, that's something, that flags something to me.
Sorry, I'm the quality assurance manager, and I'm just trying to determine at what level of granularity the information needs to be brought to the prosecution, because proficiency tests are only a part of the quality system, and they're a very important part of the quality system, but there are other aspects such as corrective actions, technical reviews, anything along those lines. Under that definition, any of that information, if somebody had messed up a case that was caught in technical review, but it did get, someone did make an error, then that could, by that definition, also be considered impeachment. And so I don't understand at what point I would then need to provide that material. And secondarily, by providing that material, it is, my opinion, would be encouraging someone to work outside of the quality system, or at least not document the correction. Therefore, they wouldn't be held to that information as an impeachable offense. Quality assurance is to improve quality, is to try to make sure that individuals are constantly improving their processes, and laboratories constantly improving their processes. They're not intended to be a punishment. And so my concern is that by providing this information, if somebody did make an error, at which the person does go through the correction process and they are released scientifically for casework. However, an individual, the prosecution states, well, I'm not going to utilize this person no longer. This person has impeached themselves because they have failed this proficiency. That's a punitive action in regard to a positive process. Anyway, that's just my 2 cents.
My only point was, what is the danger of this proficiency test is you're encouraging people not to take the test and do anything they can to get around it.
They can't get around it
But they have to, it's
in
part of
accredited disciplines.
But
They can't.
They have to do.
I mean, Brady, you have, right?
We are required by our accrediting body.
you have to- you have to take it.
Right.
Jack Brody, Galveston County. On the last point, we already struggle with that same issue, thank you, sir, in terms of law enforcement and personnel files and disciplinary actions. You rely on the profession to maintain the integrity of its internal standards. And then the prosecutor has to know about it, and then it's incumbent upon us to deal with that on a case-by-case basis. And in support of Richard's position on this, where there's a state agency involved, prosecutors are imputed with that knowledge legally. But we may not be asking for that information through the discovery process. We may not know to ask. And so that's why it's important for the DA's office, and Albert Smith, the elected DA, to be notified of that information and then rely on that process to be passed down on a case-by-case basis. And like Richard said, we'll deal with that in each case to decide whether it's going to be admissible or not. But otherwise, if it's not given to us as notice, we don't even know to ask for it.
And as to the comment about us not sponsoring that person, that's the exact opposite of what would happen. It would not, there's no way, based upon this particular instance, that I'd have any hesitancy in continuing to sponsor that particular analyst. Again, that's not the point about this. and so it rises to a bigger level. But it's hard for me to also miss the fact that the investigations I've seen done by this commission, when there has been an analyst that has had serious problems that have affected casework in thousands of cases, behind all of those, there is a series of warning signals and problems that have come up that were never brought to air until the big mistake was made. I think that we need to have this information, and I think that there has to be that the prosecutors have to be trusted that they won't read more into what they're given, that they'll deal with it appropriately and move forward. That's just the way it is, and that's again our obligation under the law to do that.
I think we need Brady training, seriously need Brady and Michael Martinak training, like to put it way higher on the list of priorities, because there is a disconnect between, I think, the laboratory's understanding of the obligations and in particular with respect to imputing knowledge in any of the state agencies that are used by the prosecutor. And so that's part of it.
It hadn't been decided yet, though, Lynn. To the extent that the laboratory, are we part of the prosecutorial team? It hadn't really been decided. We are required to provide any information that the district attorney asks us for, just as the statute says that they're required to give anything exculpatory, anything that the defense asks for. But to what extent, because we've dealt with this in Bexar County, to what extent does the person the agency that acquires the information is required then to push that information forward? Is it a push the information forward to the DA's office, or if the DA's office is requesting it?
But
if the push and pull it simply doesn't, it has to come from the DA's office, because we don't know when you want it. And just to push information into a black hole with no place to go, because the DA's office is not our only customer. Our customer primarily is law enforcement. Yes, that eventually may end up in court, but there are a lot of our investigations that don't end up in court. So we can't push everything that we do to the DA's office because there's no file charge. Our DA throws those reports in the trash. Because they have no file for it.
I don't think.
May I interrupt?
Certainly. Your commission.
We were sending autopsy reports to the district attorney's office concerning homicides, and every time a case was indicted, they'd ask for the autopsy. We couldn't figure out why. It turned out they were just throwing it away. The initial.
Okay, so
What I came up here was to talk about proficiencies.
the file-keeping practices of the Bexar County District Attorney, I think we should at least allow him to come before the group.
No, it's multiple. It's multiple over the years.
Or the series of DAs in Bexar County. I mean,
What I don't understand, and I don't think any laboratory would object, is that on a proficiency where the laboratory looks at the results, and if there is some question as to the ability of that examiner to have done the work correctly. As Brady said, there is a car, and I don't think any laboratory would have objection to doing that. I'm not sure you have a complete understanding of how proficiencies work and what issues there are involved with them. We have proficiency tests, I'm not going to say on a regular basis, but that we challenge them. If you believe that the results of a proficiency test are necessarily accurate, you would be wrong. Proficiency test results are done as a consensus of laboratories. The company that provides proficiency results are not even required to be a testing laboratory. So they cannot authoritatively state what the correct answer is. So there are instances where there are poorly designed tests. Are you asking, when we have a situation where we believe it's a poorly designed test, that everything goes to the DA's office? So then we then have to sit down and explain to you what the design says, why it was done, why the proficiency test is flawed. Do you have time to want to do that? Or are you going to work with the quality system, our accrediting body who already we've required to report to, and allow the system to work the way it's intended to work? Because at what granularity do we report to the DA's office?
I think
These two go
There's-
to ASCLD.
I think
it
this might
comes
be.
to us, but the problem is that I think there's a misunderstanding in the laboratories that needs to be addressed about what the law is in this area and about whose decision it is to make what is important and what isn't for disclosure purposes. And I have never heard a prosecutor say that the law puts that decision in anyone's hands but the prosecutor.
Nobody's disagreeing with that. The question is this commission going to make a recommendation to require laboratories to preemptively require to give that to the DA's office when the DA hasn't asked for it? The DA can ask for, and individually a DA can require the laboratory that is their laboratory to give that to them. But the question is this commission going to require the laboratory? Because we fall under you and we have to follow your recommendations.
We received a self-disclosure from a laboratory stating that the analyst failed a proficiency test due to her negligence. The laboratory decided not to disclose that to the DA. That's what we're talking about right here. And I don't think that the prosecutors would think that the judgment call that the lab made not to disclose it, and I don't think they're doing it for any other reason than just that we haven't talked about this issue and that there's not a real understanding about when it needs to go. But I can't imagine the prosecutor in that county not wanting to know that information.
That's one case, and there's an error because she had the wrong finger. But what he's saying is there's oftentimes on these proficiency tests, and I've had it too, where it comes back that I was in error. And then we argue with them, and then they take another consensus, and then they send it back and say, oh, you're right. We had 80% of the individuals saying they don't agree with this, and now we're going to just get rid of that question. So in that case, I see where you're saying it's a mistake. She's looking on one hand and she says it's the wrong finger, but many times it's that whoever they initially pulled was incorrect, and most of the pathologists don't agree with it. And this happens in laboratories too. When I was a lab director, we would argue that that was really a flawed question, and a lot of people would miss it. 90% of the labs would miss it. That's what he's saying. There are times, because they're just proficiency tests, that they will change the answer because so many labs either missed it or argue it. In this case, this is an error, and maybe you can rule that if it's this type of an error where she just has a left finger and it's a right hand, I see the difference. But he's actually arguing there's other ones that later will be overturned, and so are they going to report all of these to the district attorney's office and then 4 months later say, oh wait a minute, now it's corrected and they didn't miss that question?
I think that I would likely not have not send, if that's something we had to do, send to the elected DA in Dallas. I think the public integrity unit there would probably handle that, and it would be their responsibility for maintaining and dispersing it. But if you've proven that the actual test is erroneous, I do have a problem with that disclosure, that you've made an error when in fact eventually the test is that sample. So in those cases, I think that wouldn't be disclosable. It wasn't the analyst error.
Right.
And I don't disagree with that. I don't, again, this is, as Lynn has stated, this is there's no arguing this was a mistake. This category of mistake has to be disclosed. There's no question about that. We have that obligation. That's what we're speaking to. And it does not naturally follow that we're going to get hyper-technical and delve into the whole realm of things. Again, if I miss a question and I argue with the teacher about it and they give me the point, I didn't miss that question. I get that. That's logic. At a very basic level, this type of error needs to be disclosed.
Well, Richard, that's correct, and I agree now, with understanding the law and everything. But the laboratory sometimes takes them, the proficiency time comes, and it's happening. By the time that resolve and they know exactly what happened, it might take 5 months, 1 month to sometimes 1 year. To, the proficiency person. So when do they have to disclose it to the prosecutor?
When they determined it was a mistake. If the process has to be finished for them to get to that point, then that's when they tell us
So
about it.
when they got the root cause and everything has been done, not the
Yes.
first thing?
No, we are not.
I just want to be sure everybody knows it.
Nobody's questioning the lab's ability and the necessity that they internally control and the process they use to meet their proficiency standards. And I have no interest in watching that process. When it's over and a determination has been made that a mistake was made, at that point, we need to know about it. That's at least my position on it, that no, we are not asking to be a partner in that discussion. We're not qualified to be a partner in that discussion, just as I'm not going to argue. I don't want to delve into and argue the point that if the lab if they challenged that proficiency test and ended up having them say, okay, that wasn't a mistake, I'm not going to argue that point either. But at the end of the process, that's when we need to know about it.
Okay, I wanted just to be sure that everybody be on the record so everybody knows.
Yeah, I just have a few comments, and obviously did not think I was going to end up on video today. I was trying to have a casual Friday. And I guess in kind of tongue-in-cheek, but not really, I mean, if what's required is a request on behalf of all of the district attorney's offices in Texas that we need this information, then I'll stand here and make it. I mean, we need this information. There are many more cases that prosecutors handle than analysts who fail proficiency exams. And so to suggest that the requirement should be that the state should be issuing subpoenas or getting discovery orders to get information on every single case just to make sure that there's not an analyst on that case that has, any baggage, for lack of a better word, I think is a little bit counterintuitive. I can tell you that in Harris County, we have a great relationship with our labs. We are working on, and in fact, we're in our pilot program right now of our disclosure database, where we're gathering information on all recurring government witnesses, police officers, analysts, etc. And our agencies know to contact us, and the purpose of that database is to provide internally, not externally, it's not available to the public, but to provide our prosecutors with access to the information that they need to disclose. And just to kind of go back to, Dr. DeMaio was talking about the gotcha moment, right? We don't want proficiency tests to be gotcha moments. Well, on behalf of the prosecutors, I would like to pose this gotcha moment, and that is that I don't have the information that I need on an analyst. The defense attorney has it because he's issued a discovery order that he's not told me about because he's certainly not required to. And then I'm the one who's gotcha'd in the middle of trial. I'm accused of a Brady violation. And then now, certainly under the recent Schultz opinion, my law license is on the line. So these really are big, important issues, and they're issues that are bubbling up right now. Brady and Giglio have always been here. The Michael Morton Act is what really brought all of this to the surface. Any training that I go to on these issues, every district attorney's office in the state is grappling with how do we cull this information? How do we receive it? How do we sift through it? What information needs to be disclosed? What doesn't? We're all working on it on a daily basis. I've literally been in meetings for a year on how to handle it in Harris County, and we're just now to the point where we're putting together a list, and we're working very hard just for the analysts in the room and the representatives from the labs to know that we first of all very specifically state that the receipt of information about an officer or an analyst does not disqualify them as a witness per se. We are not commenting on their availability, their reliability as a witness. As lawyers, our job, even though we have the information and may have to disclose it, if it's not admissible, we litigate. We're protecting to the extent that we can the reputations of these witnesses, but we still have to know about it because we have to disclose it. And again, if we can keep it out of the trial, we'll certainly do that. But Brady and Giglio, and certainly Michael Gordon, has put us in a position where we have to be in possession of the information so that we can properly disclose it. And then I think that's all I had to say. Obviously, the issue that's directly in front of the commission right now, in my opinion, is clear. I mean, there's no question about it, but it does open the bigger question of when does information need to be given? And again, my position, and I think my brethren here would agree, that all DA's offices need to know if you have someone who has failed a proficiency exam, certainly something that has been due to negligence, we need to know about it. I think the imputation question has been answered. I think that if I'm relying on a laboratory to provide information and to be a state's witness, then you're part of the prosecution team. So those are my comments on this issue.
Thank you. Don't even know where we're at.
Dr. Bernard.
You know,
I think I know which case we're on at this point.
yes, I'm going to take a vote on this. Someone has to make
I
a...
think what we
What
originally
was the
said was that the
subcommittee's
laboratory-
recommendation?
The laboratory had done all that was necessary
Right.
regarding this particular issue. But then the discussion was about proficiency tests.
It's a philosophical discussion, right? So we've drifted off the topic.
So there are two different topics here, whether they're two
Right.
different motions is,
I think I would stick to one motion and not get into the second one yet right now.
But they're still
we
reviewing,
need
but they're
to
still
make-
reviewing cases. I mean, we don't have the results of those, of the case.
No, on Corpus, on Corpus, the recommendation from the committee is no further action is required with respect to their corrective action, but that they should let the prosecutor know about the failed proficiency test
Yes.
in this case.
And that is my
Right,
motion
that's
as
fine.
relates to this particular case.
I second that.
Okay.
Aye,
Aye.
nay,
all right. The fourth case is Wilson. It deals with DPS, Houston, and DNA analysis. Defendant Jackie Wilson was convicted by a jury, sentenced to 60 years in prison for the murder of Cynthia Hughes. At trial, DPS analyst testified that she performed 2 DNA analyses in her investigation of the case. One was a DQ alpha test that confirmed the presence of Wilson's DNA on a knife blade next to the body on the front doorknob, and in vaginal and anal swabs from the victim. She testified she performed the DQ alpha test in 1996, when the lab did not have the ability to do STR testing. But in 1998, a second DNA analysis using STR typing was performed, which showed the presence of Wilson's and the victim's DNA on the blood taken from the railing to the stairwell outside her apartment, in a blood sample taken from the mattress, on the blood taken from the knife blade, on fingernail clippings taken from the decedent. The STR further showed Wilson's DNA in the blood on the doorknob assembly and the sperm cell fraction from the vaginal and anal swabs belonging to him. He complained that the analyst gave false testimony, issued false reports, withheld evidence during trial, and alleges that the analyst never conducted STR testing. In response to an appeal filed by him, the state is maintaining the DNA evidence in the case is uncontroverted. The recommendation was that this be referred to the DNA mixture triage team. Is there any discussion?
You're going to hear that quite often.
Does our prior motion and acceptance of that motion give our legal staff the ability to just do that now?
I would say that, y'all are the attorneys. I mean-
Well, I think for now, for today, we should take individual motions
Okay.
to refer.
And from here
And
on.
then from there on out, we'll switch
Okay.
the.
So the motion or the recommendation from the subcommittee was this be referred to the DNA mixture triage team.
second, anyone?
Second.
Aye,
Aye.
nay,
All right, the fifth case is Harris County DA's office dealing with DNA. Complainant Darius Ellen was convicted in 1983, sentenced to life in prison for the aggravated robbery in Harris County. He was granted DNA testing in 2012. On November 27, 2013, the DPS Houston lab reported they were not able to retrieve a profile for comparison, but recommended DNA testing using minifiler kit. The testing was performed using minifiler and excluded him as the contributor. The state's in the process of determining whether DNA was from the victim or a possible alternative suspect. A second analyst retested the evidence but was unable to get a profile due to degradation. The victim's son was found. DNA was obtained from him. The DNA material was not strong enough on mitochondrial DNA testing to yield a profile for comparison. Mr. Elam also asserts the fingerprint evidence was used falsely to implicate and identify him in the crime. His attorney is Gary Udishin, who's a defense attorney in Dallas, and currently all the all the biological evidence is now back at DPS Houston, where further testing is being confirmed. The recommendation from subcommittee was also that this be referred to the DNA mixture triage team.
With a note that he's represented by Gary Udishin, Inger is working on the case for the state. It's
taking a long time.
It's just taking a while. So it's in process, and I don't know what else we could possibly do.
So moved.
Motion.
You moved? I'll second.
Aye.
Aye.
Nay.
The sixth case is Cockerham, deals with Southeast Texas Forensic Science Center dog scent lineup and the autopsy. Mario Cockerham was convicted of capital murder in April 2009 for the suffocation death of his 6-month-old daughter. He alleges evidence used in obtaining his conviction was a dog scent lineup and that a biased report from the pathologist who determined his cause of death. He was identified as the perpetrator by the child's mother, who was also stabbed during the incident. In April 2011, the commission dismissed a complaint filed by him because the allegations fell outside the jurisdiction at the time. The commission forwarded the complaint to the Innocence Project, who declined to accept the case based on facts and such as the account given by the mother, who was a witness and was also stabbed. In February 2013, Texas Court of Criminal Appeals issued a unanimous opinion related to dog scent lineups that they do not provide enough evidence to support a conviction beyond a reasonable doubt, and that dog scent lineups as primary evidence are insufficient to support a conviction. The subcommittee and staff recommended that that this be dismissed because it's already determined that the dog scent lineup had been evaluated by the Texas Court of Criminal Appeals and determined to be not valid, and that there'd be nothing left for the commission to do. Secondly, the evaluation of the autopsy is outside the commission's jurisdiction. So the recommendation was that it be dismissed.
Second. Aye.
Aye.
Nay.
I think we're not really, when I'm giving the recommendation, that's not,
So who made the motion?
unless they're
Kessler?
allowing me to
Kessler
make a
made the
motion.
motion,
so-
yes.
Kessler made the motion.
Yeah, we
Okay,
did.
all right, just want to make sure we're getting the first motion. All right,
Who seconded? I'm sorry. Bobby?
Bobby.
Bobby.
All right, number 7, Stevens, Austin Police Department Controlled Substance. Deborah Stevens, who was a former employee of the Austin Police Department Crime Laboratory, filed a complaint against the Austin Police Department. She complained that the Austin Police Department falsely reported to the media and the professional forensic community that an analysis she conducted in a controlled substance case against Stephen Louis Vallejo was tainted. She claimed there are no errors with the analysis of the case, and further asserted that APD created corrective action reports to taint her reputation. She's requesting an audit of Austin Police Department by an outside agency. In response, Mr. Gibbons, laboratory manager, pointed out that the Vallejo case was part of a previously dismissed complaint that Ms. Stevens filed with the commission. And in this particular case, he states that what she has forwarded is a draft report, and that when an administrative review is conducted in LINS, the draft is replaced with the signature of the originating author and finalized, and will show final report date. So this is a draft report. An ethics complaint was also filed with ASCLD, and it was dismissed by ASCLD. The recommendation is that the complaint be dismissed, and it does not allege any negligence or misconduct to the particular forensic analysis at issue.
Before we go there, I just want to refresh the recollection of the commission that there was an investigation into these same allegations, or very close to them, that was headed up by Richard Alpert a couple of years ago, for which a report was issued and dealt with, in particular, the question of draft reports versus final reports. And Patty Williams came from AFCLAT Lab, and we did an on-site visit, and the commission concluded that the allegations were not substantiated and offered some suggestions for improvement as the laboratory was moving to its ISO accreditation. It was moving from legacy to ISO, right? And so that entire process occurred, and what you have here is sort of a reiteration of that error of cases, as well as a number of interwoven HR type complaints and general allegations of ethical issues, and sort of a request that the commission go on some sort of fishing expedition at the laboratory. And I don't think the commission has ever done that with any laboratory. So that's all I have to say about it.
Okay, someone has to make a motion to dismiss.
I'll make a motion to dismiss.
Second.
Aye.
Aye.
Nay. Okay.
Number 8, this is the Spence case, McLennan County DA's Office, DNA and bite mark analysis. Jason Spence is the son of former death row inmate David Spence. David Spence was executed in connection with the rape and murders of 2 17-year-old girls and the murder of an 18-year-old boy in Waco in what was known as the Lake Waco triple murders. Mr. Spence, Jason Spence, believes that his father was wrongly convicted, and he is asking that we review bite mark evidence used to convict his father, and testing of DNA evidence related to another person convicted, in this case, Anthony Melendez. The bite mark analysis was a significant piece of evidence that led to the conviction of Mr. Spence for the Lake Waco murders. Mr. Melendez is currently represented by defense attorney Walter Reeves, and is awaiting DNA testing available in this case. Originally, this was reviewed in a complaint because the complaint was against a laboratory and DNA analyst in California who had the evidence. At that time, Dr. Eisenberg offered to test the evidence at North Texas free of charge if the evidence would be returned back to Texas. And the Commission's General Counsel worked with the attorney, Mr. Reeves, to assess the status of the DNA testing. And on November 9th, 2015, the Commission General Counsel sent Mr. Melendez a letter informing him that UNT Health Science Center has offered to perform both nuclear and mitochondrial DNA on any evidence remaining. This is also conveyed to Defense Counsel, and it's currently in the process of getting it all transferred to UNT. Currently, there's really nothing further the Commission can do in this matter with regard to the DNA testing. It's up to the attorneys in the lab performing that. It, however, may have some merit in reviewing the case in terms of the bite mark review, but as far as anything further that the Commission can do regarding this, and it was a 1982 murder, the recommendation is that the complaint be dismissed.
It's already on the bite mark list, but the DNA, I mean, aside from Dr. Eisenberg offering to do the testing, for free and trying to facilitate that process. The commission has no jurisdiction to order DNA, to move DNA, to do anything. I will say Representative, excuse me, Representative Ray's office called and wanted to know what was going on with the case, and we told him the information we had. So there is definitely some interest in the public and in our legislature. But from what I understand, it's at UNT and they're working the evidence.
So everything's been, the two things he asked for are
It
being
was
done.
delivered last week, from what I understand.
So the recommendation was that we dismiss the complaint because there's nothing left for us to do. It will be evaluated in the bite mark review group.
Want to make a proposal?
Motion dismissed.
Second?
We have someone who wanted to make a public comment.
Oh,
Sorry.
I can't.
Yes, sure.
sure.
I am Jan Thompson from Waxahachie. I've been connected with this Lake Waco murder since 1982. My niece was a victim. She was
Could you come?
brutally killed.
Oh,
We
no,
can
never mind.
take the mic off you.
I'm sorry, I didn't say it. I didn't say she had that.
My name is Jan Thompson. I'm from Waxahachie. My niece, Jill Montgomery, was murdered at Lake Waco, July 13th, 1982. David Spence was convicted. I attended 4 capital murder trials, sat through every minute of every trial. I personally never could believe or understand the bite mark testimony, as some of the rest of the family couldn't either, but at that time we believed what our district attorney and private investigator told us. Of course, we wanted to believe we had the right people. We no longer believe that. David Spence was executed for the crime. Tony Melendez is the only living defendant, I'll say. Now, he's in prison in Livingston, Texas. He's been there 33 years, I believe. The bite mark evidence for David Spence's conviction consisted of, and you all probably know this, but I have to say it. A year went by after the murders. The medical examiner in the autopsy states possible insect bites on my niece. A year later, a year and a half later, a special prosecutor was brought in from out of Waco, out of McLennan County, by the name of Ned Butler, and he had a good friend named Dr. Homer Campbell in Albuquerque, New Mexico. Dr. Homer Campbell had just finished one case on bite mark evidence. Ned Butler looked at the pictures of my niece on her breast and said, you know, that might be bite marks, human bite marks. So he calls up Dr. Campbell, and Dr. Campbell gets involved. And the next thing we know, we have a slam dunk because of this. I'm sorry, folks, but I just can't see that this should be ignored. There's so much more involved. It is a very complicated case. It's very, very complicated. And it was in '82. But that means that my niece was 17 years old, and I really believe that the people that were convicted of that crime were not and is not guilty. If Tony Melendez is not guilty, I said if, he does not deserve to be spending 33 years with his mother dying at home where he can't even check on her.
It just shouldn't be. And I'm more or less begging you guys to really, really think about this. I know you've said the commission really can do nothing more. I understand that. But I would appreciate any thoughts that you might have that you could give someone else that maybe could help us in this. We need to know about this DNA. There's something really strange. The labs are telling us they've never seen it. Okay? And that's, I'm talking about UNT. They're saying, no, they don't have it, they've never seen it. But yet we were told that in October of 2015, that Walter Reed has the results of that DNA. But yet we aren't allowed to know that. Is his client not allowed to know what his own results were in that DNA?
Was that the California test?
No, we were told it was Pennsylvania.
So at some point, the evidence went to NMS Labs in Pennsylvania. I don't know why. At another point, it was in a laboratory in Arkansas. The thing is that for the commission, just to be clear, on the DNA piece of it, we are trying to help facilitate that testing, but we have no jurisdiction over any laboratory outside of Texas, and that DNA evidence, we can't take custody or do anything with it. That's for courts and lawyers. Now, on the bite mark piece of it, that transcript will be reviewed. It's not that we're saying that it won't. We're just saying that the complaint has 2 requests in it. Okay. One is respecting the DNA testing, and the other is with respect to the bite marks. On the DNA, Dr. Eisenberg has been saying for a couple years that they would test it at UNT. And so that's the extent to which we can do anything on the DNA. I mean, right? But on the bite marks, it will go in with the rest of the cases that will be reviewed.
Okay. I will add this, and then I'll politely sit down. Walter Reeves does not see fit to inform anyone, family or even his own client at times, as to what he's doing or why it went to Pennsylvania. We don't have any idea, and neither does his client.
That's a matter for the state bar. That's something else that we don't, if he's not representing, I mean, if he is not doing what he's required to do as relates to his client, that's with the bar. I can tell you that there's no obligation for him to communicate to anyone else. But, okay, but we just don't have any control over that.
But to his client?
That's a state bar matter. That's not a, I'm just saying, I'm not disagreeing with anything you've said. I'm just saying we can't do anything about that in this group.
I understand.
Okay.
The state bar there was a grievance filed.
Okay.
And it was dismissed.
Which again is outside of our control.
Right.
My name is Scott Opel, and up until last Thursday or Friday, I represented Jason Spence. Jason's had a hard time, but he's got a good companion named Bernadette Fazell, who is not going to let this go. Bernadette has been living and breathing this case for years. I was introduced to Jason Spence through Bernadette, and Jason understandably is frustrated over the whole process. But during my tenure as Jason's lawyer, I had a paralegal named Mark Shoemaker, I believe, who I apparently pissed off last week, and he took Jason with him. So I don't know who Jason's lawyer is at the moment, but during my time representing Jason, which was, I guess, about 6 weeks, we called Eisenberg's office. And from what I was told, when I overheard Mark on a speakerphone conversation, was that the results are in, the DNA results are in, but we can't get them because we're not, we didn't order the tests. And so Walter Reeves apparently is the only person that Eisenberg's office is willing to communicate with. And Walter Reeves, for one reason or the other, hasn't produced them. So I would suggest, just as a member of the public, that there be, even though you all may not have a jurisdiction or teeth, you can at least request the results of the DNA. In some,
I don't,
propose
we can
that
talk to Skip Reeves about it.
you can, is there any way that if you have to, for whatever reason, I don't know what Skip Reeves' motives are or what his interest in for getting the results, but Weisberg's office says the results are in. And if for whatever reason, and you just heard the State Bar has already ruled on the complaint made, it's just a matter of getting the results. You would think that a letter of representation from a subsequent lawyer would suffice for purposes of Heisenberg's communication, but their position is that Walter Reeves ordered the results, or ordered the test, and only he is entitled to it.
So that's the way-
Where's Walter Reeves, and why won't he give the family the DNA results is our question. But can we go around Walter Reeves in your position of, if nothing else, encouragement, for goodness sake?
We can encourage
Please
him,
encourage.
but the fact of the way it works is this is an unusual case, but at some point, the state released that evidence to Mr. Reeves. And so Mr. Reeves, from the laboratory's perspective, is the submitting agency at this stage, and therefore, the results go to Mr. Reeves. Now, we can talk to him. I promise you, when I leave here, I will call him. But I just can't, I think this, the laboratory is following its procedure. And
It's a chain of control from hell.
Right, it's been really, the whole case, I don't know how they're gonna get any, the evidence has been in very many places from what I understand.
But for the record, I don't represent Jason or his family. I just came to listen to what the results are.
I think one of the strengths of the commission is we try to work together with as many people as we can to facilitate resolution of difficult issues, and we will keep trying to do that because I understand that.
One of the strengths of the Spence family is Bernadette Fazell.
I think that we will do what we can, and I would encourage Ms. Thompson to continue to call us and communicate with us, and we will keep trying to help out to the extent we can.
I so appreciate your help and Liz, just in communicating with us. It's hard for us to even get anyone that will talk to us about it, so thank you very much.
You're welcome. Okay.
So we have made I think we passed.
Yeah, we're done with that one.
Okay.
Yeah.
The comments again after.
Fire marshal, yes, fire marshal.
We're going to have a presentation now from the fire marshal.
Which agenda item is this?
So we have our state fire marshal here, and he needs to leave at 11, so we want to interrupt the complaint treatment.
Right.
Here from our fire marshal, who has great news for us.
Yeah, hi, good morning. Chris Kinley, State Fire Marshal, and just wanted to update y'all. I apologize, I haven't been able to be here in a while. Travel keeps on getting away, it seems. But that said, we have been continually working on the recommendations issued by the Forensic Science Commission. And it's hard to believe now, but we're entering our 4th year of our establishment of our Science Advisory Work Group. And so we're very excited about that. We continue to do the quarterly fire investigation forums. We have completed the review of all the convictions that the state fire marshal officers involved with arson. And thank Dick in his former role with the Innocence Project of Texas. We forwarded those cases to him so his staff could review them in the spirit of transparency. And so we've done that. Going forward, we'll review each year. We're going to review 2015, and we'll take that to the Science Advisory Work Group going forward for review of those convictions. And we are continually trying to encourage other entities around the state to do the same process as what we've gone through the state fire marshal's office. I know Nick was supposed to talk about it, and it's on the agenda, but, okay, well, we'll do that. But in the spirit of collaboration, I give a lot of credit to Nick and his former role in Innocence Project Texas, but the International Association of Arson Investigators has come out and endorsed the process that we are using in Texas. One, having a multidisciplinary team that y'all have amongst your 17 recommendations, what we call our science advisory work. So they are encouraging other fire investigation organizations around the world, and this is truly an international organization, not just the United States, to establish that panel to review past convictions, and they're equally encouraging their members to have retroactive reviews. And we think this is a huge step forward. It is, since then, a lot of good things are happening. Florida, West Virginia, Ohio, Tennessee, Maryland are all approached us either to come out and visit with them or their respective fire investigator association in their state, or they've been coming. Ohio has already been to our Science Advisory Work Group meetings once. They're coming again next week, or in Edinburgh. And so there's a number of organizations, I say, put their toes in the water and seeing how the process works. And we want to remove any concerns they may have how that process works. It's a very transparent, open process. It's been very good for the State Fire Marshal's Office. And we continue to do that. We're doing primarily cold cases. We don't have any referrals from the Innocence Project, and since we've already completed all reviews of our convictions, aside from 2015 and each year as we go forward, we just continue that process. And again, look at cold cases, but we're encouraging other jurisdictions around the state. We've been going around Texas since this time last year, encouraging local jurisdictions to review their convictions as well as the International Association of Arson Investigators is encouraging their members to do just that. So very exciting, and I'll give y'all a lot of credit. This is ground zero where all this happened with those recommendations that we are continually diligently working on. So any questions for me?
I just appreciate everything you're doing. Thank you.
It's collective we.
I just want to add to it, you have in your binder the statement from IAAI. As he said, largest professional organization of arson investigators in the world, over 8,300 members worldwide. And there's some very strong language in this statement that they released that I just want to read a little bit from it. The IAAI believes that the fire investigation profession, as it matures, has a duty to correct past errors, including errors such as wrongful convictions. Further, a properly functioning judicial system not only endeavors to avoid such errors, but also attempts to identify and correct them. Accordingly, the IAAI supports criminal justice agencies that engage in post-conviction review of the science and methodology underlying arson convictions when there is a credible and substantial allegation that those convictions were based on outdated science or methodology. And that's just a little bit, but that's strong language coming from the largest group of arson investigators in the world, and this is made possible because of the example that we set here in Texas, and largely because of Chris Keneally and the work that they've done. So that can't be acknowledged enough. I know we like to pat ourselves on the back every time we can, but really, you guys are doing a great job. So
thank you.
Thank you for all your service.
We all deserve a tremendous amount of credit, and I'll always be grateful, and thank you for what y'all do for the state of Texas as well. And transition to Steve Sedek.
Yeah, sure. Steve, you want to give us?
Well, on the spirit of the hands-on training, one of the 17 recommendations there in the report, Steve Sedek, who is the Wiley Fire Marshal, but also represents Collin County, the Fire Investigator Association has been doing a lot of work in a partnership with Sam Houston State University of getting cadavers and doing burns, and so they've acquired a lot of data, and it's very good training. So I'm going to shut up and let Steve talk. And again, thank you all for your support.
Thank you.
Thank you.
Hello, again, my name is Steve Sedek. I'm the Wiley Fire Marshal. I'm the president of the Collin County Fire and Arson Association of Investigators. I'm not here to ask for money this time. but our class went really well. We had federal, local, and state folks at our class. We had 3 different states and 10. We had 6 crime scenes that we created. And some of those crime scenes, we had up to 35 federal couples throughout the crime scene. So we did gather a lot of data from the crime scenes that we're still kind of sifting through. People are looking at what kind of research they may be able to pull out of it. That's kind of been our goal all along, is to include academia, learn from academia, do some practitioner training out in the field, and actually do hands-on. Your funds that you provided us for this class were very well used. We're going to do a second class this year at Sam Houston State in September. Along with your funds, I have to thank a lot of other folks, Sam Houston State Staff's Lab, Center for Biological Field Studies. They allowed us to do these burns and schedule for 2 years in advance. And I've had over $90,000 of in-kind donations for this course, for just this last course. So it's amazing the kind of support I'm getting from both folks like you and the private sector. I just wanted to thank you and give you an update. It was money well spent. Our goal this year is to do a class of 110 folks with 10 crime scenes and treat it as a large-scale investigation where different crime scenes are connected, along with gathering the same amount of data as we did last time and then improving on that data. So I do thank you for the support.
Thank you.
Thank you.
Did you go to, you saw, so you?
Yep. Yeah, I was able to step in and attend just a couple of hours here and there on each day and talk to all the participants, and it went extremely well. It was very well organised. You couldn't fault the way it was actually conducted. You did a fantastic job. And everyone there said it was absolutely phenomenal in terms of a learning experience and being able to transition that into their daily duties, which was good. And it seemed like an extremely good course and training to do. So yes, it was, from what I was able to glean from all the participants, that it was a much worthy course to attend, and it was a great learning experience. So I look forward to it again this year. Can I just add to that? The one thing I'd like to do, and we'll talk with Steve about this, is incorporating maybe some little bit more forensic science research in with that as well. So we'll look at maybe doing a little bit more collaborative work with the forensic science department and do a little bit more research to assist you guys as well. And that'll be really broaden the scope of that training, which I think would be great.
Yes, ma'am, we welcome that. Thank you.
Back to the complaints. Number 9, the Eccles DPS Waco sexual assault kit, DNA. In 2012, a jury convicted Randy Eccles for indecency with a child by contact, sentenced him to 20 years in prison. He complained that the same nurse who performed the exam neglected to document the number of debris swabs she took from the victim's buttocks and ankles, which then opened the door for tampering with the evidence. He also generally complained she misrepresented her medical findings. His DNA was compared to a profile from evidence from the crime scene. The profile was found to be consistent with Eccles' profile. He complained the evidence was tampered with and unsealed at some point, and the DPS crime lab employee failed to report this. He also claims the detective in the case tainted the crime scene with his profile from buccal swabs the detective obtained. This was recommended to be referred to the DNA mixture team. There was no allegation of negligence or misconduct related to the actual forensic analysis.
So moved.
Second.
Aye.
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 Number 10, this is the McClure case, in which this involves Dr. DeMayo and bullet trajectory and gunshot wound. At trial, McClure confessed to killing Ken Hilliard and stealing property, but asserted the conduct was justified as self-defense. The medical examiner from Dallas County testified that the skull was fractured by a blow to the head, that the decedent had ingested methamphetamine, and the cause of death was gunshot wound and blunt force injuries. Dr. DeMeo was called to court by Mr. McClure to refute the assertion that the head injury contributed to the death. And he complains that Dr. DeMeo was negligent in his testimony because he answered questions pertaining to the evidence at the crime scene regarding relative positions of the decedent and the perpetrator. When he lacked the direct knowledge, there was sufficient information to express the opinion. He believed Dr. DeMeo's testimony regarding the time the shot was fired was an unascertainable fact based on what Dr. DeMeo had for review. And he alleged further that Dr. DeMeo speculated about ballistics when questioned at trial that ultimately negatively affected the outcome of the case. In this case, both Dr. DeMeo and I have to recuse ourselves in this, since the autopsy is done by my lab, and Dr. DeMeo is the subject of the complaint.
Okay.
And this had to go to straight full commission because the subcommittee couldn't function with just Richard alone.
We no longer have a quorum, do we?
Yes, we do.
Okay. But Dr. DeMeo can't vote.
No, neither
Yeah,
one
but
of us
the
can
quorum,
vote.
so the quorum is not impacted by recusal, put it that way.
Okay. So, as someone who's not recused, I'm going to recommend that this full commission dismiss this complaint as it deals with an autopsy, which is not within the jurisdiction of this commission.
Second.
Aye.
Aye.
I know. Just telling me, everyone looks at me, but then she hits me and says, no.
Anyone, any
Don't even say
nays?
aye. I can't vote aye.
All right, we have 2 recusals and no nays, so it passes.
Okay. Number 11 is the Brown Fort Worth Police Department firearms tool marks case. In August of 1997, Jarnell Brown was convicted of capital murder in Tarrant County for the shooting death of a person during a 1996 robbery. He admitted he was involved in the robbery shooting and fired 4 shots. However, he claims another person was also shooting and that the other person actually killed the victim. He stated that the Fort Worth PD crime lab received 9 bullets, and he claims the laboratory omitted findings related to 6 of the bullets, although all 9 are detailed in the report. He further alleged there are discrepancies in the laboratory report related to what bullets came from which gun. He states the lab also mentioned one of the bullets analyzed did not match bullets from the gun used to kill the victim, but the lab then later stated the bullets were fired from the same firearm used to kill the victims as bullets 5 through 8. Any overall questions of reliability of the report request to review the laboratory findings. This also had to go to full commission because Richard is with the Tarrant County DA's office, I think.
Yes.
Yeah, I thought we moved.
That's not
So the staff recommend this should be referred to the Innocence Project, and the complaint should be dismissed since the original analysis was performed in 1997.
And because, I mean, it doesn't really state any negligence or misconduct, and he has some legal claims, the clinics will vet them, but I don't know what else there is to do.
Motion, someone make a motion.
So moved.
Second?
Second.
Aye.
Aye.
Nay.
All right, number 12. Guadalupe Padilla is currently serving a 37-year prison sentence, concurrently with the 15-year prison sentence following a 2002 conviction for aggravated sexual assault of a child and indecency with a child by sexual contact. At the trial, the DPS Austin lab presented results showing no semen detected on samples taken from the victim during the sexual assault exam. They also reported that the DNA testing was done on the bed sheet from the bed where the assault occurred. Test results determined that the victim was excluded as a contributor to the semen stains on the sheet. 3 post-conviction DNA testing motions have occurred, the results of which STR DNA testing on the bed sheet revealed the victim was excluded as a contributor to semen stains on the bed sheet. Padilla could not be excluded as a contributor to the stains on the sheets Two of the semen stains contained a mixture of DNA profiles of Padilla and an unknown individual. The STR testing of the victim's vaginal swab indicated no human male DNA was detected. The DNA profile from the vaginal swabs was consistent with the mixture, from which the victim could not be excluded as the major contributor to the DNA, and due to a low number of alleles in the minor component of the mixture profile, no comparisons were made. The results of the post-conviction YSTR DNA revealed no YSTR profiles obtained from the victim's vaginal swabs. He also asserted in his complaint that the evidence of an STD found in the victim's sexual assault kit excluded him from being the perpetrator, and alleged the bedsheet evidence, which excluded the victim's profile, had no traces of an STD, therefore indicating the evidence of an alternate party. He requests the Commission research the significance of draft genome sequence of the sexually transmitted pathogen Trichomonas vaginalis, and believe that this information applied to DNA testing would assist in identifying the alternate party who was the real perpetrator in the sexual assault. The recommendation was that this this complaint be forwarded to the DNA mixture triage team.
Discussion?
Okay, look. Aye.
Aye.
Nay.
Did we have a motion?
Who made the motion?
I mean, I just said what the recommendation was.
No. Everyone was looking at me. I assumed.
We need to have a motion.
I'll move.
A quit.
All right.
Albert moves.
I move.
Lammer seconds.
Hammer
And
seconds.
then,
Okay.
aye.
Aye.
Aye. Okay.
Committee chair can't make the motion?
No,
No, they shouldn't.
Okay.
All right, number 13, this is the Pinion case, Tarrant County DA's office, general innocence allegation. Mr. Pinion is currently serving a 15-year sentence after a November 2012 conviction for indecency with a child by contact. He asked the Commission to review all evidence in the case. He also complained about the enhancement of his sentence, stating his charge for possession of drugs was unfair to apply to the enhancement ruling. This did not allege any negligence or misconduct related to forensic analysis, but really asserted just general allegations of innocence. And we had to move forward to the full commission because it came as a complaint with the Tarrant County DA's office. The recommendation by the staff was that because it didn't allege any misconduct to the analysis, that it be dismissed.
Make a motion. Someone make a motion.
So moved.
Second.
Second.
Aye.
Aye.
Nay.
Okay, number 14 is the Irvin unknown laboratory. It's a DNA case. Mr. Irvin is serving a life sentence for aggravated sexual assault conviction in Jasper. His sisters claim that he's innocent, and they are requesting a copy of the case file from Jasper County, laboratory reports, and that they've been unsuccessful in obtaining them. The staff has requested a copy of the report, if it exists, from DPS Austin. And based on the limited information and the fact they seem to just be trying to get results of the analysis, the recommendation was that the complaint be dismissed.
Make a motion.
I move that it be dismissed.
Second. Aye.
Aye.
Nay.
No, on this one, I do think that we should give it to Bob Wyckoff because he could probably check against the list that the laboratories have created to see if it's a mixture.
Okay. If there's any evidence.
Yeah.
If there's
Yeah, if there's a, I mean, we don't have, the request is so scant, it's hard to know, so.
Okay.
Richard?
I'll move that we forward this to the DNA mixture group.
Second.
Second.
Aye.
Aye.
Nay.
Okay, number 15 is the Rogers IFL firearms tool marks case. Chaz Rogers, who's the mother of victim Anthony Hudson, who was shot and killed in 2012, complained on behalf of the defendant, Devin Chandler, who was convicted in her son's death, believing that Chandler was wrongfully convicted due to faulty firearm tool mark evidence by IFL and seeks closure and finding the correct murder. Mr. Candler was convicted in October 2013 for manslaughter, and 3 juveniles were shot, one of those being 16-year-old Anthony Hudson, who has died. Mr. Candler was arrested for the murder. She believes that IFL misinterpreted the firearm tool mark evidence. In this case, she said that the evidence was transferred from IFL Lancaster to IFL Euless for analysis. And according to her, .38 caliber revolver was identified as the weapon that killed Hudson. She said that in her research, the .38 revolver shell casings are known to remain in the cylinder upon, or she called it spinner, upon firing the bullet, and that she has doubts as to IFL's findings and conclusions relating to the shell casings found at the scene. She also complains that IFL did not test a Wolf Federal 9mm found at the scene, questions why it was not tested. She also requests DNA testing on the 9mm. There was a subsequent follow-up response from IFL, which indicates that the bullet recovered from the decedent was in fact a .38 or .357 bullet, and that the casings, well, it wasn't casings, it was a cartridge, was a 9mm. And so it appears that her allegations or her complaint is in fact inaccurate. And the recommendation following the response from IFL was that this complaint be dismissed.
Someone want to make a motion?
So moved.
Second.
Second.
Aye.
Aye.
Nay.
In this particular case, IFL wrote quite a detailed response to each of the questions that the mother of the victim had, and so we want to send that to her so that she can read the explanations and maybe get some closure for.
Right, and
for
Ron
questions.
Fazio was present for our review, and he
was fine.
said he had no problem with us doing that, so.
Not saying the actual analysis, but the summation of the points in their response.
Yes, the response.
And I think that will clarify a lot of her clouded
You're right.
questions.
It's a good thing to do.
Number 16 is the Downs DPS El Paso DPS Lubbock DNA. James Downs was found guilty by a jury in 2008 for aggravated sexual assault of a child under the age of 14 years and aggravated kidnapping, for which he's serving a life sentence. He allegedly kidnapped 2 victims, a 10-year-old and a 5-year-old, and assaulted them together. He complains that his blood should not have been drawn when he was arrested, that the blood was used to contaminate other evidence that incriminated him. And he also claims that all of the investigating agencies failed to follow proper chain of custody. He also requests analysis on saliva, pubic hairs, and other hairs taken from him at the time of arrest. The 2 children, the identity appears to not be in question, as both children identified him as the perpetrator. The DNA tested in this case was likely a mixture sample, and the recommendation was that this be dismissed since there's no allegation of negligence or misconduct related to the analyses. And it could be forwarded on or referred on to the mixture triage team, since it probably is a mixture.
Anyone want to make a motion?
So moved.
Second. Aye.
Aye.
Nay.
Number 17 is the De La O Bexar County Crime Laboratory DNA. Carlos De La O was convicted by a jury on 4 counts of aggravated sexual assault of a child, 2 counts of indecency with a child by contact, and 3 counts of sexual assault of a child. In August 2000, a sexual assault exam was performed on a 14-year-old girl indicating she was pregnant. In September 2000, the child had an abortion. A sample of her blood was taken and the products of conception were turned over to Bexar County Forensic Science Center for DNA analysis. The DNA analysis of the samples revealed a 99.9% probability that De La O was the father. He complained that the Bexar County forensic examiner violated scientific protocols in conducting the paternity analysis. And this was, Dr. DeMeo is going to have to recuse himself from this. And it was recommended that this be dismissed because the allegations of negligence were unsupported. We got a pretty significant response back from Bexar County Crime Lab.
Okay. I'll move that we dismiss the complaint.
Second.
Call for a vote.
Okay. All in favor?
Aye.
Against? All right, it's unanimous. Number 18, this is the Webb, Dr. Susanna Dana blood spatter analysis. Marlon Webb was convicted of capital murder by a jury and sentenced to life in prison on May 31st, 1996. Webb claims that Dr. Susanna Dana, a pathologist, improperly testified regarding blood spatter analysis in this case. He asserts that Dr. Dana is an MD and unqualified to testify as a blood spatter analyst. At trial, Dr. Dana stated the gunshot wounds of the victim did not create back spatter from an entrance wound, which Webb claims by today's standards and techniques is an incorrect conclusion. Dr. Dana was not required to respond, but did, and her response included that she never presented herself as a blood spatter expert. There's a fairly good amount of material that's in the testimony, which I did not see anything that indicated that she claimed that she was a blood spatter expert. As a physician who performed the autopsy and saw the wounds and the wound tracks and the structures injured by the bullets, her opinion was requested on how blood would spray from the victim's body as a result of the wounds. She did not recall if she was shown the scene photos prior to trial, but was shown the photos at trial and asked her opinion about the scene photos in relation to the decedent's wounds and how blood would spray from his body when he was shot. She said to the best of her recollection, she was never asked to interpret scene photos as to blood patterns other than as they related to the wounds on the body. And all of the opinions that were given at trial were based on her training in interpretation of gunshot wounds, coupled with her experience evaluating gunshot wounds at autopsy. So the recommendation was, there are a couple of things. One was that this be dismissed. Dr. Dana did the autopsy. This, in regarding the medical examiners, is not covered by the commission. But there may be some discussion regarding blood spatter, and that this might be something to forward to the license committee to discuss where does blood spatter actually fit and who does it and what credentials or training might be appropriate for it, if I got that right. And that Dr. DeMeo probably has to recuse himself on this.
But can I mention something about blood spatter, whatever spatter, I can never remember which they like.
I don't know, Kenny?
Yeah. I don't think it's done in crime labs. Or most crime. I can't even say this.
You're not here.
Not for
Okay.
this discussion.
So the first recommendation was dismissal regarding the complaint.
I move that we dismiss the complaint.
Second.
All in favor?
Aye.
Those against? It's unanimous. The second would be the further discussion and recommendation that this be forwarded to, one, discussion of blood spatter, but we're referring it to the license subcommittee to discuss about, one, what is the definition of it? Two, what is the training required? And what area does it? Because some areas, such as the police evidence collection committee or collection agencies may do it, and that's not required to be under the commission. But if it's a trace evidence area, then it would be. So there's some more that has to be discussed, although my understanding is there's quite a bit of already on the plate of the commission, but this is an area that.
Is that your understanding?
So Lynn said I could make.
It's kind of really soft pedaling the topic, I understand, but that this is probably needs to be discussed at some point as to where it really belongs.
Lynn said I could make a comment.
Okay.
I know a little about that thing. Most of the people who are doing the interpretation are police officers. They're not in crime lab side. Are there any crime lab?
We do not perform that test.
Right.
Bill, at APD, does the blood spatter get done in the laboratory or is part of crime scene?
It's part of crime scene, which is part of our laboratory, but it's in our crime scene.
And in Bear? You don't do it?
We don't do it, but we do consider it crime scene.
So, and I think we talked about, so Greg Hilbig, who is soon to be introduced as the chair of the Licensing Advisory Committee, we talked about this a bit yesterday, so it's on the radar of the committee, I think.
Right. That's correct, yes. But it's going to be very, very interesting when you get into it. Because it's bifurcated. It's the blood from injected weapons from the blood from the bodies. And very interesting.
Well, there's a component that, as in this case, comes from the autopsy, that the medical examiner may be capable of rendering opinions on part of it, but to what degree and where do you stop is the other issue.
Yeah, because I usually stop on the body. But it's very, very interesting and unscientific field.
That's how you really feel.
So do we already have a motion to refer this? Did we have a motion to refer this?
Questions for licensing that we should ask them and let them come back and tell us what they think.
Yeah, it's already on their radar.
Okay, so make a recommendation.
Do we need to, or is it already done?
No, that first vote was the other.
I move that we refer this to the licensing committee to address the issues discussed.
Second?
Second.
Aye.
Aye.
Nay.
All right, the 19th, and the last complaint, is the Jefferson County Crime Laboratory, DPS, Houston DNA. Lawrence James was convicted by a jury for the stabbing death of his aunt in 2012. He was arrested while driving his aunt's stolen car. He almost immediately confessed to murdering his aunt, and his confession to police was consistent with circumstances at the crime scene. Investigators found blood in the house, outside the house, and in the aunt's car that was used to confirm James' DNA was present at the crime scene. He complains that a pathologist, Dr. Lisa Funte in Beaumont, performed the autopsy on the decedent. Jefferson County Crime Lab, who initially collected biological evidence from the crime scene, and DPS Houston, who performed the DNA analysis in his case, fabricated and tampered with crime scene evidence in a conspiracy to incriminate him for his aunt's murder. He alleges the pathologist reported ethanol in the decedent's blood, but the decedent did not drink blood. Excuse me. Sorry, I'm running out here. Alleges the pathologist reported ethanol in the blood, but the decedent did not drink alcohol. Yes, most people don't drink blood. And if you read in the other information supplemental, this was a decomposing body, so that's the answer to that. He alleges the agency collected the DNA evidence, sent an employee to collect the evidence who's related to the assistant district attorney who participated in the prosecution of the case. The recommendation, well, this had to go to full commission because Dr. Funte trained in Dallas at my office, so the staff recommended that this complaint be dismissed because there was no allegation of negligence or misconduct related to the forensic analysis in the case.
Someone want to make a motion?
Also move.
Second?
Second.
Aye.
Aye.
Nay.
Can I ask a question just out of curiosity? So when a body's decomposing, you can see ethanol, right?
Yes.
Well, under some circumstances, you can see ethanol, right?
No
Doesn't
matter if
always
the
happen.
person was a drinker or not.
Yeah, it's post-mortem formation by bacteria.
Yeah. Yeah, now, if you get into certain levels, then it starts becoming more Likely, they also consumed alcohol if it gets really high, but it can get up pretty high, at least in our experience.
It deserves a good paper from someone that doesn't study systematically. I'm making a suggestion.
I think I go back to the same thing, some of us have a whole lot on our plate at one time.
Okay, let's drop down to 6, the Rio Grande identification project.
So we have some updates there. We've made quite a bit of progress. Telephone conferences between EAAF, which is the Argentine forensic anthropology group that does a lot of the reference sample collection in Latin America, and also with the University of North Texas, which is in charge of the DNA testing for the unidentified remains that are sent there. We also have talked to the FBI about the rules around the CODIS database and uploading of reference samples with the Training Center for Justices of the Peace, and we've consulted with Dr. Farley and tried to get her guidance on a bunch of things, not the least of which is revisions that can be suggested to the code regarding the entire way that medical examiners and JPs operate in terms of medical legal death investigation. And we have some progress, which is a draft memorandum of understanding between UNT Health Science Center, the commission as sort of facilitator, and the Argentine group that has like a database of a couple thousand reference samples that we all think that if those reference samples were run against UNT's local CODIS database, that there would be hits. But there's been a lot of disagreement about how to go about processing that material, including the anonymity of the people submitting the reference samples being an issue, whether or not when the report comes back from UNT, the profiles of the remains will be included to help the Argentine group provide technical advice to the families that yes, this likelihood ratio is strong enough and so forth. So we were relying really heavily on the advice of Dr. Farley and consultations with Dr. Stern. Dr. Pirwani has helped us on conference calls. We think we have a good MOU. Dr. Farley commented and raised a couple questions that we'll integrate. But we're really trying to make progress at the very least to get those reference samples that are just sitting there checked against the CODIS database that's local to UNT. The advantage of doing so, we're not going to be able to check it against the national CODIS because the FBI won't allow it because they can't verify how those reference samples were collected if they followed the protocols that the FBI has established. But because UNT does so much of the missing persons work in the country, the vast majority of what UNT has locally, it's pretty much, it's very close to what the national database is. So there are some additional profiles that are out there that won't be searched, but a whole bunch of them will be, which has not happened to date. So that's progress, I think. I don't know, Dr. Farley, did you have anything else on that? We need to do training for the Justices of the Peace. That's a huge, huge part of our issue. And it's a very complex set of legal jurisdictions and challenges and problems, but we're trying to work on it the best we can. So, did you have anything you wanted to?
The education part for the Justice of the Peace, I think most of the Justice of the Peace would really like to see more education in the death investigation part of their office. You know, there's just like one training usually when they come into office for a couple of weeks. I actually give some training at the hurricane conference every year on just this, on mass disasters and unknown bodies. But it would be really helpful for them, and I think they would all be thankful to have education. Maybe at that one time when they come for the 2 or 3 weeks and they get, education on how to run the courts to get additional information on death investigation, especially the John Doe's, on what's required. Because most of them don't even know that you're required to have a DNA sample. In the way it reads now, there's a lot of things that you may on unknowns. It doesn't actually say you have to do. And it would be helpful to have that. And I've been working on that with the code, what should be under for the JP, so he can just go to his code and say all these things have to be done.
And I think that what we learned is the problem is the later it gets in the fiscal year, the less money the counties have, the
Yes.
less likely they are to order that the body be sent for autopsy because that costs money. And that means if they send it just to be to the funeral home, there's no DNA collected from that person. So then you've lost the opportunity to compare that person's DNA against the references collected from either the consulates or from countries in Latin America.
And even investigative agencies don't realize that they should be collecting DNA on these cases. So you might have your local sheriff's office at the scene with this decomposing unknown individual, but they don't even realize they're supposed to put that individual into NamUs, that there should be some collection of DNA at the scene, and that if they're not going to order an autopsy, they don't realize that either. So some of the law enforcement don't realize that. Now, in our county, all the bodies do come. But in other counties, they may not, because it is, come this summer, there's thousands of people crossing, and hundreds of individuals die, and that's very expensive for the counties along the border. If you're paying $1,500 or $2,000 a case for each one of those cases. We've made it for our county that if the Justice Peace feels like it doesn't need an autopsy, he feels like he knows why. We have autopsy techs who are hired by the county that actually collect all the DNA, do all the pictures on the body, get the height, weight, and fill out a form that is compatible to NamUs so we can put all the information in. But over the years, they've quit doing that now. They're just sending them on for autopsy.
For autopsy. But there is I guess what you're describing is an alternative approach that could be taken for those JPs who don't or can't afford to or whatever order an autopsy that can at least get the critical information captured.
They wouldn't have a cause or manner of death. They would come up with their own cause or manner of death. In those cases, I don't get involved at all, other than to make sure everything goes into NamUs and then we send the sample to UNT. But most of the time, we are able to identify, because our individuals aren't as decomposed as some of the ones in Brooks County. They're fresh in the river, so we're able to identify ours easier. They may not be decomposed, or they still have fingerprints, and we can do fingerprint identification. But the problem with that also, which we brought up at the meeting when you were in Edinburgh, was that a lot of individuals who are picked up and detained by Border Patrol actually lie about who they are and where they're from in order to go back to Mexico. And we're finding a lot of false IDs from Mexico and even real IDs from Mexico, but they're actually from Guatemala. So they're able to buy an ID, an identification from Mexico, so they go back to Mexico and can cross again. It's so much easier to just go right on the border and cross back than to go back to Guatemala and spend a month coming back again. So when we fingerprint ID, we have to be cautious that it really is that person. And that's why we need additional information. And we ask the Mexican consulate to help us prove their identity as Mexico, and when they can't, then they go as a John Doe if we can't identify them. They do not get the name. We'll put them at AKA that name, Mexico, and then I will say why we don't believe it's that person and why we don't believe he's from Mexico. But I'm not sure this gets disseminated through the state and that everybody realizes it, because over and over, people will find that ID and go, this is him, and he'll come in with that name. No matter how bad that ID looks, or that there's extra little pictures in his pocket of him, they'll give him that name because that's the identification on that card, with a fingerprint on the back. So then they fingerprint ID to the identification card.
To the fake ID.
There's a lot of training involved with law enforcement too, just because they have an ID, it doesn't necessarily mean it's that person. We're seeing that in Arizona and California as well, with the identification cards.
Switching the topic just really quickly, on the reports that you authorize, because you have the jurisdiction over deciding ultimately whether or not a reference sample matches sufficiently. Well, I mean, I know they do the DNA at UNT and they will give you the likelihood ratio, but you make that call, right? That's your, and so do you see any problem with including the reference profiles so that the Argentines or whoever's working with the families can look and say, yeah, this is a strong enough association, or do you see issues with that whole thing?
The EAAF actually, I believe, does have DNA individuals as part of their group. You have to check with them and make sure. So they would understand and be able to read that. Where sometimes we have the consulate that just wants to read it, and they would not understand it.
But, you know, if she gets a report with the DNA, becomes part of your record.
Yes.
And autopsy reports are public records in the state. And if you consider that part of your autopsy, you release it.
But the likelihood, so on the likelihood ratios, if UNT says this is a match, or this, we believe that this is a strong enough likelihood ratio, you accept that as the call, or not always?
No, I don't. Because sometimes I'll just say like 1 in a million for Hispanic males, or, you know. Often we have more than one family member missing. So at that point, I also go back to his height, weight, any identifying scars or marks, and any dental that he may have. And then I compare the two, and if the age, you know, height, weight, he has the partial plate, the family says he has the tattoo, the family says, then I say, yes, that's consistent with. And I actually write a letter to the judge saying why I think it is this person, and this additional information from NamUs missing person databases matches our person, and that's what I do.
And then when you say that, then that begins the process of repatriating the remains to the country.
Right.
Do you have any remains that a host country refused to accept? Because I've heard that happened in a couple cases in other counties.
They don't refuse it, they don't pay for it. There are some countries that help pay for the body to go back to, like Guatemala. There are some countries that don't pay for allocating the body back to the country of origin, and the family has to come up with the funds to, you know, fly the individual back. And in some instances, they may decide to cremate, which makes it less expensive, and we'll try to work with them on getting the cremated remains back. But since there's a lot of individuals who don't believe in cremation in those countries, then it's kind of working with the consulate and the family, trying to get the best deal if they're not going to help the family to get the remains back to their country. So far, we've always been able to get them back.
But I mean more like, have they ever contested the strength of a likelihood ratio or anything like that?
Yes, I have seen that contested, and it was warranted. And in that case, another family member came forward to give a stronger likelihood ratio. And when they redid it, it was in the billions. It was a much better ratio. Because often if you use children, that might not always give you the best ratio. And they do tend to get a lot of siblings or children, and then you don't have a mother, and you just have the man's children, you know, and that's it. And sometimes there may be discrepancies. Maybe that's not the person's child. So in those instances, we try to get a brother or sister if they're still around, since we don't have the mother, and that's when the ratio.
So you just keep working on it until you feel comfortable?
We keep working on it. It could take 2 or 3 months to get someone else to come forward. We just tell the siblings we need someone else, or the children, and they'll try to find another family member who's willing to give a sample. So far, we always have been able to find another family member to give a sample.
You've not had to put any in pauper graves?
Yes, every year we have about 2 or 3. We get around 65 a year, and we're able to identify all but 2 or 3 usually. And those go marked as a John Doe in a specific area. We put that in the NamUs database of exactly where they're located. And we actually went out and saw where they're located, and it's very nicely done. They have it in their computer system. They actually have a logbook, and we have it in NamUs, so we have 3 different ways. If they're an AKA, because we had a name but we couldn't verify, they also have the AKA name with the John Doe, so that we know if anybody comes looking for that name, that this individual had that name, but maybe he was from Guatemala. He wasn't from Mexico.
And the county bears the cost for those.
Yes,
Yeah.
and that's another issue for counties, is that's very expensive, you know, to bury the individuals. There has been a change. It's not in the JP part of the code. In the JP code, it says you cannot cremate unknown remains. But in another part of the code, it says you now can cremate unknown remains. And that's a little worrisome, because if they don't take the sample now, you don't have any DNA to even, you know, get from the body. If it had been buried, you could bring out the body, get teeth, bone, and then later just do DNA and confirm. But if you cremate, there's no DNA left.
So there's a conflict in the code right now?
Yes.
So Dr. Pirwani has, if he were here, he would have very strong things to say about this particular
Yes, conflict.
subject.
You heard Stern and I both say, no, you're not allowed to cremate unknown, John Doe's unknown remains. Both of us thought that because we were reading chapter 49. But there was another chapter where it says humans are allowed to cremate unknown remains.
So if you don't take the DNA, then
That's it. So if the judge didn't order an autopsy and it just goes to a funeral home, they could actually cremate the remains.
So is this something we're going to need a legislative change on? ultimately?
we have to make legislative recommendations. I think that's the expectation. So we will be working on that.
We've
And
been
we actually have a
involved.
representation from Senator Inaposa's office here who can help us. Desiree Knudsen.
Of course, one way to always get an autopsy is just see if the state will bear the cost for an autopsy. Some states do things like that, but you know, any unidentified body, the state will pay. So.
Well, kind of like our SIDS cases, the state actually reimburses.
Right, the SIDS
reimburses
cases.
some of the expense for.
Yeah, the state pays for SIDS cases.
Oh, really?
Yes, they do about $400, I think they help reimburse for SIDS, each SIDS case. That's not a bad idea.
Yeah, and of course, you wouldn't have necessarily to do an autopsy. You could just say, it would be sent to a medical examiner's office for obtaining DNA, and, you know, make a nominal sum of a couple $100.
And that's why our county had worked out, they hired the 2 autopsy techs who now, anytime it's not ordered, they do, you know, what I said, they actually take all the clothes off, take all the pictures I would take. They
Right.
mark all the identifying marks on that individual and they upload it into NAMUS and take the appropriate samples.
That would, yeah, it won't be huge amounts of money if it's not an autopsy.
So that's one idea we can put on the list, the long list of ideas.
And that could be part of the training if there's some place who's willing to do that for a certain charge, like a medical examiner's office.
It could be.
Then at the training, they could say, here's the medical examiner's office that you can bring individuals to if you just want the DNA.
That's a good idea.
Because, I mean, in South Texas every year, and we brought this up with Stern, it is like a mass disaster. I mean, all those counties, we get so many individuals coming across.
Well, you know, we got some of them in San Antonio, too.
Houston gets some too.
I know, and even Corpus gets some.
Anything else? Thank you so much for coming and giving us the report, and we'll keep working on it.
So I think we'll go back to number 4.
Yeah, I just wanted to give a quick update on the rulemaking changes that you all have adopted at our last 2 meetings, where we just removed references to DPS. Basically, they were administrative changes, but those have now been published. The timeline has passed, and they've been published, so when you access the program, the correct references are there. And then the only other pending item was an issue that arose related to the Commission's provisional accreditation requirements. So as part of its administrative rules, the Commission allows provisional accreditation for laboratories that are seeking to add a discipline or a sub-discipline during the period which they want to add it, and then they're finally accredited by the accrediting body. And part of the Commission's requirements to obtain that provisional accreditation require an independent auditor to come into the laboratory and give the okay. And until now, the practice has been that DPS has offered to do that for free for laboratories that want to add a discipline and want to be provisionally accredited. So they'll send someone from DPS in the laboratory to conduct provisional audit, and they'll be able to submit the report from that, was to DPS, now to us, to qualify for the provisional accreditation. And then when DPS would do their own internal, they would do their own, seek their own provisional accreditation, DPS would send someone from another regional lab to the laboratory that's seeking the provisional accreditation. So really the question is whether or not that satisfies the independence requirement, or whether or not we should change the way that's been done, because the Commission now oversees this and DPS doesn't. So we did solicit feedback from our Laboratory Directors Association, and from what I understand, this doesn't occur very often. It's not something that's really significant, but it is a tool that's used sometimes.
Especially when they can't, like, say ASCLD lab is backed up or something, they can't get an assessor out timely or an auditor. At least they can do a provisional accreditation to get the casework done while they're waiting for the ASCLD lab or ANAB or whoever to come out. And I think, some people said, well, some of the lab feedback was, well, we don't even really need that provisional accreditation. We just go straight to the main edition of the discipline. But then there were others that said, well, no, it does serve, it has in the past served an important function, so don't get rid of it. But I think the general consensus, sorry Brady, was that when DPS is doing its own provisional add-on, they should get a different laboratory to come in and do the audit. Number one, it gives outside perspective. It's not that big of a deal for the labs that they would be seeking help from. It's a one-day audit, and it is for a shortened time period, but it would help meet that independence requirement. Am I misrepresenting that?
No, I think that was the fair way to represent the conversation. We have utilized that because we train people in one lab and then move them to another lab to open up a discipline. And this tool has allowed us to open those new disciplines rather than waiting for the accrediting body to come in and do a full assessment. So it's a productivity issue for us. In the past, though, we've used auditors that come from the DPS umbrella, and the discussion is that done with independence. So the suggestion is, should we be asking a local county or city laboratory to do that? That's not a problem.
Yes.
I'll just add real quick, the provisional thing also helps immensely from the laboratory's perspective of bringing those new disciplines or categories of testing online, because for ASCLD lab, you have to do mock cases. Because they actually want you to do real casework, but we can't do real casework in Texas because we're not accredited, so it's a chicken and the egg thing.
Yeah.
So we had to do it on mock cases, which then becomes a sticking point with the assessors. Well, you haven't actually shown it on real casework. So by having that provisional, it allows us to really streamline it, be able to provide casework that then the accredited body can look at actual work rather than mock cases.
So do we have assessors in Texas that would be willing, from the county and city labs, that would be willing to go into DPS for free, just like DPS?
When we had our meeting on the 22nd, the discussion was, is there's a consensus that we don't mind helping each other out. The only concern was, and we do that now, we go to DNA audits and different things for each other when we need to, but the concern was is if we do this and it's a traveling type thing, our agencies may not necessarily want to fund that. I mean, if I'm going across the street to DPS and help Brady, that I can get that done. But if it's if there's travel and lodging and stuff involved, I think the local labs are a little more concerned about being able to fund that.
Maybe since it doesn't happen very often, the commission could find a
We
place
might be
for
able to
that.
help, or we could, the lab that is requesting the assistance, I would think it would be worth it to them to pay the travel, especially since they don't have to pay for time, as long as the offering lab is willing to give the time. And then,
We also talked about putting a list of assessors together, so everybody
Yes.
kind of knows who has what resource. And it's a matter of, if they're on that approved list, then you might be able to find an assessor that's in the same town or in town over.
I did think of one other thing though. What about, there's so many laboratories that are out of state. Are we going to offer that same free service to them?
Probably not.
Treat them the same way that everybody else?
Well, I think they're just gonna have to meet the requirement however they can meet it. And
Well, they wouldn't be, those other states, they could still do the casework without being accredited in their state. They just couldn't do it for Texas.
Right.
Whereas people in Texas, we're stuck because we can't do the work without accreditation to admission into court. So those other states, they already have sort of a safety valve. They could do it for their locality, unaccredited, up until their accrediting body comes back on site.
so hopefully they'll be in better, well, it depends on the laws of their state, I guess, but I think because it happens fairly infrequently, I think we'll be okay. And, if it gets to be, if the travel costs get to be a burden, we can work on that. I think the commission did invest quite a bit of money in paying for assessor training for a whole mess of people last year, so we should have a good list, I think, at this point. So we'll just keep working on it, and if the travel stuff becomes an issue, like if the host agency can't pay and the offering agency can't pay, we'll figure something out.
Maybe if you want to drill way down into it, the commission or whatever part of the commission deals with it, the laboratory money, that assessment, y'all could tell them, suggest, provide an assessor to add to that independence, where the laboratory is not going to another laboratory and saying, can you come do this for us? The laboratory would go to the commission say, let us look at our list.
Yeah.
Contact someone on the list, can you do this? And then our accrediting body does the same thing, and then you say to the laboratory, is this person acceptable? Do you have any conflicts of interest? So that way the commission is actually the one providing the assessor. You're not just reaching out to the lab rec next door.
Or the person that you worked with for 20 years before you came to this new lab.
Just would add another
Yeah,
level
that's a
of
good idea.
independence and
Okay, we will work on that, Tim, that's a good idea.
Thank you, guys.
Right, so I don't think the rules need to change in light of that.
We'll just leave it as
We'll just
is.
leave it as is.
Okay, let's go on to number 5. Dr. Mosai.
So Dr. Mosiani had to leave, but we have a new chair of our licensing advisory committee. Do you want to give a little report of what we did yesterday, Greg, or?
I came there briefly.
Just, it was our inaugural meeting of the licensing advisory committee, and I think that we made a lot of progress, but there's a lot to work on.
There is a lot to work on, but we got a good start yesterday morning. What we've done so far is we've just kind of tried to focus on the big picture issues and keep going. Sorry. And discussed that we would, there's going to be some special cases that we have to look at downstream, but right now we're trying to look at baseline education requirements. We formed a subcommittee for that within our subcommittee, I guess. Then we formed a subcommittee to look at the legal issues.
The legislative recommendations.
Yes, make legislative recommendations for any unclarity in the law, where we have questions about what does this really mean. We also had a subcommittee on continuing education,
Ethics.
and I can't remember the third one.
The exam component of the requirement.
Yes. We've discussed bringing several of the agencies that already offer licensing to certification to the next meeting so that we can talk to them, see what they have to offer, express our concerns on what their current operations are that may not meet our needs, and let them know this is what we would really need to work for the Texas legislation. They may be somewhat flexible in being able to provide that. So right now what we're trying to do is establish a baseline. This is what's available to us, this is what our resources are, how do we comply with the law without reinventing the wheel more than we need to.
So we'll have more to report next time.
Yes.
And Greg has a co-chair, which is Inger.
Yes, that's correct. Thank you, I think.
Let's go on to number 7, update the Texas Association of Private Medical Practice.
All right, I'll make this quick. We had our meeting on January 22nd up at Tarrant County. We had elections. If y'all are unaware, I'm sure y'all are, because she had to resign from the licensing committee, but Linda Johnson retired, and so she dropped her membership with our association and also dropped as our secretary. So we had to have elections this last time. Sue Howe, Dr. Howe with Tarrant County Laboratory is our new secretary, and Roger Kahn with Harris County is our new president. So he'll be giving these updates from now on. Our meeting consisted mostly of talking about how the selection process went for the licensing advisory committee and the membership that we put forward. We also had some discussions with Lynn about the provisional provisional accreditation stuff that we just talked about. I think that was about it as far as what it was mostly focused on the election this last meeting. I do want to thank the commission for the support over the last 2 years. I think we've done a lot of good things over the last 2 years, and I'm looking forward to what Roger takes us to the next 2 years. Spent a lot of time at the Capitol with Lynn and Nick and Brady and Tim, and we got a lot of great things accomplished this last year. So appreciate the partnership we've had.
Thank you for your leadership, Bill, and service.
Number 8 is Mr. Alford.
So, the commission gave me permission to start looking at working on this project. It all rose out of a case presented to the commission that questions and testimony regarding retrograde extrapolation. I believe that as science goes, there's probably more of this type of science going into courtrooms than any other type of science because it's involved in misdemeanor cases. The two scientists that I've been working with on this are Robert Johnson and Chris Hartzell, both with the Tarrant County ME's office. What I asked them to do was help me create an understandable written document that talks about retrograde extrapolation. They went much further than that and actually created and put on a 2-day school regarding retrograde extrapolation for the Fort Worth Crime Lab. One of the issues that they brought to my attention, and I'm kind of curious if this is a problem throughout the state, is that there are every lab analyst that does the actual testing, sometimes there's a limited number of people that are qualified and trained to do retrograde extrapolation. And so their purpose in doing this 2-day training for Fort Worth, and they shared the materials with me, a very extensive description of the science, including some actual testing involved, made me wonder whether the ultimate thing that the commission thinks that we need is just a written document, or whether or not we want to be involved in helping facilitate training to increase the number of people that are qualified to do this type of interpretation. So, obviously, from a numbers standpoint, how does it work with DPS? I mean, is that...
This was kind of our case. We brought this to light last meeting.
Would you mind, I'm sorry.
Yeah, I'm sorry. This was our case that kind of brought this situation to light at the last commission meeting. So what we did as part of our corrective action is we brought all of our blood alcohol chemists and our toxicologist here in Austin to Austin for a 1.5-day meeting. And it was kind of a statewide meeting for that particular discipline, but then we did focus some training on this particular topic. So we are trying to ensure that everybody that's doing the testing has all the tools to be able to testify as part of that testing. A 2-day school is very beneficial, and that could help us kind of move that process forward. So we've started a process, but there's always room to improve on that.
So am I correct that I'm correct that all the people that are trained to do the analysis don't necessarily have the training to do the retrograde extrapolation?
Well, it was covered during their training, but then it depends on how often they interact with that in court. And so retraining is what we're talking about, which is needed. So part of that statewide meeting helped that, but if you have a program that we can put on for the labs across the state, that would be beneficial.
Okay.
Do you guys do retrograde extrapolation? Oh, you don't do blood? Do you do blood alcohol? You don't do blood alcohol. What about Bill? Do you guys do retrograde extrapolation?
I'm not really sure.
Maybe, because you do blood alcohol.
Yeah, we do blood alcohol.
Okay. So I guess what I'm looking for is just from some guidance about what this project ends up being. Is it strictly a written explanatory document, or do we benefit more by being a part of some training that would actually create more qualified people to give accurate testimony as relates to retrograde extrapolation?
I think you always benefit when you do extra training and expand the number of people that have a formalized bit of information.
We should do both.
Okay. So
A resource paper and training.
Okay. And so when the commission would be able to provide funds to help people attend, go to the place where the training is being done, perhaps?
Well, we can
How extensive training would it be?
Well, I think it's stated, I mean, part of it, from looking, and I didn't make the copies, but I can make sure I share the PowerPoints. The training as it exists starts with, I mean, it goes from just an understanding of alcohol in general, and all the way through to science, and contains different, and covers all different aspects of retrograde extrapolation, and other types of extrapolation, other types of opinion that can be given, such as how many drinks for this particular person would have to consume over this period of time to reach this level. And then they actually, I think, that, to me, looking at the training they did, the most beneficial part are the actual hands-on examples, where they created case problems where they had to go through and just confirm and make them comfortable taking that science. So it, again, in Tarrant County, we've generally gone to the, directors of the labs. I mean, we don't usually get that another witness for that type of testimony.
Why don't we see what Chris and Robert Johnson recommend on training, and then we'll see if we can get the budget together to support it.
Okay.
You may have more than
And I
just
can
those
actually
two.
share, if you want to look at this, but PowerPoints have done, I can share that.
Thank you.
Okay.
We probably have some people in our office that could help out in terms of participating, but, so it's not just two people, so that.
Oh, absolutely. And I think that's the other goal, is to make it, it'd be great if it could be done at the local level.
So like a train the trainers kind of.
Yeah, I think that would be, exactly. I think that's the whole idea, is to get people to the level where they're comfortable, and then they pay it forward to other people in their laboratory.
We could probably fund that. When I was thinking like, okay, every blood alcohol analyst in the state at one night
No.
hotel,
No,
and I'm thinking to myself,
No,
well, then we basically can't buy papers.
No, that's not what I viewed. Plus, that would shut down the labs, and we're not going to do that.
Yeah, so we'll talk to them about the best strategic way of communicating.
Maybe have a conference call that?
Yes.
Okay. That's what I got.
Okay.
We should probably do bite marks next, because we have, for example, Dr. Wright's traveling from out of state. We don't want to keep him. So it is, I don't know what my watch is.
When our lunch is here?
Yeah, it's 11:53, so we could break just for until 12:15 and then pick it up with bike marks.
That's fine, yeah. I just wouldn't want to stop.
And your lunches are in the.
Break 15 minutes.
12:15, we'll start back up with bite marks.
Is that fine with you?
So I'm going to use my. And can everybody hear me okay? Okay. So this presentation is on number 12 on your agenda, and we're going to go through the same talk that I gave yesterday to the Bite Mark Subcommittee, and then I've made some changes to the PowerPoint based on deliberations yesterday and the recommendations that the committee came up with in the end. So, but for the benefit of the commissioners who were not there yesterday, we're going to go through the talk again from the start. Okay, so two kind of key issues from the outset for you. Before we even get into the substantive discussion on bite mark analysis, we want to talk about the commission's jurisdiction, which I often bring back to your attention when we start investigating these cases. And the commission now has significantly more jurisdiction than it did before September of 2015. But you will recall that even before the new legislation, the commission had a certain bifurcated investigative jurisdiction. And by that I mean, depending on whether the forensic discipline is subject to accreditation under Texas law, that dictates the type of investigation the commission can do when it receives a complaint from a member of the public. And so for cases involving accredited disciplines, the commission does a full professional negligence or misconduct allegation investigation. And as some of you know, but it's kind of an interesting point to come back to, is that is actually the requirement of the Paul Coverdell federal program in order for states to collect backlog reduction money. So the commission is the Coverdell entity for the state of Texas. But then in cases involving unaccredited disciplines, the commission has less broad jurisdiction, and it's limited to observations regarding the integrity and reliability of the forensic analysis, best practices, and other recommendations that are relevant as determined by the commission. So these are all things that the commission can do in investigating an unaccredited discipline. Keeping in mind that we do not have any jurisdiction whatsoever over forensic autopsies. That's the one area that there is that we are expressly prohibited from dealing with. So when we started this investigation, we needed to really ask, what is bite mark analysis status, or for that matter, forensic odontology under Texas law? And what the legislature did when it was deciding back in 2003 to incorporate accreditation as a requirement for forensic science, the hook, or the way that it enforced that requirement was through the admission of evidence in criminal cases. So specifically, what the law says is that a forensic analysis of physical evidence and expert testimony relating to the evidence are not admissible in a criminal action if at the time of the analysis, the crime laboratory conducting the analysis was not accredited by the commission under this article. And before that said, the commission had said DPS, because as you recall, DPS had this authority till very recently. So then the question becomes, well, what do they mean by forensic analysis, and what do they mean by crime laboratory? So forensic analysis is defined quite broadly. It means a medical, chemical, toxicologic, ballistic, or other expert examination or test performed on physical evidence, including DNA evidence, for the purposes of determining the connection of the evidence to a criminal action, except that the term does not include the portion of the autopsy conducted by an ME or other forensic pathologist who's a licensed physician. And the term crime laboratory is defined quite broadly too. It includes a public or private lab or other entity that conducts a forensic analysis. So that's kind of this circular discussion. And just in terms of the accreditation jurisdiction of the commission, as you know, what the commission did, and the commission has made no affirmative accreditation decisions about disciplines since the jurisdiction was shifted to the commission. We basically took all of the rules that DPS had and all of the exemptions that they had and incorporated them into the commission's rules. So DPS granted exemptions to a number of forensic disciplines, but forensic odontology is not among them. Whether bite mark analysis or other types of forensic odontology, such as human IDs and age estimations and things like that. So forensic odontology is kind of in I guess what I would call a limbo state, in the sense that it's not expressly exempt. But the commission, by rule, may exempt disciplines under certain circumstances. And you can see the circumstances are where independent accreditation is unavailable or inappropriate. It's admissible under well-established rules of evidence or a statute, and the analysis is routinely conducted outside of a crime lab. So there are grounds for exemption. So Texas courts, the way that I understand the statute reads, and I consulted with some other attorneys in the judicial branch of government, is that courts should not be admitting forensic analysis unless the analysis is accredited or exempt by statute or DPS rule. So the most prudent court, so that means that if you're not expressly accredited and you're not exempt, the evidence does not come into courts in criminal cases. But I do think, as with everything I tell you, that the most prudent course in the legal interpretation would be to confirm that reading with the Attorney General. So and also, as I said, the commission has authority to grant exemption for sub-disciplines of forensic odontology, which you could do very quickly, especially for those that are uncontroversial, and critical to things like mass disasters, such as human ID and age estimation. But returning again to the principal point, even before September, and even before the commission had accreditation authority, and even before asking the AG for an opinion, the commission can still always issue a recommendation to the criminal justice system regarding the integrity and reliability of the analysis pursuant to that part of its jurisdiction. So the rest of this discussion focuses on the research and science in response to the complaint that is in front of you. Does anyone have questions about the jurisdictional issues? So the bite mark panel, which is chaired by Dr. Kessler, held meetings in Dallas and then another one in Fort Worth in the DA's offices of both counties in September and November of 2015, and heard from various members of the ABFO and others within the forensic odontology community. And there was a real focus. What Dr. Kessler tried to keep the focus on was, okay, what is the status of the research? What has been done in the discipline? And what can we learn from that? What observations can we make? And where do we go from here? So there were two key questions when we talk about the state of the research. And one is, so there are two, I guess, premises that the analysis is based on, and these are the areas that the research generally concentrates around. So one is the uniqueness of the human dentition, which I think the community is coming to find is less important in the analysis than the ability of human skin to record bite marks with sufficient fidelity to allow subsequent analysis. So Dr. Kessler asked for research, and many other stakeholders submitted various lists of papers and research results. I want to say very explicitly at this point that the community has come to the conclusion, I think the commission agrees, and will put this front and center in the report that it issues, that statements of individual identification and assignments of probability and statistical weight are scientifically insupportable at this point. So things like, that bite belonged to Richard Alpert, or there's a 1 in a million chance that that bite came from someone other than Vincent DeMaio. These are unsupportable statements. And just to refresh everyone's recollection, that's not just true in this discipline, but it's the same thing we look for when we're reviewing hair microscopy cases as well, those types of statements. I think one of the things that the panel really struggled with is the fact that despite the fact that everyone recognizes that you can't do individual identification and you shouldn't be assigning probability or statistical weight, this is the decision tree that is on the ABFO's website right now. Now, the reason for that is not because there aren't many responsible forensic odontologists who recognize that this is not where they need to be, but because the way the organization is structured, they can only make changes to their materials periodically in conjunction with certain meetings that they have and in compliance with their bylaws. And I think this contrasts, and certainly for the committee members, contrasts quite starkly with what happens in other forensic disciplines when there's a recognition of something certainly significant with respect to the ID criteria, but pretty much anything that's done in forensic science, when there's a recognition that there's some fundamental issue or flaw, it's corrected, immediately. So that was one of the things that caused concern on the panel. So I'm going to run through some existing research highlights. You have all of this in your material. I'm probably not going to say it as well as a forensic odontologist would, but I'm going to do my best to just tell you. I'm presenting these as studies that were in all of the material we received I'm not saying any of them are good, bad, or indifferent. I'm just saying this is what we were given in terms of the analysis that's out there. So an early study was 1975 by Whitaker, and it compared bites in pigskin and wax, and not surprisingly found that pigskin is less reliable than wax. I think, from what I understand, one of the main points of this study was to analyze the effect that time has on someone's ability to make a correct association or attribution. And what they saw was, you know, the sooner to the bite, the better the results were in terms of being able to make a correct attribution. Now you'll see throughout these studies that there are two very common types of studies that are done. Porcine skin, so pig skin, and cadavers, in large part because biting humans with sufficient force to allow study is problematic. Though they are trying to do that at the University of Texas, San Antonio, but I'm not sure that, and in a lot of these studies, they did the best they could with the material that's available. So here's another one, a subsequent follow-up by Whitaker assessing the ability of forensic dentists to determine a child bite from an adult bite. So we see in a lot of these cases, they're very brutal child abuse cases. And so the question was whether you could distinguish between a child and adult bite, and you see what the simplistic interpretation of how the dentist scored on that. And then in 2001, we have a study from Dr. Pretty and Earhart, I'm not sure if I'm saying that right, but the authors noted that that study was not a formal research project, and it did suggest some agreement at the highest, where the evidence quality was the highest. And that is actually a concept that's repeated in the most recent study that the commission had the opportunity to look at. Oops. In 2007, there was Kaiser who looked at the uniqueness of human dentition, and the study showed that there was a difference in anterior dental arcade in shape and form, and that when individuals with similar arcade shape were superimposed, differences in tooth orientation were still evident. It was a small sample size, so I think that would be one that needed follow-up from what I understand from the commentary to the study. And then there's a series of Bush studies. Mostly they do work on cadavers, and Mr. Peter Bush presented to the panel at the last meeting. And in this particular study, of the 23 bites that were made, none were measurably identical. In some cases, there was just dramatic distortion noted. So one of the challenges with bites on human skin is distortion and the effects. So that looked at that issue. Similarly, they did another study in 2009, and this was looking at the uniqueness of human dentition and whether the attributes can be accurately transferred to skin. And 100 models were divided into 10 groups of 10 based on similarities of patterns, and what they concluded was that they had difficulty distinguishing the biter from individuals with similarly aligned dentitions. And then in some cases, an incorrect biter seemed like a better match than the actual biter because of the distortion. And then here's another study where they analyzed 66 bites, and they found that some arches with missing teeth left marks that had no spaces, while full arches with crooked teeth left some straight marks. Arches without crooked teeth left marks which indicated a tooth might be crooked. So what they're saying is because of the tension in skin, and I think the pathologist here could describe this much better than I can, there are serious concerns about replication of the marks and the uniformity once you take into account the Langer lines? So 38% of the marks created misleading patterns was the conclusion of the study. And then in 2010, there's a study by Avon using a porcine model where they produced 18 full bite mark cases where they had ground truth. And the results showed an error rate of 35.3%, though the author distinguished a critical error rate where an innocent party was chosen at 6%. And these were, according to the author, bite marks of high forensic value compared to what you would see in ordinary casework. And then we come to the study that really, I think, got us here in this room, which is the 2014 Pretty Freeman study at the Academy meeting in Seattle. And the panel, I'm not going to go into it at length here, but there were real discussions and concerns about why this data wasn't published sooner. And the bottom line is that Drs. Pretty and Freeman are, well, Dr. Pretty is not a member of the ABFO, he's from the UK. But he is an active forensic odontologist who does bite mark cases. Dr. Freeman is the president-elect of the ABFO and a practicing forensic odontologist. And they teamed up to do a survey of diplomates. 100 cases were selected to represent a wide spread of anatomical location. These were cases that diplomates themselves turned in to be reviewed. And what they were trying to do was to find out inter-examiner reliability. So was there sufficient evidence to render an opinion on whether the injury was a bite mark? And then using the decision tree as a guide, was it a human bite mark? And then did it have distinct identifiable arches and individual tooth marks? So they weren't asking the question of, did the dentist get the answer right? They were asking the question of, are they consistently concluding the same things when measuring the criteria that's against the criteria that's in front of them? So 38 diplomates participated in the study completely, and 44 did partial responses. And there was a significant spread of decisions. They were unanimous in only 4 of 100 cases. And in 8 of the cases, 90% or more of the analysts agreed. And they did observe, again, that agreement was highest in cases where the quality of the evidence was highest. So if you look here on this, and this is divided up actually in between 2 slides, but what this shows is the various cases that were looked at and the breakdown of responses among the diplomates who answered and participated in this study. So green would indicate that the conclusion was it is a human bite mark, yellow would indicate that it was suggestive of a bite mark, and red would say it's not a bite mark. So this is where they all came down in these cases in terms of their answers. And then this is another example of that. So you can see in the cases where agreement is high is usually this is not a bite mark, so they could clearly tell that that's not what this mark was. But these 2 slides sort of show the discrepancies and conclusions that have gotten us here. So at the meeting, Dr. Pretty flew over from the UK, and Dr. Freeman was there as well, and they presented this data to the panel. And then at the end of the meeting, I think there was some optimism that a number of the group would go back and do a follow-up assessment based on the cases where they did see high levels of agreement and focusing on trying to define criteria or a narrow definition of how to identify a human bite mark so that they could measure that, understanding that they would have some false negatives, and then from there, sort of as you would do with any validation study in DNA or any other discipline, expand the definitions until to test your thresholds and to test, how far you can go to both maximize reliability among your examiners, and so inter-examiner consistency and minimizing false negatives that everyone agreed should have been included, but were excluded because the definition is too restrictive. So that effort was suspended after a letter from Dr. Sen, who was a member of the team that was going to do this, where he raised some concerns about IVR approval and, this issue about the false negatives. And so when the group, they didn't have any more research to report to us as a result of the last meeting, and I think there was some hope that there would have been some. And so in light of that, the panel was kind of left with, okay, so what do we recommend in terms of next steps and research, and what to do with the admission of this evidence in criminal cases in the meantime? So first, the panel recommends clear criteria and guidelines be established for identifying when a pattern injury constitutes a human bite mark on skin, and that needs to be tested to demonstrate sufficient inter-examiner reliability and validity when the criteria are applied. And I think that is what they were trying to get to after the last meeting, but they haven't been able to yet. And second, to address the concerns about child abuse cases, oftentimes an investigator will ask, well, was this injury inflicted because this child's being abused in the home, or was it the bite of a sibling or someone at daycare or something like that? So trying to be able to distinguish between an adult and a child bite mark and validating those criteria as well was perceived as if they can do the first project, then moving to the second project would be a priority area. And then finally, the revised decision tree, and this is an ABFO decision tree. There's also one at the OSAC level that's similar. But if you look at the third row there, two options that they're offering are dentition can be excluded or cannot be excluded as having made the bite mark. And I think that the agreement on the panel was that would be the next step after having completed those first two research projects and validation studies. So on exclusion, the reason why we didn't just put it straight up there as a recommendation is because you can't get to that until you get through the first one at the very least. And also, some commissioners, in particular Dr. Pirwani, who's ill today but has expressed real concern about exclusion constituting kind of a de facto inclusion for anybody who didn't make the exclusion list. And then this point below is really important, which is that the research should be conducted by the community. I don't think it's fair to expect that the ABFO is going to be able to, or appropriate really, to insist that the ABFO must do the research itself. The research should be done by academics and supported by the ABFO. So similar to what the fire marshal was talking about this morning, about the benefits of doing an academic, private, and public partnership, that you are able to learn a lot from that process. And then there were some additional panel recommendations regarding just basic quality assurance issues, like proficiency testing, that the discipline needs to have proficiency testing that's rigorous, meaningful, and appropriately validated. And we heard from Dr. Wright, who's here, who said that although they have a lot of the structure to be able to do that, the thing they don't have is the criteria against which to proficiency test. And that they can't really move forward on the proficiency testing, though he's been chairing a committee for the last 6 years and advocating for this, I'm told by Dr. Freeman, for the last 20 plus years, that can't move forward unless you have the criteria against which to proficiency test. And then finally, the panel thought it was important to set up a collaborative plan for doing a retroactive review of casework and implementing the duty to correct and notify key stakeholders where there are statements that exceed the limits of science. And that's something we've done in other disciplines and generally has been a positive experience. And Dr. Sen yesterday gave a presentation where he offered the assistance of the practicing odontologists in Texas to help with that review and to help gather cases separate and apart from what you can learn from Lexis and Westlaw searches. And then I just put these here because I think they will be important. If the panel I think thought that these two recommendations are premature at this stage, but that if the research is established, then you would need to see a system for peer and technical review of cases with a method for resolving discordance and expressing the same to triers of fact in a written report, and also development of model report language that informs a trier of fact of appropriate conclusions and expresses the limitations of the analysis. And these are all concepts really carried over from the quality systems that exist in accreditation settings that we know are there. So, I don't know why. Okay. So the conclusions from the panel are, number one, to express to the ABFO the observations and recommendations made if the commission agrees that these are appropriate. So I would suggest we do that immediately so that they can talk about it at the February meeting in 2 weeks' time, I think. And then at the same time, I think we should get an AG opinion regarding the current state of the admissibility of this evidence, considering that it is not expressly exempt or covered. So we need to figure that interpretation out and make sure that I'm not missing anything in the reading of the statute. And also, if the AG believes that the evidence is currently inadmissible, then what the commission faces is a decision about whether to exempt the discipline, as DPS has done for other disciplines in the past. And it seems to me that human IDs and age estimation could be exempted pretty readily and quickly, and that bite mark analysis should be held off until the research and quality recommendations are addressed. And even if the AG believes that it is admissible despite the statutory scheme, the commission can still recommend to the community that the evidence not be admitted until these foundational research issues are addressed and until the recommendations regarding basic things like proficiency testing and so forth are addressed by the ABFO. So is that a fair summation?
I think that's an excellent summation. I think all the members of the subcommittee believe that there is a potential for bite mark analysis to have a place in the legal system. But the volume of research to date would kind of tend to negate that, and that's why we believe they need to do some research to try to validate the science behind it. We've learned, I think, in our investigations that, as Lynn has quite ably already mentioned, that having some criteria for being able to recognize what is and what is not a bite mark is critical to the issue, and that the quality of the evidence is perhaps even more critical after that. And yet, kind of being a devil's advocate here, research in order to validate that is going to be difficult, because we've learned that the best quality evidence usually is going to be situations where there's laceration, minor laceration of the tissues, and yet you can't do that under IRB approval. So it makes the job of trying to validate what is high quality, what is not high quality, a little bit more difficult. The last thing, and the thing I think that we all kind of concluded was, and I think everybody is in agreement too, bite mark analysis is a pattern matching kind of situation. And all of the other pattern matching disciplines do have proficiency testing associated with it. And so that was the reason why the panel thought having some requirement to develop some type of proficiency testing was important here. So we're not saying, I guess, that we won't necessarily allow it, but that we need more information. And so we would ask that that research be done before a final determination is made.
Any more comments?
Bobby? Dr. Bernard?
No, I mean, I think that given the option of a suspicious area, taking swabs for DNA and getting a positive result there is certainly going to be a lot more helpful than trying to do a pattern match with the state the way it is now. So, but for medical examiners, if you suspect it, you better try and work it up. Doing it later is not going to be very helpful.
Yeah, and Dr. Sen did very ably communicate that, there are perfect circumstances and there are not perfect circumstances in the situation where you have bite marks available, and that the majority of the time, the evidence is not going to be of sufficient quality with the bite mark alone to have any value in the case. So, again, being able to isolate those cases, that he suggested 10 to 15% was a good percent that might be usable. Being able to isolate that 10 to 15%, identify it as potentially usable would be okay. But I think we all kind of agree that if the only evidence in a case is the bite mark evidence, and the fact that pretty much everybody agrees that you can't specifically link that to a specific individual, that case would certainly not want to go forward in the court.
Dr. Wright?
Yes, I first of all want to thank the committee. I had the opportunity to visit with them and present to them information 2 different times, and I admire and appreciate the diligence and the detail that you all went in. I think your findings accurately reflect a lot of the areas. I have some concerns about stopping the use of the bite mark evidence in the legal system, especially as it relates to child abuse cases. In my practice in forensic dentistry, I consult with Cincinnati Children's Hospital, with the Cincinnati Children's Hospital Mayerson Center for Health and Safety of Children, with Nationwide Children's Hospital in Columbus and Dayton Children's Hospital and all over. And oftentimes the issue that I'm faced with is not so much biter identification, but an intervention to get the child out of an abusive episode or an abusive environment. And it can be something as simple as a delineation between an adult and a child bite mark. And admittedly, there are some cases where you can't tell the difference, but many, many times it's very easy to tell the difference between child and adult bites. And I think if the commission moves forward and adopts these recommendations, I do have some concerns about the ability of the forensic dentist or dentist in general to protect the health and safety of children based not on an issue of a criminal matter with an abuser, but rather the ability of the legal system to provide safe environment for children based on getting them out of an abusive environment. So yeah.
We don't have jurisdiction over anything but criminal trials.
Okay.
So that is all outside of our purview.
Well, I certainly hope that it's not misinterpreted outside of this purview, that it's not an avenue that should be pursued. I think that would cause me great concern. I spend so much time looking at these abused children. As far as the other recommendations, I appreciate the opportunity that you've extended to the ABFO and our compatriots in the community to go back and provide this foundational research for you. I can give you my assurance I will do everything I can to get this moving forward as best I can. We have a meeting a week from Monday, and we're going to go armed and dangerous and see what we can get done. So, thank you.
Just as a comment to that, as much as I would like to say that it wouldn't be utilized to challenge something not related to the criminal prosecution, I suspect it will be. So I think your concerns probably have merit to them, even though it's not us.
Right, exactly.
Thank you. I also want to express my appreciation to the Commission for a very thoughtful and thorough analysis of the situation, I believe. We accept the criticisms as valid, and it's hard not to. What we hope for is to avoid unintended consequences of actions that are taken that would affect other areas of forensic odontology, including bite mark analysis, which I personally think is a valid technique if it's done properly, and the problem is that it has not always been done properly. If I may, I would like to ask Dr. Farley to come up and just give us the benefit of her experience with a bite mark case, just to give you some perspective about how we think it's appropriately used. Would that be permissible?
Of course.
Hi, I'm Dr. Norma Jean Farley. And actually, it was already covered here. I usually use it in differentiating between an adult and a child. And on some of our homicide cases on children, obviously there's bite marks on them, and usually they say that it was one of the children in the home. So when I've used a forensic dentist in the past, it's been to differentiate the children in the home from the adults, and they're usually able to do that, you know, just by canine width. And usually the children that I'm talking about are 2 to 4 years old. They're not, you know, older children. And in those cases, it's been helpful for me to show that this is just more abuse. It's, you know, the child is now dead, but there's other abuse on the body, bite marks that look like human adult bite marks. I don't usually go past that to say it's a person, a specific person. Like was already said, a lot of times it's a faint bite mark. You can see some of the teeth, but not all of the teeth. And we were using Dr. Cano, and I've used Dr. Sen before as the second. We always get 2 people involved usually on this. So we have a local person. That person will then have either Dr. Sen or another person look at it and confirm it. But in our cases, it's actually helped in ones where we find no cause of death, and it's like a 2-year-old, and they're looking at it as SIDS, and there's these bite marks on the body. It helps us to show, no, this was an adult that bit this child. It's not one of the children that bit the child, so this is prior abuse to that child. And in those cases, in one of my cases, I got a confession from it just because of the bite marks.
Any comments more from the public or from the commission?
Well, I do. There have been some arguments that we've heard before that you can't say that there is a bite mark. And certainly there's some times when they're very vague, and you can say maybe it was, maybe it wasn't. But there have been homicide cases that there's no question in my mind that that was a bite mark. Now, tool mark and identifying who did it is a whole different ballgame, but there are certainly cases, just like there are cases that you have a dog bite and we're able to say that's a dog bite. You know that there are circumstances where you can at least be confident that that is present, but again, the matching who it goes to is something we wouldn't have done anyway.
I think the ABFO and the community is, you know, they gotta have criteria for making that assessment.
Yeah, I was going to say the same thing. If they could establish criteria and could point to this bite mark had these criteria associated with it, there would be more confidence that it really was a bite mark. And then the other thing is the peer review, the blind peer review. And the subcommittee did talk about that and emphasize that having blind peer review and, if possible, multiple blind peer reviews would increase the validity of the analysis.
Yeah. We would never make a cause of death based just on what we think might be a bite mark anyway. Right. But, you know, that's why if you're worried about it, you better be swabbing it.
Well, and again, it's already been said, I mean, the problem ultimately is the lack of criteria. The problem is that as science now stands, the best that can be said is there are some experts that think they have the ability in the right cases to do this. And the trouble with that being the standard is, and we focused on its use to prove someone's guilt, but we have to be sensitive to the fact that an expert on the defense side could use the lack of standards to try to convince a jury that it couldn't be their client. And the difficulty in challenging that testimony would be the same, that there is no criteria, there's no standardization. And that's why I believe that there's a need for these standards to be created. And until they're created, that we have to be, you know, make the point that it shouldn't be brought into court until those standards are done.
And I think that's also why we kind of selected the things, because the first issue is the most important. And if that can be proved, then you can move on to the others.
And I just remember Dr. Pretty standing in front of the data and saying, I mean, I have to listen to him very closely because he talks really fast, but what he was saying was, we should be worried about this as a community. We should be concerned about the fact that people are all over the place in their answers. We got to be able to establish the criteria, validate the criteria, and keep. There's no perfect study, but the work can be done if people work collaboratively to do it, I think.
Well, nothing else. Well, I'd like to make a motion that we adopt the conclusions.
You shouldn't make the motion as per.
Oh, that's right. I keep getting that. Okay. Someone will make the motion.
I'll make the motion that we adopt the conclusions.
Second?
Second.
Aye.
Aye.
Nay? Update from the hair or microscopy balance.
Nick has a PowerPoint. Do you want me to help you get that set up?
While Nick's doing that, because I harken back to what Dr. Wright said, is it possible for us, when we issue this recommendation, that we emphasize criminal?
Yes, absolutely. We will make that very clear.
Good, okay.
So people can see. All right, is my mic working?
Is it on?
Now it is. All right, is it working?
Yes.
Okay. All right, so we've got, let's get into this real quick. So, since the last meeting, we've had an opportunity to have another hair review team meeting. We met about a month ago. We've also started since then having cases come back from our partnership with Latham and Watkins. If you remember at the last meeting, we discussed how we would get the records, get it all put into a Dropbox form, send it to them so they could do checklist phase 2, where their job is to review the testimony, answer the very specific questions that we're doing on this review. These are the results from the 10 first cases that we sent to them. It's technically 12 because 2 of those were co-defendants who were jointly tried. So we've got 5 of these where the hair review team has made a recommendation for a notification, 5 of which where they haven't. In the slide study, I'm only going to go through the 5 where we're making a notification recommendation to save us some time. But should you want to see the other cases and the testimony in those, I can make that available to you very quickly. So the first case we're going to look at, State of Texas versus David Lee Cook. It's a Harris County case, 1986 murder, voluntary manslaughter. Both of the defendants, it's David Cook and Sandra Henry. They're both convicted and sentenced to life. Neither one are currently incarcerated. I don't know if that's because they've made parole or if that's because they're deceased. I do not have that information. It's Raiden Hillman was our analyst. She is a recurring name because she did a lot of the cases that we have seen. So the hair was the victim's hair on the clothes of the defendant and the suspect's hair on the victim's leg. So remember our review questions. Did the reporter testimony contain a statement of identification? Number 2, did the reporter testimony assign a probability or statistical weight? Number 3, did the reporter testimony contain any other potentially misleading statements or inferences? On this case, let's see, hair review team answered question 2 affirmatively. We had a probability offered in this one. Is it then likely that one of the hairs from the victim's body is from the same origin as the hairs obtained from Ms. Henry? Yes, it is. When later discussing it, is there then a probability that the hairs in the envelope from the same source? There is. On direct, there was not a value given to this probability. It was just talked in terms of it's likely. Defense counsel on cross tried to clear this up and get a number out of the analyst. And when asked, he said, I would think that would mean greater than 50%. Yes, I would say that. So the hair review team, when seeing that, said, okay, we've got a probability, we have a problem with that. That was the main issue in this case, and it's also a theme with all of the cases that we see here today. A limited amount of discussion of the limitations of the testimony, of the limits of the science. That's one of the big problems we're seeing, is that you may have some wishy-washy language that we don't really like. It may not be obvious error, but without a proper discussion of the limits of the science, it really creates a situation where you could have, the jury believing that you are having a personal identification. Any questions on this case? Next one was Bobby Dean Kaiser. It's another Harris County case, 1990 aggravated sexual assault. He had a 10-year sentence. It's Hilleman again. It was 1 pubic hair from the bed sheets. In this case, it was questions 1 and 3 that were answered affirmatively. Is hair unique to an individual? Are people unique? Yes, people are unique, except for identical twins, and that's why specific fiber analysis or hair analysis and body fluid analysis is done. That's how we are able to use it as an identification or association with a particular individual. As hair and fiber analyst and expert in the field, have you ever seen 2 hairs from different individuals that matched? I have not seen samples from 2 individuals that matched. That is correct. Again, this is the same kind of situation where the discussion leading up to it, you use it to individualize and to associate. Had a problem with that. And then going on further in the testimony, the term match was used a lot. We didn't have the discussion of what are the limits. So that's where we're finding this problem of overstating or creating this false impression with the jury.
I think what's interesting with this particular analyst case is it's really interesting because sometimes I would use her testimony for training because it's so excellent in terms of the way she testifies, the way she sets up the issues, the way she, everything is excellent. And then other times, it's like, kind of textbook error. So we're trying to figure out if it's timing based, like if it's depending on the time or
I think it's
the lawyers.
I think you put it that you move thoughts and words into a court of law, and you have the adversarial system and the pressures that come to bear on it. And I think that's what explains it. It's like the saying about all plans are good until you get hit in the face. I think that some plans, all plans work into your hidden face. I think they get rattled. I think it isn't a matter we say just tell us what you want to say. There are questions, and the questions are designed to make the answer look favorable to one side or the other. I think that explains this, because this, to me, a lot of the problem in the second example is what isn't said, as you indicated before. And by not saying it, it leaves this impression. I take it from that, if I was a lay juror with no experience, that hairs are like fingerprints.
Right.
That you can identify them, even though it's not specifically said, it's implied in there, and might even be argued later.
Well, and even in some of these cases, they'll say it's not like a fingerprint, but then they'll go on to say make some statements that give a lot of strength to the association. So it cuts both ways. And with Hilleman, there are cases on the no recommendation on this set of cases where she testified and it was perfect. And it was prior in time than these cases. So it's really interesting.
Maybe it was an issue of that the cases later in time got, the associations or the clarifying statements got stronger as the training became more in depth or whatever. But it's all over in terms of the timeline, right, Bob? All over.
And a lot of it too can be the prosecutor and how the questions are asked and how because once you see enough of these, you can see kind of the pattern of how the evidence is set up, how the limited association is set up, and you'll see it in a lot of these, this question of have you ever had 2 hairs from different individuals that match?
Well, and depending on the strength of the other evidence, that's also going to be a difference, because if it's just throwaway kind of extra stuff that we don't really need or it doesn't really hurt, then the way the questioning comes out and the way the answers come out is going to be different too.
And what I've found too in a lot of these, now that I'm going and pull the records and we only want to pull these sections, a lot of the times the hair analyst is the last or second to last person to testify. So take that for what it is.
So further on, as a result of making the comparison of the unknown pubic hair to the known pubic hair, were you able to make a, yes, I was able to make a result. It was consistent with the known pubic hair from the defendant. And then a question, did it match the defendant in all microscopic and myopic examinations? Yes, it did. So when you pair that with the previous discussion of it's how you individualize, it all kind of comes together to give this impression that, well, okay, it is that person's hair. Another joint trial, John Clarence Solomon and Charles Hawkins. It's another Harris County case. 1987 sexual assault. Each received life sentence. Hawkins is still incarcerated. Raiden Hilleman was the analyst again. We had hairs from the victim's bed sheets. One head hair was associated to Solomon. 2 pubic hairs were associated to Charles Hawkins. Answered the third review question affirmatively. This is another situation where it wasn't just one statement, it was just kind of this overall feeling that this just doesn't add up, this doesn't reach the level that we want it to. So let's go through some of the testimony. This right here is just making the association with the 2 individuals. Then it was asked whether it's a Negro hair or Caucasian hair. It goes to that, and it also goes to individualizing that person's hair. So it was this similar statement. Have you, in your experience, had a situation where you could not distinguish 2 people's hair examples? Not in a particular case, I have not. Do you know approximately how many cases that you have worked involving the analysis of hair? Approximately 75% of my work is hair. Would you say that on many occasions you had the opportunity to find hairs that were microscopically consistent with the known suspect? I would say maybe in 40% of the cases. So you have all this testimony that just further builds this picture that it's pretty strong evidence, even if it's not known exactly that that's person's hair. This is one of the ones where it was the confluence of all the testimony. Like I said, it wasn't just one statement. The hair review team felt like if there's still hair available, it should get tested just to make sure. Lynn?
Yeah, this was more of like we're going to issue the notice. It could really go either way. It was a really tricky transcript, but to be prudent and to say, look, if there's hair available, send it to UNT for MITO.
And it was largely the lack of the giving the limitations, because they go into, well, we look at these, we look at the cortex, the medulla, we look at all these things, but then there's not that at the end of that, well, it has these limitations. That part's not offered. What's offered instead is it goes to individualizing a person's hair. And that's where we thought the problem was at. Next, Tracy Parker, Tarrant County case. I'll let Dawn update us on this here shortly because there has been some post-conviction testing. It was 1994 aggravated robbery, 55-year sentence. He is still incarcerated. It was Patricia Eddings from the Tarrant County Medical Examiner's Office. 1 7-inch head hair on a suspect jacket was compared to a very short head hair standard of Parker. It was testified to that it was a few millimeters. This was one of the things that for us stood out was there was a limited availability for the comparison to be done. We didn't have a 7-inch hair to a 7-inch hair. And this one, it was the third question again. It was just kind of the overall testimony. And you'll see here, we get to, let's see, and to me, this is very much like making an identification of a person. Everybody has eyes, ears, nose. It's the way these things are all put together that allows us to form what someone looks like. And we make a hair examination, we look at the known hairs, and we set up a basis, range of characteristics, and we look at the question hairs, and we fall within a range of characteristics. It was this testimony of your facial characteristics that make you you. Well, that's very individualizing, and it makes it sound like all those same types of characteristics will allow you to discern someone's hair in the same type of manner. And that was at the very beginning in the early part of the testimony, setting up what the hair comparison even is. That's, I think, what largely gave the hair review team pause to begin with. Bob, if you have any comments at any point, feel free to chime in.
For Jack, well, I know you weren't at our meeting, but yeah.
And following up with that, when they started going through, okay, well, did you compare this hair? Did you compare that hair? Match was used a lot. So in comparing the question hairs to known hairs, did you find any hairs that matched Jerry Parker? Did you find any that matched Kelvin Williams? And then a couple of lines down, did you find any hair that was comparable to Tracy Parker? So we had these terminology of, did you match the other co-defendants? Did you match their? And then we get to the person in question. So it was all this together that made the hair review team want to make the notification on that one.
That was also
It was a
a
tricky
close
one.
call because she says, can you go back one slide? She says, or he says, I forget, was this?
This is Patricia Eddings.
Okay, so she says, I didn't say it belonged to him, but I said we used the term match. It means it exhibited the same microscopic characteristics and could have had a common origin. So the problem with that, I think, for the group was, we know what she's trying to say. Forensic scientists don't hear match the same way jury hears match, but jury hears match differently, and we recognize that now. And so I think the idea was not so much to notify on error, but to say to the DA, look, if there are hairs left to retest, you should retest them.
I have a question. So what we don't have here, it almost seems like the problem isn't words out of the analyst's mouth as much as words out of the questioner's mouth. The questioner's using words that, like match, having strong words. I mean, is that, am I right about that?
Absolutely. We actually have cases where the analyst says, actually, we don't say match. We use other, we don't like that terminology.
But more
So
importantly, the answer to these is no. I mean, in terms of match, it'd be more problematic if she'd said, yes, there's a match.
Well, she does. She says, what I said was we use the term match. She says, I didn't say it belonged to him, but we use the term match. So, and another couple analysts, they say, I mean, one of our analysts this time corrected the lawyers multiple times and said, we don't like that term, we don't say match. And so those are on the no notification list.
Okay.
So it was this whole.
So what was
It didn't
missing
make
from this
sense.
is there needs to be an affirmative, the person given the answers has to be defining the term in such a way or explicitly rejecting that anything they're saying is connected to word match.
Not necessarily. So we've had transcripts where the person does not correct the questioner, and we have no problem with that as long as everything else that they say sets the context appropriately, talks about the limits of the science, and uses appropriate terminology. Here, what we see is this sort of weird conflict between, I didn't say it belonged to him, but I said it matches him, which means it's all the same. And so that was the issue. It may not mean that to the forensic scientist or to the hair examiner, but to the jury, it can be misleading. And so in this particular case, we're not flagging it as quote-unquote error. What we're saying is to the DA, look, if there are hairs left to retest in this case, they should be sent.
Yeah. And I think part of it,
that's the most prudent course of action.
and part of it too is, at the beginning of the testimony, if the setup and explanation of what the hair comparison is includes that discussion of what the limitations are, and not this discussion of, it's like looking at a person. You see their eyes, their nose, their face, their bone structure. If you have an actual discussion of what the real science is, then we're okay.
Gotcha. So it's almost like part of the recommendation is going to be that the analyst be equipped with some very good disclaimers, so there's no misunderstanding about what ultimately the science can do and what the science can't do. That would be
Well,
helpful.
that is not always in the control of the forensic scientists, and often it isn't. But this review is not just about making observations for the scientists, but also for the legal community.
Well, that's what I'm talking about, for our
Yeah.
benefit.
Yes.
To give them an opportunity to put the
lay
limitations
the
out there
foundation.
up front. Okay. Sorry.
So in that instance, would it be appropriate to provide the courts with a statement about hair analysis that should be read into the record?
It doesn't work that way in criminal cases. I mean, at a hearing challenging it, if there's a disability, then the analyst would have an opportunity to verbally say that, but we don't. The court doesn't, the way you've described it would not be possible, but it would be possible for the analyst to start off with a general, just laying out, as is done in other sciences, including the one we talked about earlier, retrograde extrapolation, with the limitations of what they can do and the things they have, the assumptions they have to make, and all those things are laid out to begin with.
I also think this is the perfect example of what we were talking about with the process of the adversarial system and how sometimes the analyst can try and go through things correctly and questions get asked in a way that sort of take that off the train a little bit. Because here we're talking about, when she's answering the questions about match, I mean, you're taught as the witness to answer the question that's being asked, and she's giving the answer, which is no. And that's the way that she would normally be able to do that, not necessarily to inject, although we would, I think that from a forensic analyst standpoint, it's always good to try and clarify if we're asking the questions in a way that's wrong. But even later, after this statement that's on there on 285, there's a statement after that where the defense attorney specifically says, so you can't say it was Tracy D. Parker's hair. And the witness replied, no, sir, I'm not. You're not willing to say that. No, sir, I'm not. So even after this part where she's talking about we used the term match, which I frankly, in reading the context of the statement, of the entire transcript, read that to mean when we were asked questions about the term match. And so maybe that's what they meant, maybe they didn't. I think it's an inherent problem in trying to review a transcript and trying to understand that the witness is asking questions. So not to, necessarily, I'm not trying to change your mind about it, but I see the problems in it and why reasonable minds might differ on whether or not this one in particular is an issue. Regardless, in this case, it doesn't necessarily matter because the testing was done in 2012, so there was STR testing done on the hairs that were available then. And actually, I reviewed this case as well because it was one of the DNA notice cases from DPS. But it was actually one that was a partial, not a mixture. So it was in that group that went out before we were able to identify specific CPI cases. So in this particular instance, even though it was on the DPS list, it fell into the category of the ones that were not CPI and were not a DNA mixture. And so there's really not any other sentinel event review that needs to be done with that one.
So we don't have to send this letter then?
Well, I mean, that's,
So we don't have to send a letter?
Right, yeah.
Well, I'm not speaking, I'm not, I had questions, but this is a Tarrant County case, so I'm not.
Oh, right. So there's no need to do it.
I mean, y'all can do what you think you need to do on it, but, we've already done the testing.
No, because we would only recommend the mitochondrial test, which we've
Yeah,
already
so
done.
it's moved. It's moved.
okay, that's fine.
I just had a question about the process. I've heard stated over and over and over again that a statement that could lead the jury to believe that there was an individualization, when there is an out-and-out statement by the witness very clearly that they are not doing that, how can this be on the list? Because they're not leaving the jury with that impression if they've made that affirmative statement.
So Tim, we do a contextual review of the transcript of a group of 8 people. This was a very close call, and the group walked away with the impression that the most prudent course would be to send a letter. On 5 of them were sending letters, on 5 of them were not. Reasonable minds certainly disagree on this.
But it's
transcript.
inconsistent with the statement that you've all made, that any statement made in testimony that leaves the jury with the impression that it is.
That's not actually a statement we said. We didn't say any statement. We said the overall context. And the overall context in this case, the group thought, I'm not speaking personally, the group thought was that when the beginning of the testimony, she says it's like looking at a person's face, sets the table for a false impression, and there was no full discussion of the limits of the science. If that had been given, I don't think it would be on this. I think the panel would have said,
If what had been given.
move it on down the line.
You can
I'm sorry,
disagree.
what wasn't given? Maybe I misunderstood.
Recommendation.
Was this part of this testimony?
Was what part of
What
it?
you read, the
What
statement
I
that
read
came on?
was immediately the question following that question. Because I reviewed this too, and I actually came to the conclusion that you did. I felt like it was appropriate in the context and the closing argument. Even the closing argument was that, I'm sorry, that the closing argument was could have or is consistent with his hair. So I came to that conclusion too. I just certainly understand that.
And I think part of the reason why the hair team, when we have a situation like this, is going to err on the side of caution and make the recommendation, is that even if a hair analyst testified 100% correct, did everything they were supposed to do, gave all the limitations, they could still be wrong. I think that's kind of where the team comes back to, is that we've seen that you can do everything right, and there's still that opportunity that it is someone else's hair. So in an abundance of caution, we're going to make that recommendation to have it tested if it's still there.
This was a very close call, and the perception was, so we review the whole thing in context, which means two things. If you say something like the hair matched, and then go on to clarify it in a way that does not leave a misimpression, it's not error. It's not flagged for notification. But the other side of it is, if you answer one question in a way that's clear and say, no, I didn't say it belonged to him, but everything else you said, or you left an impression that you didn't really mean that. We've seen that in transcripts. We've seen transcripts where people say the right thing in the beginning, and then as they keep testifying, it gets cloudier and cloudier, and by the end you're left with the impression that it's that guy's hair. So that's why we do a contextual review. This admittedly is the closest call we've had. I can completely understand why you disagree with the assessment. It was not a universal decision. The ultimate answer was, look, if there's MITO that can be done, it should be done, and that's all we're going to say about this one. It wasn't going to be, we think that, in fact, the letter itself, which we're not going to send anymore because it's moot, had in it statements about the fact that we were just doing this in an abundance of caution if the MITO or other DNA evidence was available. So this was a very close call, and
I get it from the teaching standpoint. I mean, I think ideally, what we're looking for is to have to help the testifying analysts understand the pitfalls and things to avoid. And I definitely see the value of that. And I think the other thing worth making clear, just in case everybody listening to this isn't aware of it, this isn't the committee saying these people are wrongly convicted based upon hair testimony. This is patterns of testimony that cause concerns that are generating these letters. Because it doesn't matter how overwhelming the evidence was in the particular case, if there's testimonial errors where it's not proper.
We're not even looking at the other stuff.
Yeah, so I just want to make sure that's clear, and so it's not misinterpreted as saying that we have, letters going back to 5 cases where hair wrongly caused someone to be convicted.
I mean, in one of the ones we sent a letter out from Harris County, we got the MITO back, and it was consistent with the maternal line of the,
It was confirmed, yeah.
it was confirmed that we don't know exactly that the same hair referenced in the hair testimony is the hair that was tested, but what we do know is that a probative hair in the case was tested and came back within the same maternal line as the defendant's.
Well, and to clarify, this was SDR testing.
Correct.
So, I mean, obviously that's even better. I don't know because I got a question about that as I was walking away, so I was concerned that perhaps I just said post-conviction testing and had not clarified that it was SDR. But it was in fact SDR
Which
testing.
is obviously far more exacting than MITO.
All right, the next one, Onesimo Cordero, 437th District Court, Bexar County, 2007 aggravated child sexual assault, convicted and sentenced. I think we've got some update on this one, so this may be one that we may not be sending a letter on as well. Mike Martinez from the Bexar County Crime Lab, who's on our team, 1 hair from the vaginal swab, answered the first review question affirmatively. The testimony, let's see, the question. Now, all of us who've grown up in the TV world expect to hear a scientist say, this is the hair that came from this person. Why are you not up there telling me that today? Well, I'm not. Well, I feel, in my opinion, I'm very confident that this hair was derived from this individual. And that was the statement that gave the team. Mike agreed. I mean,
Mike brought the transcript to our attention, and they've done subsequent DNA testing, and the MITO confirmed the connection and the assessment.
Yeah,
So
we found that out, within the last week.
but that he agreed himself that statement's problematic and brought it to our attention.
So,
And also, there was a recommendation before this was a trial, this to go to DNA, and the prosecutorial team did not take it to DNA.
yeah, I think that will be something we will look at specifically with hair comparisons. All right, so an update on where we're at in the process, kind of the overall number picture, because this is going to set some questions that we'll look at here in a second, coming up to probably the next meeting that we'll want to be thinking about. So initially, out of the 693 lab reports that we gathered, we ended up with 287 positive probative associations. We also had the 120 cases on the LexisNexis Westlaw case list. Out of all of those 813 cases, after as much research possible, 78 total cases were found that could be possibly subjected to a record review. That means they're criminal trial convictions where there it appears that there's an appellate record, so that there's a record that we can actually go pull and look at. Determined that at least 29 cases disposed by plea. I'm sure there's more, but those are what I can ID initially. Out of the transcript review so far, 7 on that list of 78 I've determined that there's not going to be a record for us to look at. So that takes our list down to 71 already. To date, we've got 23 records reviewed with 12 notifications. If the 7 are approved today, we take those 2 out, adjust the numbers accordingly, with 11 cases with no notification. So as you can see, out of what we thought was our initial hundreds and hundreds of cases, when we actually do all of the vetting and working it down, there's just not that many. I mean, everyone understands just because a case goes to a lab doesn't mean a criminal conviction results from it. So I think the questions that we need to think about, I don't think we have enough data yet to answer them, but we need to be thinking about is 71 transcripts. If we're even able to get that, number's probably going to drop as we go through and keep trying to pull records. Is that a sufficient number for this subsampling review? If it's too small, how should we expand it? Should the expansion be limited to certain labs or examiners depending on notification results? And should we tackle it for input on the question? Excuse me, I've got allergies really bad. But in your binder, there's the memo that writes this up. You've got an accounting of what labs provided to us, how exhaustive it is for each lab. So using that information, we could probably figure out some ways to target some other expanded cases. It just depends on what we want to do. I think we'll have some better data back by the next meeting. We'll have more data back at least. I've already got 3 or 4 cases reviewed back from Latham and Watkins that we'll review at our next HARE meeting. We'll probably have another 10 or so, hopefully by then, to review. So that'll take us up to 40, almost maybe half of the total number of records. So those are the kind of things we need to be thinking about going forward. Lynn, do you have any other?
No, I don't think we need to even discuss it now. We just want to put the stuff on the radar that we just don't have that many records. It's really, just because the work was done doesn't mean there's a conviction, and certainly doesn't mean there was a trial and a transcript review. And this isn't like digging around in the state archives and like trying to find this stuff. It's hard.
And have any other cases been brought to the attention based upon people actually involved in the trials that you didn't? Have there been any that weren't on the list that you got from other means?
That was going to be my next point. We actually received our first letter, I think, within the last week from an individual discussing that they were convicted on HARE testimony. It appears that identity was in question based on the limited research we've done. Cited to the record. If based on what the letter says, the citations to the record are correct, statement of identification was made, probabilities were given, so that's been added to the list, and we're going to take a look at it very quickly.
Okay, and there is a transcript of that?
Yes, I think I can get it from the state archives, actually.
So is there a reason why that one was not caught in the same method you searched the other ones, why that one was not caught? You know what I'm saying?
Yeah, there's another huge potential pool out there that we're not saying.
And it should have been on the Lexis Westlaw list, I think, but the appellate record, the appellate opinion on it's old, so it may not have shown up in there. Because I went through and read all 120 cases and threw out the ones that didn't fit, and it's not on our list. So there's 1,001 reasons why a case isn't on our initial list.
And it could be that they didn't appeal. Maybe the HARE wasn't discussing the above.
That's all I've got on the HARE.
Do you guys have anything?
No, good work.
Okay, number 10, update. And my name is on here, but the paperwork says that Lynn.
So, if you recall last time, the commission asked me to get in touch with AFTI to talk to them about whether they would be willing to take a look at John Murdoch's conclusions about the findings in the case where the the Taurus was mis-ID'd. And I talked to the head of AFD, and he said they will not do case reviews where one lab goes behind another, or where they put somebody on it to review the work of another analyst in another laboratory. He said they've been asked to do that, and they just don't do it. He said they have a list of consultants that can be hired to do that on their website, but that I didn't think was my instruction. So he said that generally speaking, he does not agree with John Murdoch on QCMS, but he does think that in evaluating an ID, or the actual pattern match, that John is very thorough and fair and consistent, and that if John said there was an issue with the pattern association, that he would trust that, absent having seen the photos. And he says that even though he does not agree with John on the quantification of the stria, and he also said that the test firing of identical material to what was originally fired is understood as something that analysts should try to do. Though he didn't say that they have to do it. He just said that that's kind of commonly understood. But they would not give us anything beyond that. And they will not assign somebody to take a look at the case, to assess anything. Now, John Murdoch has come back to us very, very strongly, saying that he never meant to imply that the examiner is not able to be retrained and rehabilitated, that is the course that should be taken, that the laboratory should look at its entire quality system, including where the tech reviewer, who is far senior to the analyst, was in the process. And the AFD president told me that from his point of view, it's about examiner rehabilitation and retraining, and really a systemic issue with it not being picked up on tech review. And that's what the lab needs to focus on. And so my thought was that we should just go ahead and write the report and emphasize that the commission's recommendation is that this analyst they should continue to work with the analyst, and that they should think about a way of addressing the concerns about the tech reviewer missing the issue, and sort of wrap it up.
Because I think that was their primary, the lab's primary concern, is that there was an unfair burden on the analyst, and there was nothing really that was, we made a finding of negligence for the analyst when there was nothing really placed upon the tech reviewer, where really that finding should have been not just a heavy burden placed on that particular analyst, was their, from memory, was their main concern, which I agree with. But what does that mean for that initial finding of professional negligence? Does that still stand, even though we recommend the retraining and that sort of that course of action?
I think the commission could very easily sort of broaden that determination to include the process of working that case. So the laboratory, the ID, the confirmation of the ID, and so on, so that it doesn't inappropriately or unfairly fall on a junior analyst who is only one part of the process of making that report.
There's a fairly strong amount of things that the laboratory has done that needs to be provided back as to what steps have been taken.
Yes, they have given us some communication recently with AskCloud Lab, and AskCloud Lab asked some follow-up questions. So I think we can include that material in the exhibits as part of the overall corrective action that the laboratory is taking. So I think we should move forward, and I'll bring you all a draft report for next time that keeps in mind the concerns and the observations.
I don't think we have to make a motion.
No, I'll just, next time you will, but
Right.
I think we're okay.
Okay. Number 11, Bell County.
Oh, we didn't vote. We need, Nick's right, we need to go back and vote on the letters. So,
Okay.
I would say.
Someone has to make that.
I would not include a letter on
Just the two, just the
the
five.
Eddings case.
Just the five?
After hearing the feedback.
What about on Cordero as well? Since that one's already,
Well, Cordero's kind of moot at this point.
exactly, so are we still going to send a letter or not?
Look at me.
Well, the difference between those two cases is one of them was very borderline, and I think there are reasonable arguments that it shouldn't have been included. But Cordero is clear. So do you want to just do 4 instead of 5 of that group? So not the one Eddings transcript, but the other 4?
I'd make the motion. Can I make that motion, even though we're excluding the one from Lyon County?
Make it.
I move that we send a letter on those 4 cases.
Second.
Aye.
Aye.
Nay.
Okay. Video.
Sorry. Trying to respond to, telling them to get a letter to the commission regarding the actions on the prior case. I thought that was already.
We do have the correspondence with FPLA that they forwarded
I'm
us. so
talking
that's
about all the things that have been done to remediate and address retraining and all that that's already in place. The next case is one that has taken quite a while to bring to near closure, and that's the Bell County forensic video analysis. In 2009, George Powell was convicted of robbing a convenience store, and one of the witnesses used video analysis to estimate height. And the expert was Mr. Knox, who used inverse
Dr. DeMaio, I don't think you can leave.
Okay.
1, 2, 3, 4. Wait a minute, 1, 2, 3.
No, don't worry, I'm
Yeah, no,
leaving.
You can't leave. We'll lose our quorum. 1, 2, 3.
Now we have 5, so we're good.
1, 2.
1, 2,
We have 5.
Okay.
What's a quorum?
5.
If
Yeah,
he
fine.
leaves, we can't though, so you're right.
Keep going, or do we take a break till?
No, go ahead.
Come on, yeah, that's fine.
That Mr. Knox used single image inverse photogrammetry. Mr. Howell is approximately 6'3" tall. Mr. Knox said that the person who robbed the store was at least 6 foot tall, and his measurement was a minimum of 6 foot 1 1/8". A complaint was filed by Mr. Powell's girlfriend after she hired a group led by Al Yanovitz, whose technique appeared to be that he took a look at the video, saw where the robber's head was, went, measured that, and his measurement was approximately 5 foot 7 1/2 inches. The commission then, with the disparity of the two in the complaint, hired Grant Fredericks to reanalyze the video. He used 2 methodologies. One was reverse projection, 3D laser scanning, and the other was measurement scale analysis. His average value was 5 foot 7.6 inches. After his video was shown to Mr. Knox and the Bell County District Attorney's Office, there was a request made that Mr. Knox's method be peer-reviewed, and he mentioned an individual named Dan Mills, who Mr. Fredericks also knew and said that he would be good and was competent. His initial report indicated that both methods were reliable, which would then mean that it was that the methodology would allow for a variance of 5 to 6 inches in height, which then calls into question the reliability of the discipline. So after the conversation was held with Mr. Mills, kind of regarding that, what he said was the digital file that he received from Mr. Knox was subsequent to Mr. Frederick's analysis, and that that analysis indicated a height of 5 foot 10.4 inches. The testimony in court was not 5 foot 10, but was his measurement was 6'1" and 1/8". So some questions then were posed back to Mr. Mills, and his statement was that the digital file that he received had a minimum height of 5 foot 10.4 inches. So with that, he felt that methodology did seem to add up in terms of QC, or quality assurance evaluation, that he did, but that's different than the original measurement.
Testified to in trial.
And his testimony in trial was not 5 foot 10. And so it said, are the conclusions in the case report and testimony supported by the data? No. The digital photo modeler file with 5 foot 10.4 inches minimum height was a subsequent analysis with updated information that was not reflected in the written report and does not appear to be reflected in the testimony.
I was just letting them know we just got this.
Yeah, we received this yesterday. And then the question was, would a change such as this, that is 6'1" to 5'10'4", merit the issuance of amended report? And his position was more, didn't know that it merited an amended report as much as a letter. I'm not sure why that position was held, but he said, I would consider that to be a noteworthy variance. So from this, there seem to be several things that would be worthy for the staff, the commission staff to do. One would be that we should put together a collection of all this data into a report, and that the DA should consider that reanalysis by the FBI. They should reconsider this information. One option being a reanalysis by the FBI department if they want to get someone else. That the licensing group should prioritize this as initially at least a voluntary licensure. That all scientists, whenever they have some sort of a substantive variance, should notify the prosecution and the court. And that in this subspecialty, that the peer reviews in this discipline, there should be peer review in this discipline, and there should be a margin of considered acceptable error. And then Mr. Fredericks also has quite a few other recommendations in there that at least should be collated by the commission staff to allow the full commission to evaluate.
So we'll do another report on this case for next time and bring it in front of everybody. And did you all have any other thoughts of things you think we should add? We haven't had a chance to talk to the DA about the information we got yesterday.
It's been some time. I mean, has there been any, I'm not aware of any conversations since.
There's an email out whether they should attend today, which, I mean, they have to make their own decision. They were told this will probably be a briefer presentation than what the next one, which will have the full report put together.
Right. Okay.
But they're also notified they could listen as well.
It's going to be a tricky report because there have been so many people that have weighed in, but the issue, I think, is that when we got the first peer review from Mr. Mills, the reaction was, okay, well, if it is true that this is subjective and it is true that you can have that much subjective variation, what does that say about the discipline?
Right.
And so then when we went back and said, well, you know, what is the basis for that? And he explained that the photogrammetric files he reviewed were actually the ones that led to the 510 determination. But when you look at the transcript and the report in connection with the trial, that was all over, the minimum height was expressed as 6'1" and 1/8 inch.
And then Mr. Powell, I believe, is about 6'2" to 6'3".
Well, even comparing the second report by Mr. Knox with Mr. Frederick's analysis, it seems like there's a significant difference in those two measurements.
So, the way that Fredericks expressed, he gave us a whole bunch of different angles, camera angles, and a whole bunch of different height determinations based on those angles. And from what I recall, his lowest end was just about, just under 5'7", so 5'6" plus. And at the highest end, it was 5'9", almost 5'10".
So the tallest, what he said was the tallest the individual could be was 5'9".
Almost 5'10".
Okay.
And so I think what Mr. Mills was saying is in light of that, they're actually not that far apart, but that's not, that 5'10" analysis was not the trial testimony. That was the subsequent.
The average for Mr. Fredericks was 5'7".
Okay.
The subsequent testimony, the analysis that Knox did after Fredericks gave us his initial review is what Mills was given to peer review, which is different than what the trial testimony.
So it almost seems like we're at the same point with this as we are with bite marks. They don't have any validation studies.
I don't think they would say that. I think when I talked to Mr. Mills on the phone, he said that they should come within a reasonable margin of error, which in his view is 2 inches, and the fact, and that they should not be 5 or 6 inches. He said it's mathematics. That's what we do. It's geometry. It's not, you can use photomodeler or you can use the approach that Fredericks took. They're both valid approaches, but they should be within an inch or two of each other. And in fact, they worked a case on opposite sides of each other in a case some time ago where Mills was hired for the defense and Frederick for the state, and they were within 1/4 of an inch of each other. So it's not that the methodology should not reach a consistent conclusion according to both Fredericks and Mills. It's just that this case is...
Right, this is an outlier. This case would apparently be an outlier from that.
The analysis...
That's pretty scary because it was very important evidence that had a lot to do with the conviction. And what is his status? So we don't know what the status of any actions on the part of the attorney for this defendant have been since we started this.
The attorney, I think, is aware of, he's aware of the results of this, what action or where he is. I know he's been in touch with the judge, but I don't know specifics of where all that is.
The judge, the courts informed, the DA informed the court, the defendant, and originally there was a court-appointed attorney, and then the IPOT decided they were going to pursue the case, and Skip Reeves is representing because it's in Belknap.
Okay.
And I don't know what phase of the legal process they are in right now.
Okay.
But I don't know, there's nothing else from the commission standpoint to do except to lay out what we've seen and the concerns about, consistency and reliability and all that stuff.
Okay. I agree.
I do have a comment, and my comment is about Richard Alpert and Tarrant County DA, Tarrant County Medical Examiner Peruani, and it relates to this case in some form. And that is, there is a video associated with it, which was cut off by the police officer, and we had it looked at, and an affidavit came back that said the video was edited. So my point about being here today is that I've been waiting. I didn't know I had an opportunity to be in front of this group until about a month ago. So January 1st, 2016 marked the beginning of the 11th year my son has been wrongfully imprisoned in a Texan prison after a jury found him guilty in August 2005 of intoxication manslaughter and the 2004 death of Grapevine police officer Darren Matlin. And this injustice that was, to me, orchestrated by Richard Alpert. Our son was not drunk. He's been denied parole 4 times, and he continually gets denied because he won't say he was drunk. But during the past 10 years, we sought justice and truth through the Texas judicial system, and we even sent the video affidavit. We did the appellate, all that too, and it went to the judge, and the judge turned it back around and said, no, could have given us that before. But we had real hope with FBI, and I see you suggested that this group go to the FBI. We went to the FBI as well. And we went to them because we thought it was a color of law abuse. And we told them that the neurology expert had answered yes when he asked the question about my son having a seizure. And we told the FBI about Euless police officer Deanna Ramsar's tampered accident scene video and her perjured court testimony. And Prosecutor Richard Alpert was there the whole time. We sent those, the videotapes to 2 experts, an affidavit came back, and sent that to the judge, and he sent it back to us. And we told the FBI that ADA Richard Alpert had redirected the blood draw from the certified DPS lab in Garland, Texas. 2007, FBI said it couldn't determine if a law had been violated. 2010, told us that the matter you brought to our attention did not warrant an investigation. The FBI's Dallas division has also reviewed this matter. 2013, did not find predication for an FBI investigation. So if you guys can get the FBI to help you all, please let me know how I can do the same. But luckily, I did come across this Texas Forensic Science Commission website, and the paragraph that really came to my attention was, or the line was, that Dr. Perawani had worked for the FBI. So I'm asking the FBI to investigate somebody who worked for them. And then the other paragraph that was Alpert's biography, he says that he is well known throughout the state and U.S. as an intoxication manslaughter expert. And in one of the books that he's published, somebody has written, Diane Beckman wrote, no matter what your set of facts, Richard has a great idea for how to turn them into an advantage. I agree. I am pleased to be here with you today, and I will be at every quarterly meeting going forward, because I want my son exonerated.
Okay, ma'am, have you written anything and sent it to us?
I didn't know I could do that.
Yes, you can.
Well, that's new to me. I will do that.
Right, or you can go on the internet. and
I
you
can, I will do that. I appreciate it. This is the whole, I didn't know
Okay,
that from
I
the,
think that would be the best thing to do.
I will do that, and I'll be here every quarter.
Okay.
So the last thing I want to say is, my son life matters, and I appreciate your group being a group that works for justice through the system, and I'm really counting on you to help me do that.
Okay,
Thank you.
Well, just send it to us.
We'll look at, there's
Right.
the complaint forms online, you can submit it, and we will, and any supporting documents you have.
Thank you.
Okay, all the instructions are there.
Thank you so very much. I'm so happy I came to that.
Okay, now we were talking about the,
Powell case. So we're going to draw up a draft report for consideration at the next meeting.
Okay.
So do we need a motion on any of that, or no? No, okay.
Okay. That leaves us with the DNA mixture interpretation.
Okay, so I have got a PowerPoint on this. hopefully you can hear me. All right, so we're going to give you an update on how we're doing with our DNA mixture project. So just as a refresher, how did the commission get involved in this? And the original issue was that within the forensic DNA community, it's been recognized for some time and acknowledged in studies done by NIST that mixture interpretation has been quite variable among laboratories in the US and abroad, highlighted by two studies, MIX-05 and MIX-13. And then in April of last year, the Department of Forensic Services in DC, which is the big new fancy multi-million-dollar DC crime lab, had its accreditation suspended because Dr. Badoli, who you all know at UNT Health Science Center, had been called by the U.S. Attorney to review a case, and he found concerns about the way the statistical interpretation was done in that case. And then they started to audit additional cases and found discrepancies both among examiners and from how the labs were translating the protocols to actual interpretive practice. So then we had the FBI allele frequency restatement, and what that was the FBI acknowledging and moving from 15 to 20 genetic markers for CODIS that they had made some typos in the early 90s when they were entering the data. So like 31 of 30 some odd thousand entries were found to have been either typos or limitations of the technology they had at the time. But when that notice was released, I remember seeing it and I thought, well, this is no big deal. But, you know, it's good that they're letting everybody know. And DPS, being diligent, and some other laboratories in Texas sent along that notification to prosecutors with an offer that anyone who had a pending case, though they didn't believe that the statistics would be impacted in any material way, that they would do recalculations for those cases in an abundance of caution. And so some prosecutors took the agencies up on that, and what we saw were fairly, in some cases, not all, and some fairly dramatic changes in statistics, which set off a chain reaction among the prosecutors in particular. And the second one up there is kind of tongue-in-cheek a little bit, but people were really concerned about this because when you get to the bottom line about the statistical association in the mind of a prosecutor, there's a big difference between, 1 in a billion and 1 in 40, and there's a big difference between 1 in 1,000 and inconclusive. And so these were the types of things we were seeing. And so the prosecutors, the TDCA, started becoming concerned about this. And what we realized in sort of looking at the root cause is it's not that the laboratories are at fault somehow. What happened is a couple of things. Number one, the statistical concepts associated with a particular way of calculating DNA mixtures were not very well understood in the community. And the literature that was published didn't always make its way down to the people actually doing the practice at the bench. And also, the incentives aren't really in place in the laboratory to encourage that type of academic pursuit. And I remember I was talking to one lab director or DNA director in Bexar County, and we talked through these issues for like an hour on the phone once, and he said, while we're on the phone, a whole bunch of stuff is coming in the door and my phone's ringing off the hook. And so, you guys just need to understand that anytime we even have a conversation, it impacts the things that our metrics, which are about, case quality and getting the cases done. So that's an important piece of it. Our laboratories have really, really risen to the occasion to address these issues in a proactive way, and they should be applauded for that. I'm getting kind of tired of reading news articles about how Texas is the only state that's doing anything and where's everybody else, and I don't know the answer to that. I do know that I'm getting a lot of calls to go other places and going to Arizona next week, for example, to speak to their DNA folks about what we saw. I also think a big part of why you're not seeing this as much yet in other states is because I don't know that they sent out those FBI allele frequency notices with an offer to recalculate. And if they had, they would probably be seeing the same changes in statistics depending on when the case was first analyzed. So it does help, though, to understand gaps in educational infrastructure and incentive systems, and just to do a root cause analysis as a community. And one of the other things we're realizing is that the labs don't always have time to talk to each other. And so a laboratory may be using a certain interpretive technique that nobody else in the state is using. So we have to provide better fora for discussion among the laboratories. So what have we done since the last meeting? Well, we did scientific training for our analysts regarding the main principle of CPI, which is that you do not use for calculation purposes loci where there's evidence of allele dropout, as well as principles for reintroducing loci in a scientifically appropriate manner. They also talked about alternatives such as, making sure that you try to deconvolute a mixture and that you try to use other statistical methods that are far preferable to CPI. I want to recognize Bexar County in particular with respect to this because when Bruce Bedoli looked at their cases, they obviously had been thinking these issues through from very early on and recognized that as the evidence got more and more complex and was moving really quickly out from under them, more and more touched DNA, the CPI is not very well suited to handle those cases. Is that a fair statement, Aaron? It's not the best.
It's not the best, especially when you're dealing with low-level interpretation. And so there is obviously a level of concern once you get to a certain point.
Right. And so, to put it mildly, the expectations and demands on the laboratories in terms of, law enforcement will swab everything at a crime scene. I mean, doorknobs and all kinds of stuff that many, many people could have touched, and the statistical methodologies weren't necessarily adjusting, as you might hope, quickly enough to handle that. Not to mention the fact that the kits that they're using are more and more and more sensitive, where the statistical methods aren't necessarily appropriately tracking that level of sensitivity. So we did training up at Tarrant County ME's office, multiple day training with the section leaders from around the state. Then we did 2 more weeks of pure statistical interpretation issues with Dr. Simone Gittleson, who was an absolute godsend from NIST. She came for 2 weeks. She went to Austin first, then to Houston, then to Fort Worth. And DPS hosted her at those locations, and that was really, I think, very helpful for the analysts. And then thanks to a grant from Judge Hervey, we were able to send people to STR mixed training in Massachusetts because they couldn't get the folks from New Zealand to come to Texas for one training fast enough, so we were able to send them there thanks to a grant from Judge Hervey. Dr. Bedoli, day and night for weeks, reviewed all of the mixture protocols from the labs, as well as case samplings from all of the laboratories, including all of the DPS regional laboratories that do DNA, which is 9 labs, and then did go-to-meeting conference calls with everybody, giving them his observations and walking through the electropherograms with them. He also did some meetings in his office and offered suggestions of ways they could update, amend, or revise their protocols to ensure that not only is the main principle of CPI being observed, which is that you don't use loci where there's evidence of allele dropout, but that if there are ways to appropriately reintroduce loci so that you're not leaving good data on the table, that they account for that they have a way of handling that in their operating procedures that is well understood across the laboratory systems. That it's particularly challenging with DPS because they have a lot of analysts. And so to get everybody on the same page and make sure everyone understands the concepts is challenging. And then we did also a conference call with QAS at the FBI around making sure that the retroactive case review that people are doing is not in conflict with the QAS standards. And so Doug Hares and Tony Honorato from the FBI assured the laboratories that the FBI will work with them to make sure that they are not in violation of any QAS issues. And in fact, the FBI, the SWGDAM is rewriting the QAS standards because this is not the only circumstance where you have to review cases using kits that you may no longer use anymore and for which you may have one person in the lab proficiency tested anymore. And so the question is, well, if the QAS standards say I'm not supposed to interpret if I'm not proficiency tested on the kit, am I not technically in violation of that rule? And so the FBI has been really good working with us on those issues. We also, at the request of the laboratories, released a clarifying statement that Dr. Hugh Stamm helped with on the Commission's website about what exactly is meant by current and proper mixture interpretation protocols. We keep pushing for the release of a guidance paper on CPI that was written by what the FBI, I just found out, called the Killer Bees plus Mike Coble. This was a paper to really let the community know how to do CPI properly that we expected to already be published, but they sent it into FSI International, and the response was, why are you talking about CPI? You should be doing likelihood ratios. This is because they're all from Europe. The peer reviewers were all from Europe. So now they're trying to get it published anyway. And even if they have to publish it on the Texas Forensic Science Commission's website and nowhere else, we are going to get that thing published. And now, interestingly, Dr. Badoli said that even though the peer reviewers are from Europe, he doesn't really understand why they don't see some value in in putting a CPI paper out there, because he said there are labs in Europe that do CPI, and there are labs in Asia definitely that do CPI. So we'll see what happens with that, but they're continuing to work they're working very hard on getting that paper out. The only reason we don't just put it on our website is because I think the analysts wanted a peer-reviewed journal that they can go into court and say, here it is, and this is what we do, and it's not just because these 5 guys said so, but it's because they said so, plus it's been looked at and reviewed. We have training at K-Law in Plano next week for lawyers, and that training includes basics in DNA, as well as mixture interpretation issues, probabilistic genotyping, and breakout sessions, strategic sessions for prosecutors and defense lawyers. And then we have a presentation next week in Arizona. We got invited to speak at Bodie's conferences, both the one on the East Coast and the West Coast, and at ISHI, which is the main DNA conference annually in September. I think that's in Minneapolis. So somebody wants to know what Texas is doing. So we're going to try to go to as many of those as we can. Now that's the update sort of on the scientific training side. In addition, we have sort of a major big deal development, which is that in January, the Texas Indigent Defense Commission approved a $400,000 grant, is that right? To begin a statewide review of the cases, and that statewide review is headed up by Bob Wyckoff, who's over here, who you all know because you referred a bunch of cases to him earlier. We also have 2 counties that have their own triage teams set up. One is Tarrant County, and that's headed up by Don Boswell, among others, and Travis County has the Capital Area Defenders doing their case triaging. I understand that the Indigent Defense Commission is getting ready to do supplemental grants to those counties, and it's just going to ask that they stay well coordinated with Bob's team, which they, I think, talk probably every day at this point. So I will say that I just got back from Tarrant County at a training they did, and I'm super impressed with the whole wheel they've set up. It's very thoughtful, extremely thorough process, and I know John's been working really hard on that.
That was very well received. I've had a lot of defense attorneys come up and compliment the speakers about being the ability to get it at a level they could understand it.
Oh, good.
So it's
That's
very
good.
much appreciated.
I figured Bruce's talk was over everybody's head, but
yes.
we're going to have to dumb Bruce's talks like way down, I think. But I'm glad that they appreciated it, so that's good. So then in February, we're doing these trainings, and Bob's got 100 law student volunteers that he's already enlisted to help collect data and provide factual case summaries. Now, this is Bob's screening chart. Do you want to talk a little bit? I'm sorry to spring it on you, but this is sort of how he triages the cases for the statewide review. And Dawn has her own system, but they are all talking to each other and sharing information and sharing resources.
Okay. I think I can talk about that. Yeah, so we're sort of feeling our way, but the way we do this, we have a P.O. box in Houston, and we get letters from one of two sources. Some DAs in certain counties have sent out a notification letter to people whose cases had DNA mixtures. But so far, it hasn't been the major metropolitan areas. The two biggest counties thus far are Williamson County and Denton County. So there haven't been the big influx of cases from the big metropolitan areas yet. So we've gotten about 200 letters. About half of them have come from DA notifications, half have come from prison postings. Judge Hervey was instrumental in getting notice letters posted in the prison libraries across the state in, I think she said 10 different languages. So far, it may just be English and Spanish, but it's about 50-50 that, the source of the letters. So we get some letters that we forward to Dawn up in Tarrant County or to the capital area defenders. So what we do first is we send a reply letter to the defendant explaining a little bit more about what the whole thing is about. And they send an information sheet back that enables us to familiarize ourselves with their cases a little bit better. So then we determine, the first thing we determine, and first of all, this project, we talk about a triage team. We're going to ultimately enlist, hopefully, hundreds of lawyers statewide. We need lawyers in every part of the state. We've got the law students because they're doing some preliminary work. They're going to be good gophers. They can go get documents. They can get Court of Appeals trial records. They can do factual summaries as well as anybody, but they're not going to be doing the ultimate review. That's going to be done by attorneys. We hope to also get civil firms involved, like Latham and Watkins, who helped on the Hare review. So the first thing we try to do is to determine whether the case was a trial or a guilty plea, because that's going to determine what we do next. Let me see. What we're doing, and I'm glad there's some lab people here, because it's important for me to let the lab people know that we are not just going to say in every case, you get to work and start recalculating. We don't do that. We all know there are too many lawyers, not enough lab people, so I can enlist a lot of help among the legal community. So what we're doing where possible is we're trying to determine whether the DNA, even if recalculated and even if it was a dramatically different result that even excluded the defendant, if that DNA is material to the conviction, if it could possibly have played a role in that conviction. If the answer is no, we end our review. And so that is something that's a little bit easier to do in a jury trial, because we can get the trial records, the appellate opinion, we can talk to the litigants, we can talk to the defense attorney. We can make a pretty good assessment of whether that DNA evidence was at all pivotal to the conviction. And if we feel like it wasn't, and we err on the side of caution, but if we feel like there's no possible way it was, we end our review of that case. We never even contact the lab, okay? On a guilty plea, it's a little tougher. So what we've been doing through the help of Brady Mills, we've been sending the list of guilty plea cases to the DPS, and he will determine whether a CPI was issued in the case. We get a report that says one of two things from the DPS. It will either say recalculation may be advisable, or it may say that no CPI was issued in this case, therefore, there's nothing else we can do. So we will close those cases out. If there was a CPI issued, then we do an investigation to determine the role of the DNA results in the entry of a guilty plea. Now, this is inherently difficult because it comes down to what role did the DNA play in inducing that defendant to plead guilty. So the way we're going to do that, I went up to Williamson County yesterday, and they've got a really good protocol involved where they're going to send us all of their offense reports, other information that they think we might benefit from looking at and trying to assess the case to see if the guilty plea might have been induced by the DNA. We're also going to talk to the defendant, to the defendant's attorney. We're going to make an assessment of whether that DNA result was material to that guilty plea, whether it induced the guilty plea, what role it played. And again, we're going to err on the side of caution. We're not kicking anyone off the list unless it's pretty obvious. So we do that investigation, and if the role of the DNA was not pivotal, the review ends. We send the guy a letter saying our review is ended. If the DNA could have been material, either the entry of a plea or the result of a trial, we request recalculation from the lab, only then. So we obtain the recalculation of the DNA from the lab. So what if the new results are statistically insignificant? What if it goes from 8 billion to 7 billion? Okay, that case is over. We send, the findings to the defendant. We say that we don't believe this is statistically significant. We end our review. So what we're left with as to either trials or pleas, the cases that move forward, and I say that guardedly, because we don't have any binding effect on anybody. We don't determine whether a case really can move forward or not. But if we get a case where the new results are potentially significant, and they may be material to the conviction, then we send a letter that is copied to the judge and to the prosecutor, advising the defendant to request an attorney under Chapter 64, which is the motion for post-conviction DNA testing. And I know in Williamson County, what they're going to do is they're going to go, persuade the judge and encourage him to appoint a lawyer at that point, if they get a letter from our review team suggesting that. Now, when we send letters, these closeout letters to defendants, we tell them you're free to pursue any legal option you want. We don't want them to have the impression that because we said something that they're foreclosed from taking further action. It's just that our review will have ended at that point. If we get results from DPS that say no CPI was issued in a case, we will provide that to the prosecutor. So this is our review. We're still in the process of fine-tuning our, that's Lynn's, fine-tuning our protocol. We're working with prosecutors. We're going to, hopefully this will be a collaborative effort until it can't be, and we're going to be discussing in Plano next week the legal remedies that lawyers can follow. We're going to act as a resource to lawyers. That's one of our main two functions here. The other function is, honestly, a paring down of the list. The previous projects I've been through, I've learned this much. You want to try to get to the people whom you can really help. We want to try to get to innocent people or people who can get a remedy. And you can't bring the full force of a thorough habeas investigation or treatment to every case. You've got to develop streamlined review questions and ways of approaching these cases. You err on the side of caution before you knock anyone off the list, but you got to get through this quickly. There's going to be a ton of cases.
I have a question. What is, when what kind of variance, do you have a formula for what you're going to call significant change? I mean, obviously, going from billions to 1 to 10.
Right.
But do you have you come up with?
I don't have a formula, Richard, but, you know, again, I'm going to err on the side of caution. If it's 8 billion to 6 billion, I'm eyeballing it and saying that's not a big difference. If it's 8 billion down to 1,000, you know, I can see a judge saying, well, it's still 1 in 1,000, but I'm going to leave that one in. We'll know it when we see it, and a formula may develop. Maybe Dawn would have a good idea about that. But I don't know when a statistic becomes significant, but we'll figure it out.
Okay. Sorry, Bob, I have just a quick question. If you have a report that has CPI on certain items, but you have random match probability on other items, are you still going to ask for a recalculation on the CPI?
Probably not, but we'll just look at the case and.
I think the answer is if the random match, there has to be an assessment of like what, if you got a strong random match probability or modified random match probability on some probative piece of evidence, then I don't see the point of redoing the CPI on a secondary piece of evidence. So at that point, he's going to have to really work with the prosecutor to figure out the best course. And the prosecutor is ultimately probably going to make the request of you, like, yeah, we think we need to do it here or not. And like Brady made the point that, you know, you may have a list of 40 exhibits or something, maybe not 40, but let's say a dozen exhibits. And you could have 11 of them that have super strong modified random match probability stats on there and one CPI. Well, at some point you have to make an assessment of resource issues and whether it's worth it. And I think we're trying to be thorough and reasonable at the same time. So we may be counting on the labs to help us interpret those reports. And Dawn, do you have thoughts on that?
I was just going to say, one of the things that we had was a form that our labs basically helped come up with, and so we could use standardized codes for whether it's RMP or CPI or whatever, or that they probably weren't thrilled with the form initially, but they approved it. How about that? So anyway, because it's still a lawyer form. But what they're going to do is there's a chart where they will identify each piece of evidence. And last time at the meeting at the ME's office, we discussed the possibility of maybe affidavits being able to be issued regarding only those pieces of evidence, maybe instead of full reports. And I don't know what the progress is on that, but I just wanted to mention that. The other thing is, because our form is not actually asking for an amendment, we're just asking to identify which of the items that involves CPI. That form then goes to the defense attorney, who can make some sort of materiality call as to whether or not they think they need an amendment, or if the prosecution thinks they need an amendment. But that way you're not asking for that on everything all the time.
And I think that is a really good form that we may incorporate into the rest of the statewide review. Now, DPS issues an actual report, and unfortunately my name is on the report, but it goes to me, but it actually goes to Bob. And the report says, is their initial assessment, it says, there was no CPI issue in this case, or this case, we've evaluated it may benefit from recalculation, or this guy was, there was an exclusion to begin with, or this is a DUI, or, I don't know, whatever, any number of things that, and that is an actual report, like it looks like a DPS report, and that is also very helpful because it's very official looking in it, and it allows Bob, when he's communicating with the prosecutor, to say, okay, here's what DPS has said so far. And it's just a form that they came up with and they use. So we haven't gotten to Bexar County yet, but when we do, we can talk about whatever makes sense for you guys. To the extent you're even gonna, you don't even have very many cases, but.
Well, and a lot won't have a recalculation. It may be something that went to inconclusive where a stat was issued before. And so it's not necessarily that it's just a recalc, although on the RMPs, we're doing recalculations with the POP stats. even though that's not the mixture interpretation issue. But then, certainly anything relating to the actual mixture interpretation issue is really kind of more what we're looking at. If they happen to ancillarily have the issue with the pop stats, since everybody had recommended that to begin with, we are agreeing to that, but we're looking more at, our notices are only going out on the mixtures. And the only reason I actually was, besides answering that, was because last time we were here, the commission asked about numbers, and we are actually in the place now where we pretty much know all our numbers. And so if you're interested in what we think might be, coming down the road, I hope it looks the same for Bob here. But essentially, we had probably just under, we did it a little different. Bob, you may want to stay here in case you have. We did a little different because we asked for lists of all DNA cases, and then the prosecution went through and identified which ones resulted in convictions. And then from the conviction ones, we went and asked back to the lab, can you identify which ones are CPI? Because those are the only ones that we were really concerned about with the convictions that were CPI, rather than all, somebody mentioned earlier the number of times that you do work for law enforcement, that never makes it to the DA's office. Obviously, those are not the ones that we're interested in. So we had 10,000 DNA cases, a little under. Of those cases, not that many got filed actually, but without going into all the specifics for each one, because most of the times those are, maybe we don't know what the investigative lead was for the police agency. But of those, I think that we probably expect that we will have less than 150 cases that actually involved CPI. So the ones we're actually sending notice out on are only 150, which is obviously significantly less than the DNA cases, and even than the, 2,000, maybe a little, 1,000, 2,000 CPI, or conviction cases that were filed at the office and resulted in convictions.
Our numbers were similar. We had over 10,000 DNA cases. However, we only had 398 CPI cases, of which I'm not sure how many actually went to trial. That was just provided to the district attorney's office. So it's in their ballpark now. I was just curious as to what Dalton was.
So, it's not germane to the discussion, but that's good, because it will take an analyst at least one full day to recalculate one case.
And just because
with review.
And just because it's a CPI notice doesn't mean that we're asking for a recalculation at that point. We're waiting for the defendant or the defense attorney to actually ask for that amendment after looking at the form to see if that particular piece of evidence is important to that case.
Right. I wanted to put it in perspective for those people who may think you go to a computer and push a button and it just spits out a new number.
Right, because you have to go to the electropherograms and look at the actual.
You have to pull everything back out and sit back down and reinterpret all the data, and depending on the number of exhibits that were done. But on average, with technical review, because we issue our recalculations as an actual amended report or supplemental report. So we don't do it some other affidavit.
And we haven't done that yet. It was just discussed at the mixture deconvolution seminar that maybe that might be okay. It might be in line with QAS standards where there wouldn't necessarily be a problem if it was one specific piece of evidence. I don't know what the resolution was. I just mentioned it because it was brought up as a possible solution to not having to go through and issue an amended report that involves every single piece of evidence on there. And I don't know what the ultimate resolution of that is. But if this holds true, it's actually good news, right? For you. No, I mean, if it holds true, if Bear County had similar numbers, we have similar numbers, maybe you'll be in that situation, maybe you'll be in that situation too.
Hope so.
And that's CPI related, the mixture is not single source donors, because
we did not do, anything that was separated out as a RMP, or, if it's maybe some of the hair or something. This just is completely related to CPI.
This also, your process does not preclude Bear County, I'm telling you as a fact, doesn't preclude Bear County answering to a request for recalculation by an attorney who simply wants to have it done. we will still do that. So
Correct.
it's not like, when y'all are done, that's not our intention. I can't speak for anybody else, but our intention is if somebody wants it done, we will still do it.
This is just us asking for it to make it easier and try and streamline the process. But certainly, we can't control what everybody else does, and nor do we want to.
I will say one thing that's been helpful is that aren't you guys going to create something in your system for cases to check the forensic disciplines associated with the case? So in the future, they can actually be searched in the system, like all talks cases or all.
And actually, we had initially thought of it as what we call tags, but what we have done now is we have labeled the digital media, like the reports, when the reports are uploaded, we've actually labeled those reports with a specific name, and we can generate reports to search for those, for all reports with that name. So if it says, and we have a forensic discipline list, and it's obviously, which particular types of testing go underneath that forensic discipline list, somebody inputs that, and the prosecutors also do that at, I know I saw that face, because yes, we're concerned about that. But somebody inputs it based on the list, and then our prosecutors as well when they use it at trial. And then we can search for all DNA reports or all ballistics reports going forward.
No, actually, what I was laughing about was that there was a previous endeavor in the state for to create a CJIS system that all the counties, and it would create a unified system that all all counties would have similar type systems, but kind of fell apart. About 5-6 years ago.
Maybe a
So
shame.
not all counties, so every county is pretty much reinventing the wheel with regards to whatever, however they're dealing with their data.
But yes, we're trying to prevent this in the future.
Okay.
Thank you.
So just things to keep in mind, long-term effort, there's a lot of cases. There are a bunch of technical issues trying to recalculate when the labs have switched kits, for example. And just, I think as you heard from Bob and Don, we don't have infinite resources, so we need to be smart about what we do have. It's not going to be perfect, but we're all working really hard and working together. And so we don't know how many cases will be affected, but we're going to just keep working until we figure it out. And our labs have been just great.
Okay. Number 15, that's report of the National Commission on Forensic Science. And, okay, you have to understand that this commission, which is essentially working for the DOJ, puts out two types of documents: directive recommendations and view documents. Directive recommendations is, it'll start out something like, say, the Department of Justice mandates that all, et cetera, et cetera, et cetera. Reviews is something like, the National Commission thinks that all labs should do something, okay? Now, the word, semi-official, is that they want to start to go to view documents, not directive recommendations. Over the last couple of years, we've had a bunch of, documents going out, and they apparently started reviewing them 6 months ago or something like that. So they're way behind. So that's why I think they want view documents. The directive documents are really nice, but the Department of Justice has virtually no control over anybody. It doesn't control a significant number of crime labs, no medical examiner system, and usually their directives are, you will, in all federal homicide cases, you will use an accredited medical examiner's office and crime lab if they are available. So if it's 100 miles away and they don't want to, they go with the other. Okay, that's what's going. The feeling that they had mentioned a number of times that they only had funding for another 13 months. That was about 10 months ago. And from the feeling I get, what it means is they hit the iceberg and the water is starting to come in. Don't forget, if there's a new administration, who knows? And so, next time I thought I'd bring you, I'll show you what has been, quote, officially passed and approved by the Department of Justice. But it's kind of, a lot of people were shocked when they fully realized that they really didn't have much power. And mostly these are suggestions. And in regards to Texas, any suggestions they made, we've already accomplished. They're behind us, okay? The one document that I thought was kind of interesting is that they're trying to ban the phrase reasonable degree of scientific certainty. And, reasonable degree of medical certainty. Like generally, this won't affect medical examiners because we don't use this phrase in autopsies. It's going to affect, I guess, some crime labs, but they really don't like this phrase. But it's a view document, which means you really shouldn't do this, please. So.
That was, on that subject, Jules Epstein, who's actually coming to Plano next week for training at K-Law, he gave a really interesting history of the use of that term, and it turns out it's something that lawyers kind of force the scientists to say, not the other way around. And so I just found that entire history really fascinating.
If someone dated it back to the 1930s, some judge suggested, well, why don't you use this phrase? And then everyone adopted it, and then it's being put on, because I know when I have private cases that want me to put it down, and in civil cases, I never put it in criminal cases. And I say, okay, I don't care, doesn't mean anything. And the attorneys also have kind of admitted it doesn't mean much. The next thing is.
So we had the OSAC meetings in Leesburg, and they approved their first standard in the area of seized drugs, and all it really says is that if you're going to test seized drugs, you need to pick certain types of tests out of certain categories. What we saw in that example was that a lot of the disciplines are bringing standards, existing standards over from an organization called ASTM. And there's some issues with that because even the subcommittees would like to improve upon some of that language. That's not ideal, but they can't because they don't let them revise it except for certain points. And so what we're finding is toxicology is bringing standards up that they kind of created from scratch, and they're much, from the perspective of the lawyers, they're much better and much more thorough than the ones that are being brought over from ASTM. And so it's going to be really interesting to see how the OSAC as an organization deals with that. And also the fact that those ASTM standards that I referred to, you have to pay for them. So for the legal system, that's not particularly helpful if you're representing indigent clients, for example. To have to pay for those standards kind of seems to go against the whole concept of the organization. So it'll be interesting to see how the OSAC develops. It's still very much in the early stages, but they're trying to get some standards through. And I will keep reporting back as that happens.
16, 17? You got 16.
I told you that we have various trainings and upcoming conferences. I'm trying to limit my travel, but it's getting harder to do, especially people really want to hear about the DNA mixture issues, and as long as they're willing to pay for it, I suppose that to the extent the schedule allows, I'll try to do that. But I told you which ones we were invited to. Bodie East and West were invited to the next Ishi conference, and so we'll just do what we can.
Lee?
Next meeting date?
Yeah.
It's looking like we're gonna meet the week of April 11th, either the 11th and 12th, or the 12th and 13th. So if you can't do that day, please let me know. But we'll have it again here at the Omni, but it's on either a Monday, Tuesday block or a Tuesday, Wednesday.
Okay.
They didn't have a Thursday, Friday until June, I think, mid-June.
That's probably too far away.
And we're supposed to meet in April, so if we stay on the quarterly schedule.
You got the case on last.
I can't do this.
Okay.
Lee, can you send us an email to remind us to look at our calendars? Okay, thanks.
Yeah, what's that, something monkey thing?
So if we do Tuesday for the full meeting, you could do that.
Will you send us some program where you ask us to input dates and see who can make it?
And Survey Monkey?
Yeah, Survey Monkey.
Yeah, I can send you, I can do that if this doesn't look like it's gonna work for the majority.
Okay.
Yeah, I think that's the best thing.
Because this would be the best, most cost-efficient date to meet.
Dr. Hughes Stamp can't do Mondays or Wednesdays.
I got her
You got
as
her.
no.
But she's a yes for Tuesday,
Yeah, I
right?
can do Tuesday.
So if we did Monday, Tuesday,
So if we
we
had
could
the
do our,
full
we could do
meeting
our
on
screening.
Tuesday.
Give the full
maybe.
meeting on Tuesday.
Yeah.
And the full deal on Tuesday.
So that would mean the people that were meeting the day before would have to get here either Sunday night or Monday morning.
Which is much easier
Okay.
for me.
Well, obviously, some of these agenda items are going to go over next time. And I think you said we've got already 2-3 cases. Oh, did we
2 or 3 cases for,
submitted for,
oh, we've got so many cases.
Complaints?
So many
We've already got 5 or 6
We've already
complaints
got-
submitted.
5 or 6 already?
And
By the
two-
time we get the mail for Monday, it'll probably be another 4 or
Okay,
5.
3 or 4 was last
They're
week.
just,
Yeah.
it's hard to keep up at this point, but we're hoping most of them will go to,
A lot will go to Bob. They just left, but.
they left, but a lot will go to Bob.
Good.
So is that our default position? Anything that's potentially just go them for screening through them, regardless of
Any
Unless
public,
there's other
issues? That's, yeah.
any public comments?
Get behind you.
Yes?
Yes, Honorable Commission, my name's Mark Shoemaker. I'm here as a member of the public and also at the request of Jason Spence to read a prepared statement. I'm passing out 2 things. One, the prepared statement, and second, some information that I believe is relevant to the Spence case. I'm here to try to, in addition to discussing some of the thoughts and emotions of Jason Spence, to try to persuade you to reconsider the Spence matter. It seems to me this is a unique historical opportunity for a body that has been given investigative powers by the legislature to look at a matter that is crying out for reinvestigation, for crying out. It's like the big elephant in the living room. We know that Mark Cheney, as of last fall, was released due to the disputed bite mark evidence. That's relevant to the Spence matter also. However, we have an issue of DNA. And it seems to me very simple that regardless of I've heard a lot of statements about jurisdiction. There's an issue of justice. Plato, in Plato's Republic, teaches us that truth is a function of justice, one of the components. You as the investigative body, even if you don't believe and you are advised that you don't have powers to compel, you have powers to seek advice. You have powers to request, whether it's to the Attorney General, whether it's back to the legislature. You have this ability. This man, David Wayne Spence, was executed April 3, 1997. It seems to me that the opportunity to lay it to rest, so to speak, once and for all, to look at the DNA. I hear a lot of talk about this scientific method, and I applaud you for how you've approached the bite mark in a very methodical way. The execution of a man, I understand you may be uncomfortable, was revisiting an execution that took place 9 years ago. I understand that. I'm sorry, 19 years ago. I understand that. But again, this is a justice component. If this body believes its function has anything to do with justice, has anything to do with the investigative part of truth and seeking that justice, it seems to me this body would go back, relook at this matter and say, one, why isn't the DNA being tested? And two, how do we get it tested? My understanding is Dr. Eisenberg,
This case is already on the list, we're considering it.
I understand, but no vote's been taken. But listening to it, it sounded, I want to make sure that there are items that are additional to your consideration. For example, there's a court order out of McLennan County related to the DNA testing. This is a 2013 court order that ordered in a related case, Tony Melendez, that the DNA go from Tarrant County to a lab in Arkansas, and it be tested. Very simple. And then come back to Tarrant County. That never happened. What happened was, it somehow went from Arkansas to a lab, NMS Labs, in Pennsylvania. Then went back to UNT Labs, where Dr. Eisenberg is, went back to NMS until January 27th of this year. This body could contact Dr. Westring, who's the director of NMS Labs, and he would confirm all of this that's stated in the timeline. So it seems to me that I would encourage this body to look very closely that it does have the jurisdiction to act in its investigatory capacity, to push this issue, push it to a conclusion. After all these years, it seems the right thing to do is to conclude it. Because the worst thing, here's a worst case scenario. Here's the scary scenario. If the DNA comes back and shows that David Wayne Spence was wrongfully executed, and it shows that he wasn't a participant in the crime, there is this chance, because in discussing probabilities, that the people who committed the crime are still out there, still out in the public. So it seems to me there's an overriding public duty here. Okay. I've been requested by Jason Spence to read a prepared statement. It's short and sweet. Just for the record, I was introduced to Jason Spence through Bernadette Fazell, who's tirelessly worked on this matter regarding Mr. Spence. And I met Bernadette Fazell through working in the offices of Scott Ogle. It's not relevant why I left Mr. Ogle's office. I'm not a licensed attorney. I have no monetary interest in this, for the record. Prepared statement from Jason Spence. I went to see justice for my dad and my grandmother. I cannot imagine what it was like for my father, sitting in jail, just waiting for the day he was to be executed. When I was young, we would always go see him, but never allowed to give him a hug. The only time I ever got to touch him and hug him was when I was around 5 years old and he was in a cage. We always stayed with my grandmother, Juanita White, until she was murdered. I remember watching the reenactment of her murder on TV. When I was 19 years old, I remember clearly watching my dad's death. He wanted me there and I wanted to be there for him. The only time I got to hug my dad after that was when he was in his coffin. I told him that I would not quit until I cleared his name. Other people made the same promise, but they gave up. I want to know why things are going so wrong with the DNA. People have the info, the results, and are keeping them from me. I'm tired of all the games that people are playing regarding the case. I need the answers now. No more delays, no more hiding things in secret. So, you've had a long meeting. I commend you on listening to this. I respectfully ask you to seek justice in this matter as you are doing in other matters. Thank you.
And again, I want to reassure you that we are working on this case. And we will do what we can do. Okay, any other comments? think we can recess it and then we'll meet again.
Second? Somebody
Second, I'll second.
Made, okay, so.
I made the motion.
Okay. Second. Aye.
Aye.
Nay.